You talking to me?
Maybe.
You say?
Why is the clock supposed to somebody?
That's what I'm playing.
I don't hear any sound.
You don't hear any sound.
Oh no, it's
Just lagged. I can now hear myself back. So that'll echo back. See, this is how long it is since I've actually done this, that I have absolutely no clue what I'm doing. Hello? So I've not actually been live in. Well, no, I don't know. And this is my Twitch layout, not my YouTube layout. I don't know where. I couldn't find my YouTube layout. I need to sort it out again.
Good afternoon. Given the point that we reached in proceedings yesterday and that we have a number of groups to debate before we reach the next line, under Rule 9.8.5a, I'm minded to accept a motion without notice to propose that the next time limit be extended by up to 2 hours. And I invite the Minister for Parliamentary Business to move the motion.
Thank you, Presiding Officer. I moved.
Thank you, Minister. The question is that the time limit for debate on amendments be extended by up to 2 hours. Are we all agreed?
2 hours.
We are agreed. The first item of business is the continuation of Stage 3 proceedings on the Gender Recognition Reform Scotland Bill. In dealing with the amendments, members should have the bill is amended at Stage 2, that is Scottish Parliament Bill 13A, the marshalled list, the groupings of amendments. The division bell will sound and proceedings will be suspended for 5 minutes for the first division of the afternoon. The period of voting for the first division will be 45 seconds, and thereafter I'll allow a period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press their request to speak buttons or enter RTS in the chat as soon as possible after I call the group. I would ask members to now refer to the marshalled list of amendments. We move to Group 10. Point of order, Douglas Ross.
I'm grateful, Presiding Officer, for accepting the point of order. I wondered if I could seek your guidance on the official report of this Parliament. The official report is a written record of what is said in public meetings of the Scottish Parliament and its committees. Not my words, but the words of the official report website hosted by the Scottish Parliament. Last night, the Deputy Presiding Officer suspended the sitting to, and I quote the official record, "We will have to clear the galleries now. We will suspend the meeting for a few minutes while that happens." The official record states that at 18:24, meeting suspended. At 1900, on resuming, the Deputy Presiding Officer invited members to resume their seats. In the intervening period, the Deputy Presiding Officer had begun proceedings again. I then made a point of order. That is totally removed from the official record. Not a single note of it. At that point, I was urging the Deputy Presiding Officer to make it clear that if people have been unruly, they should be removed, but people who had sat through silently and listened to the debate should not be removed. That point was, I think, accepted by the Deputy Presiding Officer. We then had further discussions because I pointed out, on the record I thought, that people had been threatened with arrest if they did not leave the public gallery. Again, there is no mention of that whatsoever in the official report, which, I go back, is supposed to be a record of what was said in public meetings of the Scottish Parliament. Later on, my colleague, Jeremy Balfour, said in a point of order, I seek some clarification about the question that my colleague, Douglas Ross, asked just before the suspension in connection with who can use the gallery. But anyone trying to read what I said in response to what Mr Balfour said will find no record of it in the official report. So how can we possibly have a situation where there is an incomplete official report for an important session of this Parliament?
I thank Mr Ross for his point of order. My own understanding was that proceedings were suspended, but I will look into the matter that Mr Ross raises and I will be back in touch with Mr Ross. Now, we move to Group 10, Certificates Obtained by Fraud. I call Amendment 108 in the name of Jamie Green, grouped with Amendments 110, 114, 115, 116, 138 and 139. Jamie Green to move Amendment 108 and speak to all amendments in the group.
Thank you, Presiding Officer. Can I first of all place on record my thanks to colleagues and, of course, more importantly, the staff of the Parliament who aided and vetted us so diligently last night into our late sitting, and it is without them we would not be able to do the jobs we do, and I wanted to place that on record. And I'll try not to speak to keep them here till midnight, so that's the good news. I'd also like to welcome people back to the public gallery. We are an open Parliament, and it is important that we are a Parliament of the people, for the people as well. So, this group of amendments, Group 10, which we didn't get through to last night, are largely centred around the concept of certificates that are obtained by fraud. Now, those of you who were here in the debate yesterday will know I made comments around what I felt was a much-needed compromise in this piece of legislation, compromise that was notably absent at stage 1, given that many concerns yesterday over the many hours were raised about use of this new simplified process for nefarious purposes. A number of amendments were proposed by various members to that effect and were voted on accordingly. My running theme throughout this presiding officer has been 2 points in my desire to amend this bill. Is not to do so to be difficult, not to take advantage of it for other purposes, but simply to make the bill better, and that's a desire I think we all should share. Now, I've come to a view through that desire based on 2 themes, and that's one of compromise and one of competence. And I think those 2 words are recurring themes that I hope we will all bear in mind as we go through today's amendments. The issue of compromise is an important one, because without compromise, I don't feel that both sides of the argument will feel fully satisfied that they've been heard and listened to, and that is competence is equally important, because this is a stage 3 debate, and what we put on the face of the bill will live on the face of the bill in black and white for generations to come. So through that process, I have come to a view that the amendments, as they are currently drafted, are indeed that of compromise and competence. They are compromise because they, in my view, ensure that this new process, whatever your views on the simplicity of it, is not taken advantage of or abused. And my amendments seek to do that through a number of ways. There are 6 amendments in this group, 4 substantive and 2 consequential. The first one, Amendment 108, addresses an issue that was raised when introduced this concept at stage 2, a stage I was happy to participate in constructively. A member in that debate, Pauline McNeill, raised a very valid issue around the definition of what a fraudulently obtained certificate might be and look like. I think actually it was quite a challenge set to me. It has been very challenging to get a well-rounded definition of what a fraudulently obtained certificate is, without being so defined and limited that it actually could prevent prosecution in valid cases. My understanding is that this revised amendment, 108, is much legally clearer. 108 states that a GRC is fraudulent if the applicant knowingly makes a statutory declaration or includes information in their application that is false in a material particular. So what does that mean in practice? That is to say that an application would be fraudulent if there was relevant evidence that the court saw that was sufficient to prove that the application was fraudulent. Of course, that would be a matter of the independent judiciary in the scenario of either a jury or a judge or a sheriff. But it could include, by way of example, a broad range of evidence to support that there was suspicion that an application was fraudulently made. That could include a number of factors, such as the physical appearance of the offender in question, evidence from those who know the offender, names used, pronouns and prefixes used by the offender before, during and after living in the required gender period, and anything else that the court may deem appropriate. Happy to take an intervention.
Graham Simpson.
Thank Jamie Green for taking the intervention. The issue I have with this section, and I raised it at stage 2, is it seems to me to be virtually impossible to prove fraud if, in order to get one of these certificates, you don't have to actually present any evidence. So if there's no evidence needed to get a certificate, how can there be a fraud committed in order to get one? What would be the fraud? If the only thing that you have to say is, I'm a man or I'm a woman, and present no other evidence, what fraud can there be?
Jamie Green.
Well, I'm aware of a number of other amendments that were discussed around the production of documentation. I think there is a valid point in that the 2004 Act does not go into great detail in specifying what evidence is required to obtain a GRC. That's been the case, however, for nearly 2 decades. And nothing in this bill actually changes that. What is missing from the 2004 Act, which I hope is a point of agreement perhaps that the member will have, as others will have, is that I don't feel that it fully addressed the issue that there is the possibility, I believe it to be a low possibility, others believe it to be a greater one, that someone could use this process, whether it's the existing process or the new simplified process of statute declaration and self-identification, as it's otherwise known as, could be used for nefarious reasons. Now, the 2004 Act, I think, was weak in that respect. What I'm trying to do with this set of amendments, and I'll go on to explain some of the others and how it goes about that, is introduce the concept that making a false declaration is a very serious offence. Making a false statutory declaration already is an offence, but by doing so, and by using this new process to then commit further offences, that the judiciary will take that extremely seriously, and that will be manifested in another amendment that I have in this group around aggravating offences. Of course, we cannot consider every scenario in every court case in which this may pass. I expect the numbers to be relatively low, but if they do come to pass in a court of law, it will be a matter, a decision-making matter on whether they believe, the court believes that a false declaration was made. It should be clear to folk out there that making a statutory declaration is a very grave matter indeed, and a very serious thing to do. And I think it is for that reason that we should put faith in the process of statutory declarations, one that has existed for generations. Yeah, in a second, I do want to make some...
Why is he shut up?
Following on from that, Amendment 114 in this group creates an aggravation of an offence when a crime has been committed using a fraudulently obtained certificate. So, to be clear what I mean by the aggravator, it's a concept, again, I introduced at Stage 2. It was rightly challenged in terms of its wording. That's the whole point of Stage 2 amendments. I've revisited it, and I'm confident that, as drafted at the moment, Amendment 114 tidies up this concept. What it means is that by having a GRC and committing an offence in which that offence can be linked to the acquisition of a GRC, then that offence will be considered to have an aggravating factor. What that results in is a harsher sentence, a harsher punishment for those who use the GRC process to commit an offence. Now, it is important that that link has to be made. Another example being, if you hold a GRC and commit a criminal offence, a hit and run, theft, for example, by holding a GRC and committing an offence, the two are clearly unrelated. If the court is confident or has suspicion that the acquisition of a GRC, and by holding a GRC that enabled someone to commit a specific offence, then the aggravating factor could kick in. That's a commonly used mechanism in sentencing. It's used in domestic abuse legislation. It's a concept I introduced during fireworks legislation, and it's a well-tested and well-known concept in courts. It's also been welcomed and received by many stakeholders. If an individual was found to have fraudulently applied for a certificate and or convicted with an aggravated offence, then their certificate would rightly be revoked. Amendment 115 makes for the automatic revocation of a certificate in that scenario. It actually also fixes a loophole where an applicant could have received an interim certificate based on a fraudulent application and was then converting that interim certificate into a full GRC. Just one second. This amendment closes that loophole and brings fraudulent applications for interim GRCs in line with the rest of the bill. Happy to give way to my colleague.
Stephen Kerr.
So is my colleague, by the way, I pay tribute to the contribution that Jamie Green is making to this whole process, and the way he's very carefully presenting his views is a credit to him and to the standard of debate that he brings to this chamber. But in relation to the fraud, is the fraud thereby defined as someone obtaining the certificate?
Mr. Kerr, sorry, I'd be grateful if you could speak to your microphone.
Yeah, it's very difficult to speak to
you. Thank you.
Right. Is the fraud when someone seeks to obtain the certificate in order to commit a crime? Is that the definition of the fraud he is presenting in his previous... He didn't want to give specifics, but is that the nature of the fraud he's describing?
Jamie Green.
It's a helpful question, and actually the answer therein lies in the wording of the amendment itself, in Amendment 108. An application for a gender recognition certificate is fraudulent if the applicant knowingly, A, makes a statutory declaration which is false in a material particular in connection with the application, or B, includes information which is false in a material particular in the application, or a notice of confirmation given under Section 8B3 in connection with the application. That's a technical answer. Essentially, if someone makes a false statutory declaration, which is entirely a distinct possibility, then the gender recognition certificate will have been achieved through fraudulent means. That's the first scenario. That in itself is an offence, making a false declaration. If, by then receiving a GRC through the normal process, that person then goes on to commit a further offence, for example, a sexual offence of sexual violence, violence against another individual, and the court believes that the acquisition of the GRC was a material factor in that offence or a facilitating factor to enable that individual to commit an offence, then that would be an aggravated offence. So it is very likely that it would only be relevant in the scenario where a holder of a GRC commits an offence and the court deems that that offence has been committed and facilitated through the acquisition of a GRC that was acquired through fraudulent means. As I said, there are a number of cases, for example, where I believe my amendment, had it already existed in legislation, would have been helpful. But by way of example, the presiding officer permits me, there were a number of cases a few years ago where a number of individuals were convicted of sexual assault, for example. Those individuals held GRCs. At the time, and members are welcome to look them up, the Crown versus Barker, McNally, Wilson, Newland, there are a number of cases in this scenario. Just 1 second. These were trans men who had female partners. It was discovered, the female partner only discovered the identity, the transgender identity of the offender in most of these scenarios at the point of intercourse. Those people were then charged and prosecuted duly with sexual offences. There is no aggravating factor in that. They were simply charged as individuals with sexual offences. In this scenario, under these proposals, the courts would look more severely on that because there would be a direct link between that person having obtained the GRC and then committing a sexual offence as the nature of it was in that scenario. In my scenario, those people would have received a harsher punishment for that offence because of that link between obtaining a GRC and committing an offence of that type. And that's why I believe that these are important and helpful additions to the legislation that doesn't currently exist in the system. I have to give way to that member.
Ruth McGuire.
Just waiting for a microphone. Thank you. I thank Jamie Green for taking an intervention. I wonder if I could take him back a little to... I listened carefully when he was answering Graham Simpson, and he seemed to say that there was no difference between the previous Act and this Act in terms of evidence, but there is a rather major difference in that people would have had a diagnosis of gender dysphoria, and I appreciate that we do not wish to have that moving forward, but does that not mean that the evidence that's remaining is a bit arbitrary and subjective? I mean, how do you prove a fraudulent inquiry if it's about how people feel?
Jamie Green.
No, I respect the member's position on this. I mean, to be clear, there are people who believe that the process of a gender dysphoria diagnosis is an important part of that process and an important safeguard in that process, because clearly evidence must have been submitted to the panel in obtaining a GRC. Of course, the change in this legislation is that that is removed. I understand that. But that doesn't take away from the fact that making a statutory declaration is still an offence. Now, whether or not evidence is submitted or not, we have had quite a wide-ranging discussion. It's not actually part of these amendments around how one proves that one is living in an acquired gender. That's been a matter of debate since the 2004 Act. So, you know, as I said, the scenarios, I mean, these are, of course, hypothetical scenarios. But what this amendment does do, and I think it is quite important, is give the court that flexibility that if there is a view taken that a statutory declaration was made falsely and that the acquisition of a GRC enabled and abetted that individual to commit a further offence, then A, the GRC can be revoked, and B, any sentence given will be harsher than in any normal scenario of a similar type of offence made by any other individual. I'm not sure if that answers the member's questions, but I'm doing my best here. Essentially what this group of amendments does, and I'll close on this, is to reintroduce the things that people believe have been taken away through the simplification of the process. And it's to act as a deterrent. And it's simply to give a strong message to people that says, you cannot use this new process. You cannot abuse this new process for nefarious purposes. If you do, then the law will look harshly upon you. You must know that making a statutory declaration is a solemn and a grave act and move. Making and doing so falsely will be looked upon by the law, and it is not possible, will not be possible, to use this process to then go on to commit further crimes and get away with it. And that's the important point here. What I'm trying to do is reintroduce any perception of a loss in safeguards by introducing things that don't even exist in the current process, that will have absolutely no effect on trans people whatsoever, who go about their business, who apply for a GRC under due process. These amendments, importantly though, going back to my second point, which I made at the beginning of my comments, is that they are competent. And that is so important in the type of chamber that we have, where we are unable to revisit legislation after stage 3. They've been legally reviewed, I believe are helpful. I believe they've been welcomed, even by those in favour of the legislation. And in my view, they're important, because that concept of deterrence is an important one. Thank you.
Thank you. I call Rachel Hamilton to speak to Amendment 116 and other amendments in the group.
Thank you, Presiding Officer. And can I stand with the comments made by my colleague Jamie Green? I would like to put on record my thanks as well to parliamentary staff yesterday. Can I also stand with him on his comments that it is important that we do compromise and that we find shared ground, which I think we did yesterday by supporting a number of the government amendments and others from these benches. Moving on to my amendment 116, which seeks to make it a criminal offence to gain access to a single-sex service as a result of having fraudulently obtained a gender recognition certificate to access a single-sex space. The amendment seeks to address a key concern of thousands of women and girls who've contacted me, my colleagues and many others in this chamber about the potential unintended consequences of the bill. The provisions of the bill open the ability to obtain a GRC to a much wider and diverse group of people. And the danger that this amendment aims to mitigate relates to the potential for bad faith actors to take advantage of the bill by fraudulently obtaining a GRC. And the right to access single spaces such as changing rooms, hospital wards, religious spaces can be conferred upon by holders of a GRC, unless, of course, the service
the problem is they're probably not going to taste very nice.
Is confident that they can legitimately exclude people of a protected characteristic. But my fear is that without this amendment, a bad faith actor, as I said, could fraudulently obtain a GRC to access these spaces. And therefore, I believe it's imperative that we criminalise such an act, both to deter people from doing so and to convict those who do so. Just on Monday evening, the committee, which I sit on, heard evidence from the Special Rapporteur on Violence Against Women and Girls, and in relation specifically to the harm that this bill could have on the rights and protections for women and girls. And during her time giving evidence and in her correspondence to the committee over the last few months, we've heard that women across the country may have to self-exclude from women-only spaces because of this bill. And we need to take these concerns very seriously. Her expert opinion should not be brushed aside. And I know that she has consulted widely on this matter and her opinion has been well informed. If this bill passes and these concerns are not addressed, I think it's right that the Cabinet Secretary takes the time to explain exactly why Mr Salam's comments have been, I suppose, brushed to the side by the government.
Why are all these people brushing aside?
Because they address specifically my amendment in this group. We must take our time to listen to those who have warned us in this chamber about the dangers of the bill to women's spaces, and I sincerely hope that members will reflect on this amendment. I'd also like to recognise the points made by, in interventions by Graham Simpson and Ruth Maguire. A lot of my amendment is based or hangs on some of the amendments that I aimed to achieve yesterday. So I just want to respond to the concerns that individuals have. And I'm not yet sure, until I hear from the Cabinet Secretary, Presiding Officer, whether I will press this amendment. Thank you.
Thank you. I call Pauline McNeill.
Thank you, Presiding Officer. First of all, I want to thank Jamie Green for, as always, bringing a thoughtful amendment round some of the actually technical issues around offences and the commission of offences, and I want to look at it from that point of view. So I'm very grateful that he has responded to a question I put to him at stage 2. So to prove a commission of any crime, you must show the mental element to the crime and the behavioural element of the crime. So it's impossible to see in someone's mind, so you have to look at the actings of the person to establish what they were thinking. So what is it about the commission of a fraudulent application, such as in this Amendment 108, that would require to be shown? Crucially, this bill is a self-identification model with no specific requirements as to what would constitute living in the gender. And as the Cabinet Secretary pointed out yesterday, the guidance on acquiring gender in the 2004 Act sets out what's required under that Act, which is to gather documentation. But importantly, it must be noted that at the end of that 2-year period, it is the panel that then signs off before the declaration. I think that's an important difference to understand. So when we come to this legislation, I think we need to be clear about what kind of evidence needs to be brought before a court before this offence would be brought before it. So, for example, as I also said at stage 2, and I think the member, James Green himself, said, well, you could show the commission of the crime by showing that the person didn't really mean to apply for a GRC and hadn't been using the correct pronouns, or had, I think you did say something about appearance. But I think because there's nothing on the face of the bill that requires a definition, I don't really think this would be enough. So that's why I'm really interested to probe this question. So how would you prove such a fraud? And of course, it's possible to reverse a GRC, and rightly so, because people may change their minds, so we do have a provision to reverse it. So my concern would be that there would be a reasonable explanation give. You could use that as a reasonable explanation, having been charged with a fraud under this offence, that you changed your mind and you reversed to GRC. I'm really just trying to probe at the technical nature of it and to see whether or not it is of any value. I mean, I would say on the balance, I would support having it than not having it, and I would also support having an aggravation because although it might be unclear to us now why it might be needed, I see rather to have a belt and braces than anything else. There is a requirement under Article 5 of the ECHR to provide legal certainty on how an offence is committed in any act that we pass. But I am concerned that the answers, not only from the Cabinet Secretary got at stage 2, don't seem to square with the legislation that we're looking at that doesn't actually require any specifics in order to acquire your gender. It's simply a declaration that that's the gender that you wish to be living in now and have your birth certificate aligned. So I'm just having some difficulty showing how would you prove that to a court. But on the balance, I would say I'd rather have it in the legislation than not. Thank you.
Thank you. I call Graham Simpson.
Thank you, Presiding Officer. And I think
they're going to keep buffering on me. I wonder if I can get the screen from somewhere else.
But I have not had to present any evidence other than state the fact or not that I'm a woman. So how can we have a fraud committed? Now people are looking puzzled by this. I am puzzled by the bill. Let me tell you. So we have a situation, now these well-meaning amendments, and they are well-meaning, yet you want to make an intervention, Mr. Kerr?
Stephen Kerr.
In my intervention to Jamie Green, I suggested that the only fraud possible would be someone obtaining a GRC for the purposes of some nefarious act they had in mind to perform.
But the nefarious thing is already illegal.
Graham Simpson.
Well, I agree that is a risk in the bill.
That's the crime.
That is one of the problems with the bill. But how do you prove it if no evidence is required to obtain one of these certificates? And that's something that many of us, or several of us, have been trying to tackle in the amending stages at stage 2 and stage 3, unsuccessfully. So we're left with a bill which requires no evidence, just self-ID. So how then can you have a fraud committed? Or, you know, unless you can prove that I have lied, and why would I own up to that? But somebody has to prove it in court. Why, you know, if you're going to have the... Yes?
Ash Regan.
Would the member agree with me that evidence suggests that the risk of getting caught committing an offence is a very effective part of deterrence?
Graham Simpson.
Correct. That would be a deterrent. So where's the risk here? There is very little risk because of the situation I've outlined, where no evidence required to obtain a certificate. How can the police, if they got involved, how would the police be able to prove anything?
Particular intervention at that point.
Yes.
But it's exactly the same problem with changing your name.
For taking intervention and actually wrestling this with that exact point since speaking to a policeman the other day who said to me that if a transgender person walked into the opposite toilet and was challenged by somebody in that toilet, one of those two people is committing an offence. How do they tell the difference?
Graham Simpson.
Precisely.
They don't
That
need
is
to
the
tell
point.
the difference because the
A
question
very
is
point,
whether or
a
not
good
one is
point,
harassing
well
the
made
other.
by Mr. Whittle, as I would expect. And so these all the amendments in this group, very well-meaning, and they would work if obtaining a gender certificate required you to produce some evidence, because then you could disprove the evidence. But we're not asking that. So unfortunately for me,
what evidence could be disproved?
None of these amendments work, and I would urge the members not to press them.
Thank you. I call the Cabinet Secretary.
Thank you, Presiding Officer. Can I just put on record my thanks to Parliament staff for the very late sitting last night. It was very much appreciated by members across the chamber. At stage 2, Jamie Green lodged an amendment to introduce a new statutory aggravator of an offence connected to fraudulently obtaining a gender recognition certificate. At the time, I supported Jamie Green's amendment with the caveat that it would require some adjustment at stage 3. I'm grateful to Jamie Green for working with me to develop the updated wording in Amendment 114. The introduction of a statutory aggravator supplements the other safeguards in the bill and provides additional assurance against misuse of the system. Jamie Green's other amendments in this group also strengthen the bill, and I'm happy to support them. Revocation was already possible through an application to a sheriff, but making it automatic in the case of conviction is sensible and appropriate, as he does here, and therefore I support all the amendments in this group in Jamie Green's name. I don't support Amendment 116 in the name of Rachel Hamilton, which specifically creates an offence of gaining fraudulent access to single-sex services. The bill already creates an offence of making a false application, with penalties identical to those in Rachel Hamilton's amendment. Under Jamie Green's amendments, there will also be an aggravator of an offence connected with a fraudulently obtained GRC. Yes.
Tess White.
The Cabinet Secretary. Could the Cabinet Secretary please just say what safeguards would be put in place to prevent those who fraudulently obtained a GRC from accessing women's-only spaces? Thank you.
Cabinet
Secretary. Not relevant.
So, first of all, the protections under the Equality Act that have exceptions for single-sex services spaces are there and are unchanged by this bill. And therefore, anyone who would be entering a service, for example, for victims of sexual assault that was for women only and could exclude trans women, if a trans woman was to try and enter that space, then it would be an offence under the common law, like breach of the peace, for example. If they were then, because they may be a genuine trans woman, trying to enter a service that excludes them, right? So in that circumstance, that would be. If they have a GRC under fraudulent and have made a false application, then clearly that is what is dealt with through these provisions. And it is a very serious offence with up to 2 years in prison and an unlimited fine in the circumstances that would be covered. Briefly.
The concept of applying fraudulently means. So will the Cabinet Secretary spell out for the benefit of all of us, what exactly does this offence amount to of applying fraudulently for a GRC? How do you define it? And how do you prove it?
So, for example...
Yeah. I might look at
someone, a person of interest,
we might
would
talk
be able
about
to go to
me.
the sheriff, for
It's
example.
not important at the moment.
And provide evidence, enough evidence that the sheriff themselves would look into whether
I'm
the
absolutely
person
right.
was living in the acquired gender, and essentially they would have to be able to demonstrate that they've been living in the acquired gender as per the guidance under the 2004 Act. At the end of the day, like any other, hang on a minute, like any other case in court, the sheriff would look at the circumstances of the case. And if it was found that the person had made a false application, looking at the circumstances of the case, then clearly they would then face the penalties for making that false declaration. And if they then went on to commit a crime, which is what these amendments deal with, and it was shown that part of the crime involved them having obtained falsely a gender recognition certificate, then there would be an...
I don't think it likes me napping with it at the same time.
Is this only the negatives at the moment or something?
In what sense? All the people that are discussing
Aggravator,
against it.
to
Yeah,
that.
pretty much. Because they're the ones that are trying to make amendments to spoil it.
So nobody's speaking for it at the moment because it's only the people trying to make the amendments.
Yeah.
Politicians are weird.
They are.
I follow the
crime.
Billy
I
Connolly
think this is
philosophy.
a
The desire to be
sensible
a
set
politician
of
should permanently
amendments
die
that
from ever
strengthen
being
the
one.
safeguards that are already in the bill, and I would ask members to support the amendments in the name of Jamie Green, but to reject the amendment in the name of Rachel Hamilton.
Up there.
Thank you. Jamie Green to wind up.
So I'm trying to adjust anything in OBS. It pauses the screen.
Thank you, Presiding Officer, and can I thank members for their contributions. It is a debate, and we on these benches are happy to have these debates, I'm pleased to say.
No, it's not even that.
Just to say 3 points, really, as these amendments
I haven't set any of it up.
are, from a legal point of view, self-explanatory,
I really should
lengthy,
the issue.
and just if I could make a little bit of progress, then I will. Thank you. I do want to say 3 things. The first point made by Polly McNeill is that I would rather there's something in the bill than nothing. I agree with that sentiment. I believe that there's something that introduced at stage 2
all I'm hearing
had
is
technical
blah, blah,
and legal
blah,
issues, and I've sought to
understand the
resolve
legislation,
those.
blah, blah, blah.
Without the assistance of certainly anyone in these benches, I've resorted to getting assistance from legal advice from elsewhere to try and make
ridiculous levels of panic about.
And I believe they are.
No, that's not how that works. People who are going to
as is
do
always
things
the
that
case
are
with these things,
offensive
such as
are going to do things that are offensive, and then they will be
aggravators that exist in
prosecuted
other
for those
pieces of
things that they did that are offensive.
They're often not.
This makes
we often don't know until they're tested.
About quality of life and right of marriage and defense of people, and it is about who gets into a bathroom.
In courts and
no different than any of the other things that these knobheads are talking about.
And they're put through their rigorous testing in that scenario. I do have sympathy with the notion that there is a spectrum of having nothing on the face of the bill that states what that criteria is around what constitutes an offence, and having a large range of specificity about it. And somewhere in the middle might have been a better balance. So I do understand that, and that's an issue that I wrestled with myself ahead of
the fact that these people even think that somebody would just
the second point, though, is
just so that
members are, of course,
some sort
as is their
of con
prerogative,
is absolutely.
if they don't support them, or they don't agree with them, or they think
Like,
they're poorly
benefit
worded,
that to anybody
don't vote for them.
who isn't
That is
trans.
the point of today's session. But the third
This is
point
it
is
over and
the
over
thing that
again.
maybe picked up, and that's the
It-
conflation of
it's
this
like,
with
wake
the
up,
other
you idiot.
clearly parallel issue of that of
I mean, there's only one
self-identification,
valid concern
which is
I've seen.
again a very valid debate to be had.
That I could see someone abusing it. I
Yeah,
don't
but-
think
yeah, on
they
the
would go
first
to
point.
trouble over GRC.
I'm very grateful.
And
Just
that
if
is
I may take the member back to the legal points, because I'm really
someone in
struggling
court
with. I
at the
just
point
didn't
at
hear an
which
answer from the Cabinet Secretary. We're talking about fraud here, which is a
they
criminal
applied
offence.
for a
And
GRC
it seems to me
after
that
they had
if
committed
that's right,
a
then
crime and they're
proving
using it to
requires
get to the
the
abuser.
act of doing this, but it also requires the mens rea.
It's
the
this
intention.
limited window.
And what I'm really struggling with here is to understand what
Yeah,
could be
and it's
adduced,
also
what
a case that
evidence
even if they
could
did
be
get
brought
a
forward
GRC to try
that
and
would
get,
show, that would prove beyond
you
reasonable
can
doubt
legally
that
separate
intention.
things out from
Because
that
I'm
so
not
that
hearing
the
that so
person's
far.
not going to be affected
Jamie
by
Green.
Yeah, and the member, makes a very valid point. The idea
even
that,
in that case, it's not that bad a
to prove that
case.
someone has made a
And all
statutory
the other
false
things that they're
statutory
worried about are
declaration
things that are handled
or
entirely
fraudulently obtained
separately.
a GRC, clearly is a matter for the court to decide. Now, there will be evidence given that, and again, it's difficult to foresee that because it so rarely happens, and indeed.
So what?
Since 2004, I believe it's so rare.
If you have committed some other crime and you have a GRC, the GRC is irrelevant to the fact that you've committed a crime.
Mm.
It is.
Rarely been
That's
tested,
like saying that
in
your
court,
birth
because it
certificate
already
bit,
is
wow.
possible
I suppose
to
it
get
does
a
in the
GRC, and
UK,
already is
considering
possible,
that women can't rape
and
in
an
the
offence
UK.
to make a false statutory declaration. So
But they use
I don't
that
have a huge
as
amount
a
of case study
hammer.
precedent to refer to.
Oh,
It would have been helpful.
Yeah,
if I did,
it's like,
actually.
but they do.
but
Women rape.
There are, you know, in my view, and I
It's
don't
not
want to
the fact that
preempt
women don't rape,
what
it's
courts'
that your
criteria
laws
might
are
look at,
archaic.
but the scenario where someone has made a declaration and clearly has done so falsely would include some of the factors I raised in my opening statement. For example, it could be proven demonstrably that that person had not been living in their acquired gender. There are ways of doing so. Yeah, no, 1 second. I want to answer the other member's point first. There are clearly manifest,
he actually brought God into it, didn't
manifest
he?
ways that one can do that, and that is, as I stated in the opening comments, around that of not living in one's acquired agenda for the period defined. For example, physical evidence of not using pronouns that are claimed to be attributed to the acquired gender, of those of evidence given from those who know the offender, who also believe that the declaration was made false. That evidence could be used in a court. And as stated in Amendment 114, the evidence from a single source is sufficient to prove that an offence is aggravated by a connection of a GRC obtained by fraud. And that would be a matter for the court in that case at that time to decide. If they were so moved that they do not believe that that case has been made, then that would be a matter for the court. Did another member have an intervention? Yeah, sure.
Jeremy Balfour.
Thank you, President. Can I thank Mr Green for taking this intervention?
Can you understand me now?
I want to talk to the Cabinet Secretary. I mean, I'm very sympathetic to what you're trying to do here. But the test within a criminal trial is beyond reasonable doubt. It's a very high test that a sheriff would have to take in regard to that. And I am still struggling to follow on, perhaps from Mr Simpson and Mr Kerr, is what evidence can the Crown bring in any case that would reach that test of beyond reasonable doubt? And I think there's a real danger here that we are making a law that could never be enforced. And is that a good way for us to be moving forward?
Jamie Green.
It may never be enforced, but could be enforced, Mr Balfour, and that's the point.
I can't remember, though.
It's important that it exists, so that in such a scenario it could be enforced.
That's all.
Now, that will... I hope it doesn't, because if
I can now. I couldn't a moment ago.
The system has been abused. But if we are in that scenario where it is tried and tested,
I asked you if you can hear me fine.
As
I thought you were talking to the chat.
It would be a matter for the court to decide.
No, I was asking you.
I
was thinking if I was roboting you,
false, and that the aggravator is so
you
relevant.
robot a little bit.
And I have
but
every
I think
faith
I'm fairly certain it's my
in the
I just don't
judiciary
trust
to
my
make
end is the issue.
that decision based on the evidence
Yeah,
that's provided.
to be honest, I'm not having a problem with the
defending.
stream from Parliament
And
at all.
that's common in a number of factors. As I said, this could be
Really
related in many ways to legislation this Parliament
and I
should probably
around
that.
aggravators around domestic abuse,
realised
where in
you-
that, for example,
that up. Okay.
the abuser was using children as a means, for example, to further traumatise the victim. And in that scenario, the court, on the balance of the whole, would decide that that's an aggravating factor. So this is it's not an unusual concept. I appreciate if members aren't happy with as it's worded, but are sympathetic to the notion of it, and I appreciate that.
So she's trying to say, I'm actually trying to defend people.
Word things in a way with advice that I get that make them competent, and I'm sure they are. But again, all of this would be tested in courts. In the unlikely scenario that this came to a court, the underlying principle, and this is a point I do want to make, though, is that the underlying principle behind it, what I'm trying to achieve, is to improve the scenario that there is a greater deterrent. You know, that perception of dropped safeguards as a result of simplification of the process, whether you agree with the new process or not, is that if in any way any member who can submit amendments, and we're all welcome to submit amendments, can introduce something that tries to improve the deterrent aspect of this, to say, no, you cannot use this new process for nefarious purposes, and if you do, the law will take that very seriously, and that's the underlying premise of it. If I haven't achieved that, and you don't think I've achieved that, don't vote for it. If you do, please do. What I cannot fix, though, is if members have problems with the concept of self-ID, that's not a problem I can fix. That is your personal view. No, I think I've probably said enough on this. Pardon? Well, I will give way then.
Yep.
Ruth McGuire.
Oh dear. I'm guessing, because I haven't actually seen any of the debates that happened in the British Parliament as opposed to the Scottish Parliament, that it wasn't quite as friendly. Big Ben. Would I be right, Amber?
I just wanted to be really clear. I was not making a point about self-identification in itself. I was just pointing out the difference.
Can I feel the
between
silence? Sorry, I didn't realize I wandered off. I apologize very much, everybody. Yeah, they could get a GRC because the GRC is set up in such a way and laden gets or it's almost possible. That's why it's still been handed out. Not that people weren't eligible, they just weren't handed out because the board made it so difficult. The whole idea is easier so that people have to self-identify basically. Are any doctor's papers required at all, Amber?
Say that, oh crap! I can't remember on this one. What?
Yeah, I'm not sure. I only know my experience in Australia, and Western Australia is very different anyway. Recognition certificates, you just apply to change birth certificate. And changing your birth certificate, because birth certificates actually mean more here than they do in the UK. To do that, when they first changed the laws, you had to have a signed letter and had to have had certain medical procedures. They know you're doing this, basically. And that's as hard as it really should be anyway. You shouldn't have it any harder than that. It is just absolutely mind-numbing. You've got years and years of waiting lists just to get hormones. Unless, of course, you can afford to go for a surgeon, then that depends on the surgeon. But to get started, it takes it may only 1 or 2 months for most people now, and even 20 years ago, you could start down the road of hormones in Australia within a couple of months. So why do you guys over there? It's pretty much just the
Sheffield GRC right now has a waiting.
Bag of the Tory party.
The Sheffield GRC right now has a waiting time of 35 years for an initial
35
appointment.
years now, is it?
Yeah.
Yeah, most people would be dead. Even if they didn't, even if the suicide rates weren't high for people getting refused treatment, most would still be dead for 35 years. It's ridiculous.
It is.
And I mean, my transition time is basically 2 years from starting to surgery. You get your first appointment in that time in the UK.
I mean, you're basically putting your life on hold while you do it. And they're out there saying to people, that's it, put your life on hold, for all your life.
Yeah. And it's really much a thing of the Tory party wanting to use trans people as the kicking bag. You know, if you've got to distract the public won't pay as much attention to you being shit at your job.
Mm.
There were no abstentions. The amendment is therefore agreed.
There were 16 extensions. 16 extensions.
Yes, I should, of course, have notified you that there were 16 abstentions. Point of order, Alexander Burnett.
Thank you, Presiding Officer, and I seek your guidance under the Scottish Parliament Standing Orders Rule 16.1.3, which states that the clerk shall arrange for minutes of proceedings to be published as soon as possible by whatever means is considered appropriate. It is obvious.
What the hell has this got to do with that?
It doesn't. They're trying to delay.
Time.
I can blame how bad this is.
And their staff at 17 minutes
Pretty
past
boring.
midnight, after the conclusion of a debate and many
It's
hours
hawkish, and I
after
suppose
some of
that's
the
to be
amendments had been voted on. And this is, I think, is completely, and even as I'm aware, the detailed results of all the amendments voted on last night have only just been published on the official report in the last hour.
Wow.
So can I clarify what measures are being taken to ensure that the standing orders of this place are being adhered to, in particular with regards to the details of the proceedings being made publicly available to everyone as soon as possible and not just a select group? Thank you.
I thank Mr Burnett. I thank Mr Burnett for his point of order. The rules do require that minutes are published as soon as possible by whatever means is considered appropriate. I am aware that divisions were notified to business managers as soon as possible. I believe that this was as close to the suspension of our proceedings last night as possible. Obviously, officials need, Mr Burnett will understand that officials need time to ensure that the minutes are correct before there are any published, and that there were several hours of business that had to be checked through before that publication took place. And we had an exceptionally late sitting last night, as everyone appreciates. I will look into the points that Mr Burnett raises with regards to information being available to some before others.
Oh.
Thank you. Point of order, Stephen Kerr.
I think it's important to ascertain from the Chair, the Presiding Officer, that it would be inappropriate for that information to have gone to journalists ahead of parliamentarians. I think that's a fundamental. I'd be grateful to have your ruling on that.
Thank you, Mr Kerr. I have just ruled on the point raised by Mr Burnett, and I did say in that ruling that I would look into that matter. Thank you. Can I call Amendment 50 in the name of Russell Finlay, already debated with Amendment 18? Russell Finlay, to move or not move?
Time.
The question is that Amendment 50 be agreed to. Are we all agreed? The Parliament is not agreed. We'll move to division, and members should cast their votes now.
I do like the Scottish Parliament deal. That's kind of cool.
I do like that most votes are done in 45 seconds.
Yeah, and it's not all ayes and nays, is it?
No.
So, because it's electronics. So. Do they actually have a record of which member voted what way?
Yes, because it comes up when they fuck it up. Because as soon as the vote's finished, they can shout a point of order if they think they fucked their vote up or it's not been counted, and then it can be done manually.
Okay.
Watched so many of these last night.
Having said that, I've always thought that we vote in secrecy. We're not supposed to tell other people how we vote. They should do that on the floor.
See, I'm not convinced that you should have anonymity in Parliament.
Because somebody could say they voted one way and then they didn't.
Yeah.
Yes. I do understand that. However, the fact that they don't have anonymity is what gives the party system so much power. I hate the party system. It would be so much better if each person actually stood for their constituency properly.
But how do you know if your
on amendment number 50 in the name of Russell Finlay?
Yeah,
is
that
yes
is of course the
62,
problem.
no 64. There were no abstentions. The amendment is therefore not agreed. We move to Group 11, late application for review of Registrar General's decision, and I call Amendment 109 in the name of Jamie Green in a group on its own.
Thank you, Presiding Officer. Hopefully a slightly less contentious group of amendments. Single amendment in this, Amendment 109, and it's around late application for review of Registrar General's decisions. We know, Presiding Officer, unfortunately, many transgender lives can be filled with much disruption and instability due to a wide range of socio-economic factors. I have spoken to a number of individuals who have already gone through the GRC process or are about to. Some do not have regular addresses, some have wider health, physical both, and mental health problems, and often require medical supervision or indeed intervention. As currently drafted on the bill, an individual seeking to obtain a GRC but has had their application refused for whatever reason does have the right to an appeal. That appeal must be made within 40 working days. There are provisions at the moment that allow the Registrar General to consider an appeal after this period if they so wish, but they are not required to. I'm concerned that if, for example, there is a higher number of applications or indeed additions to the duties that fall within the Registrar General's remit as a result of some of the amendments that may or may not pass, this 40-day deadline may indeed become a strict blanket deadline, irrespective of the circumstances of the applicant. I am of the view, sympathetically, that if a person were to have good reason for missing this deadline, perhaps, for example, due to hospital admission, sickness, change of living circumstances or a family emergency, then this should be taken into account when an appeal is submitted late. In 1 second. Amendment 109 is a relatively simple one. It does allow for late appeals, but only if the Registrar General is satisfied that the applicant had good reason for not making the request sooner. Who was first?
Liam Kerr.
It's just by way of clarification, if a way for the member. I think what he's talking about, and I followed the articulation
Obviously,
of it, but I think what he's talking about is
the arbiter of what's a good reason.
you can come in later if you have a good reason. Now, I appreciate the member gave some examples, but is there going to be guidance on what constitutes a good reason? And if not, who is the arbiter of what constitutes good in the reason?
Yeah, as stated, the amendment says that if the request is made after that period, the Registrar General must comply with the request if he or she is satisfied that the applicant had good reason for not making it sooner, but may not need to comply with it if not satisfied. It doesn't specify any grounds for which a scenario would be given. I think the concept of guidance is a very helpful one, actually. I might ask the Cabinet Secretary to reflect on that in closing comments. I think it would perhaps benefit from... There will be guidance associated with many other parts of this bill. This may be a good example where, rather than the face of the bill, we put prescriptive scenarios that the Registrar General must adhere to, but give some flexibility to the Registrar General, who I trust their judgment on whether they believe that the applicant had good reason to make a late application. But certainly, of course, some parameters around that and guidance to the Registrar General will be very helpful, given that the nature of the role of the Registrar General, and it's a point that we haven't really properly debated in all of this, is changing as a result of this legislation. And I think it does deserve you know, some wider airtime. And I'm sure we'll talk more about that as the day goes on. But yes, I don't disagree with the comments made by the member. Was there another intervention? Same point. Okay, I hope I've answered that. No further comments on that amendment, Presiding Officer. Thank you.
Thank you, Mr Green. I call on the Cabinet Secretary to respond.
Thank you, Presiding Officer. Hopefully I'll be similarly brief. Under the terms of the bill as introduced, the Registrar General must comply with a request for a review if it's made within 40 days of the application being determined, and may but need not comply if the request is made after that time. Amendment 109 provides further clarification on the discretion provided to the Registrar General to deal with late applications, and is a helpful clarification of the review process, and I'm happy to support. And I can confirm to Jamie Green and others that the National Records of Scotland will do guidance, and the Registrar General will apply to the individual circumstances using their judgment.
Hateful Jamie Green to wind up press or withdraw amendment 109.
Happy to see that further clarification on the role that NRS will play in producing guidance. I hope that addresses any concerns that members had. Thank you.
Mr Green. The question is that amendment 109 be agreed to. Are we all agreed? Are we all agreed? Yes. We are not agreed. There will be a division. Members should cast their votes now.
The kind of arsehole you wouldn't scrape up the pavement if they got hit by a truck.
Yeah, the worst thing is we would, because we're nice. And that's
the problem. Yeah, we would scrape them up. Maybe not for their benefit, but for the benefit of other people, because you know what it is.
I'm not sleeping last night trying to think about how the right and left at the moment can move forward.
That's the difference, because the people on the left tend to be decent anyway, so they're going to do the decent thing even when you get shut on from the right.
How does
and this is why the right continually shit on anybody on the left.
How does Biden fight the current Trumpism? Because you can't go after
Trump
the
vote's closed.
Unless you play dirty.
Yeah.
And you're trying to fight against the dirty. I don't know how you do it.
Yeah, because you can't fight dirty with nice.
And the result of the vote on amendment number 109 in the name of Jamie Green is yes, 116, no 4. There were 5 abstentions. That amendment is therefore agreed to. I call amendment 52 in the name of Russell Finlay, already debated with amendment 18. Russell Finlay, can move or not move? Moved. That is moved. The question is amendment 52 be agreed to. Are we all agreed? Yes. The Parliament's not agreed. There will be division. Members should cast their votes now.
The problem is the whole idea of preventing people who commit offences from obtaining a GRC goes directly against their underlying right.
Exactly. The fact that somebody who committed an offence shouldn't if you've served your time, you've served your time. You don't. Yeah. And I understand this. The fear and paranoia of people who think like that is just amazing to me. Although I do understand it from the point of view that our prisons are not designed to reform people.
They're not. The problem is again, we have a left-right problem. The left keeps... We've gone through 30 years of me watching prison reform, of us actually trying to progressively, slowly move forward to it being a more reforming, more helpful, more rehabilitating system. And then every time anyone slightly right-wing gets in power, it's about punishment and reducing costs. But it's only costs there, not costs to greater society.
Yeah,
and the vote's closed.
I've had one of... sorry, brain fog for a second there. I've had this discussion with a few people, and one of those things is that in
The
general,
result of the vote on amendment number
politicians
52
only
in the
look
name
to
of
what
Russell Finlay
actually
is yes
affects their bottom
61,
line
no
in the
63. There was one abstention. The amendment is
4
therefore
years, say,
not
if your
agreed.
parliamentary term
Call
is 4
amendment
years.
53
But if
in the
they
name of
only
Russell
care
Finlay, already
about those
debated.
4
With amendment
years,
18,
what comes
Mr
after
Finlay
it is
to move
somebody
on.
else's problem.
Move.
Even if it ends up
It's
being
moved.
their
The question
problem,
is that
somebody
amendment
else's
53 be agreed to. Are we
So
all agreed?
So there's
Parliament is
there's
not
no
agreed. There'll be a
real
division. Members
long-term
should
planning
cast the
policy.
votes now.
See, what you're
It's all about
arguing
what
for
you can do
now is hereditary peers.
I'm not. I'm really not. I don't like the idea of hereditary peers. I just think there should be there should be more of a method of holding governments accountable. We should, and I mean that's the idea of voting, is to hold governments accountable, but it doesn't work. I mean, even in a country like mine where people have to vote, and that you still don't necessarily hold governments accountable, not straight away. We let them get away with so much shit before we hold them accountable. Granted, we tend to then really hold them accountable. I mean, our Conservative Party of West Australia was so decimated that their coalition partner is now the lead part of that coalition.
And
So the minor party of the coalition became the major party of the coalition because the major coalition partner got absolutely decimated. They hardly won a seat last election. And our Labor Party absolutely flogged them. Which is awesome.
And the result of the vote on amendment number 53
they
in
had
the name of Russell Finlay is
they had a
yes 60, no 62.
that they should not
There were
have
2
had
abstentions. The
to
amendment
fuck
is
things
therefore
up more
not
before they
agreed.
finally
Call amendment 110 in the name of Jamie Green, already debated with amendment 108. Jamie Green to move or not move?
Moved.
That is moved. The question is that amendment 110 be agreed to. Are we all agreed? We are not agreed. There will be a division. Members should cast their votes now.
The problem, I go backwards and forwards, and I don't have good solutions, because you end up going. We are now in an age where technically we could have relatively direct democracy.
We could, at least on the big thing. You could technically implement a system where you could have regular votes on the big issues. And generally speaking, politicians know what the general public want. I mean, one of the biggest hassles for you guys is because you have a first past the post and non-compulsory voting, the voting tends to be skewed.
Yeah.
Towards the haves, people who are generally right-wing.
Yeah.
And so you've got these laden
And the vote is
things.
closed.
It changes young people and the poor downtrodden decide that they have to do something. But if you don't have to do something, you tend to find those who are the have-nots in society don't do it because it costs them. There is a personal cost
The
to
result of the
having
vote
to
on
go and
amendment
vote.
number 110 in the name of Jamie Green is yes 92, no 13. There were 19 abstentions. The amendment is therefore agreed. We now move to Group 12, manifestly unfounded application to Sheriff to revoke certificate. I call Amendment 51 in the name of Pam Duncan-Glancy in a group on its own. Pam Duncan-Glancy to move and speak to Amendment 51.
Thank you, Deputy Presiding Officer. I wish to speak to Amendment 51 in my name. The function of the person of interest at Section 8S in this legislation is essential. It makes provision for someone with a genuine interest in a person's GRC application to intervene and express concern that the application has been made fraudulently or that the person was coerced or did not understand the effect of obtaining the certificate. The definition of a person of interest has been drawn more widely in this bill than was in the 2004 Act to take account of the changed process proposed, and Scottish Labour support that definition. Proportionality to this function in the bill so that it serves the purpose it is intended and is not used as a means to unfairly block a GRC application. This amendment will give the Sheriff jurisdiction to determine that an application under under Section 8S is manifestly unfounded. That it is to say that the person making the application to the Sheriff has malicious intent, is using the request with no real purpose other than to cause disruption, makes unsubstantiated accusations against or is targeting the applicant because they have a problem with them, unless it is proved on the balance of probabilities that it is not. The amendment transfers the burden of proof to the respondent in any civil proceedings so that it is for them to prove the GRC application should be revoked.
It's my end.
Ensuring it is not for the GRC
it's your end.
The applicant to disprove any claims.
Starting to hate Windows 11.
Made against them. My Amendment 51 clarifies that evidence used to prove a fraudulent GRC application cannot be based on personal feelings toward the applicant, nor their view on gender reassignment itself. Applications under the person of interest powers are important, but they must be based on evidence that transcends personal opinion. I am confident that this amendment will address concerns that a person of interest who disapproves of a trans person's identity and their right to exist may use the courts to interfere in a GRC application. I will.
Liam Kerr.
I'm very grateful. I just want to make sure that the member is going to address this, which you may be going on to do. At the end of this clause, there's a definition of manifestly unfounded, and it finishes by saying that that turns on it having no, quote, evidential basis. Can the member help me understand, is there any specification of what might constitute evidence for that evidential basis, and or is there a threshold around sufficiency?
Pam Duncan-Glancy.
I thank the member for the intervention, and the language that's used in this part of the amendment was taken from the data protection legislation and also around FOIs, information around FOIs. And so there is already some precedence in how to look at that, but ultimately this would be a matter for a sheriff to determine, because at this point a sheriff has already been involved because the person of interest function has been invoked. And so it would be for the sheriff to determine whether or not there was evidence. And I hope that helps the member and provides the clarity that they need. In my view, we must protect trans people from manifestly unfounded claims, and I believe that this is something in which all of us in this chamber can agree. We also believe, as I've said, that the person of interest function is incredibly important. We believe that together with this amendment and the person of interest function, we have a suite of protections that ensure that trans people and other people get what they need from this legislation. And I urge colleagues to support this amendment, and I move. I will.
Hit by a truck, he'd probably rise again from the grave.
Does she also accept that this provision for the award of damages may put off people who have genuine concerns, but would be afraid of this element of the bill? But maybe that is her deliberate design. I don't think it is. But does she accept that this could have a serious dissuading influence over people who have genuine concerns but are terrified of what that might mean if the court ruled something differently than they would hope it would, that it would put them off completely?
Pam Duncan-Glancy.
I thank the member for the intervention, and no, I don't, because I believe if those concerns are genuine, then they would be able to prove that. They would be able to have the evidence that would be required. So the definition of malicious intent and manifestly unfounded, rather, is that it has malicious intent, is using the request with no real purpose other than to cause disruption, anyway, and makes unsubstantiated accusations. Anyone who can make substantiated accusations, who therefore has, in the member's words, a genuine concern, shouldn't be put off by this part of the legislation. It isn't designed to deter them. It is designed to deter people who may wish to frustrate the process for trans people who I think we all believe need access to this system. And even people who have voiced concerns about this bill, I believe, recognise that trans people who need to change their legal gender should not be blocked from doing so just because somebody doesn't agree with their acquired gender status. And so with that, Presiding Officer, I move the amendment in my name.
Thank you, Ms Duncan-Glancy. And I call Murdo Fraser.
Thank you, Deputy Presiding Officer, and I thank Pam Duncan-Glancy for bringing forward this amendment and for her explanation of it. It references unfounded applications under Section 85, which allows for gender recognition certificates to be revoked on application to a sheriff if the sheriff is satisfied that on the balance of probabilities the application was fraudulent. Where a sheriff makes this finding, they must revoke the certificate or take other action as appropriate in the specifics of the case. Now, I understand Pam Duncan-Glancy's intent in bringing forward this particular amendment, but having considered it very carefully, I'm concerned that it is confused and it does throw up a number of legal difficulties. The amendment seeks to make a provision that would allow sheriffs to determine that an application to revoke a gender recognition was manifestly unfounded. So a sheriff finding an application was, as with an application that was fraudulent, a sheriff can judge an application for revocation was unfounded on the balance of probabilities. And as has just been mentioned by my colleague Stephen Kerr, the section would also allow for the award of compensation where injured feelings are found to have occurred as a result of a manifestly unfounded application for revocation. And this manifestly unfounded application for revoking a gender recognition certificate is defined as one that was intentionally misleading, made in accordance with the applicant's feelings about gender recognition certificates and had no evidential basis. Now, there are a number of issues with this, and we have, over the course of the afternoon already, had quite lengthy debates around this whole very difficult issue of fraudulent applications and this question of evidence. Somebody can apply for a gender recognition certificate with no evidence whatsoever. That is the whole principle behind self-identification. They are not required to say, they are not required to, for example, change their appearance or change their pronouns. They are not required to change the way they dress. These are not requirements for obtaining a gender recognition certificate. So I really struggle to see what the evidential basis that is referred to in this particular amendment would actually refer to, because none of these things are prerequisites for the obtaining of a gender recognition certificate if we accept the principle of self-identification. So, yes, of course.
Pam Duncan-Glancy.
I thank the member for taking the intervention, and all of the things that the member has just outlined are not current requirements of what people have to prove in order to access your gender recognition certificate, and so this amendment neither changes nor affects any of those provisions.
Murdo Fraser.
Yeah, I accept that point by Pam Duncan-Glancy, but with respect, I don't think it actually strengthens her case, because she is putting forward an amendment that refers to evidential basis, and effectively she's now, I'm afraid, arguing against herself by saying these things are not currently required. Now, so what we're doing is we're creating a mechanism with an ill-defined threshold, and therefore throwing it on to sheriffs to try and make that judgment against these criteria on the balance of probabilities, with no history of case law around these particular areas. And I think it would be extremely difficult for a sheriff to try and make these judgments based on the amendment that's before us. And the second point is, and it's already been mentioned, the amendment would allow for compensation to be awarded to those who successfully claimed an application was manifestly unfounded. Now, I think there is a genuine worry this will lead to a situation where there are people who know or are concerned that a gender recognition certificate was fraudulently claimed, but they won't apply for a revocation because they are worried about the financial consequences on them should that challenge not be successful. Should, on the balance of probabilities, a sheriff reject that challenge, they would then be liable potentially for financial compensation, and that will act as a potential barrier to people seeking to challenge these awards. So I believe that allowing people to apply for revocation of a gender recognition certificate without fear of litigation is important because of the way that this legislation is opening up the whole process with so many safeguards being removed. Threatening individuals with legal action if they take up an option to simply apply for review of a grant of a gender recognition certificate should not, in my view, be in this bill. I hope that colleagues will support me in opposing this amendment.
Thank you, Mr Fraser. I now call the Cabinet Secretary to respond.
Thank you. I know from the evidence provided to the committee and through our own consultations that there is a concern in the trans community about potential misuse of the ability of a person with an interest to apply to a sheriff for a GRC to be revoked, and I can understand that. The bill allows for a person who has an interest in a GRC to apply to the sheriff to revoke a certificate on the ground that the application was fraudulent, or that the applicant was incapable of understanding the effect of it, or that the applicant was incapable of validly making the application, and that is an important safeguard. The person seeking to revoke a certificate would need to have a genuine interest in the certificate, in that it would have to affect them personally or professionally, and they would be required to produce evidence of their interest and of the ground on which the certificate could be revoked.
Cabinet Secretary, could you resume your seat?
All
Point
right.
of order, Tess White.
Officer, as you can see, the gallery again is not full. There are people again who have been refused tickets, who would like to actually witness what's happening today. They've been refused tickets, they've been told they can't access. That's completely unacceptable. And will the presiding officer take a view, please, and those women and people who can't get access, please? It might be too late, but there are some who would like access for the empty seats above. Thank you.
This is on the back of 4 women in Scotland have fraudulently claimed
there was
all
no
the
evidence
tickets.
that people had been prevented from coming into the building, as far as I'm aware.
I have evidence, and I will feed that to the.
White,
so
thank you.
women in Scotland got all the tickets and then didn't show up,
Yes.
so that people.
I will not have the chair challenge, Miss White.
Right
I'm
now, the only
responding to
people,
your point of
virtually
order.
all the people in the audience are gentlemen.
I will respond to your current point of order.
Scotland,
I
who are
will
a turf
ask that
organisation,
this matter be looked
and of course
into.
they
It's
can't
not
get
something I can rule on from the chair. As
Of
was said
course,
yesterday,
they're basically
we would hope
stopping
and
anybody else
expect any members of the public that wish to attend proceedings to be in the public gallery that can be accommodated to be
That's
allowed
why
to
there's
do
so few people there.
With
'cause
that,
there's so
I would
few,
invite the Cabinet Secretary to continue her remarks.
Yes.
Thank you.
very loud.
As I was saying, that the person
had like
seeking
11
to
yesterday.
revoke a certificate would have to
Outside.
have a genuine
11.
interest in the certificate, and it would have to affect them personally or professionally, and they would be required to produce evidence of their interest and of the ground on which the certificate could be revoked. At stage 2, a number of amendments were lodged along similar lines to Amendment 51. I indicated at the time that I was sympathetic to the aims of those amendments and would consider if there was anything that could address those concerns without raising wider access to justice issues. I have not been able to identify any for this bill because existing mechanisms already allow the courts to dismiss groundless applications in the most efficient manner. In a clear case of lack of genuine interest or bad faith, a sheriff could dismiss a case at the first hearing without even having required the GRC holder to formally participate. It is a common statutory requirement that a person has an interest in a particular matter in order to bring proceedings to court, and the courts are used to determining what amounts to a genuine interest. Yes.
Pam Duncan-Glancy.
Thank the Cabinet Secretary for taking the intervention. Would the Cabinet Secretary accept, though, that in those proceedings it is on the GRC applicant to, the burden of proof is on the GRC applicant rather than the person who is applying to revoke the certificate?
Cabinet Secretary.
Oh, let me just continue. If a person was to make repeated vexatious applications to revoke the GRCs of different GRC holders, there is an existing provision in the Courts Reform Scotland Act 2014 that would allow the Lord Advocate in the public interest to apply to the Court of Session for a vexatious litigation order, and this would require the person to get permission from the court before making a further application. The courts also have existing powers to properly compensate the GRC holder for their legal expenses and to sanction a malicious applicant through an enhanced award of expenses against them. Now, we will work with the Scottish Courts and Tribunals Service on any updates or changes to court rules which are needed as a result of the bill, including where those rules could avoid any negative impacts on the GRC holders which arise from the court proceedings. Now, I consider that the law already provides mechanisms that can be used to respond to a malicious application, because, of course, the prospect of litigation being used maliciously is a general issue that is not particular to these circumstances. There does not appear to be anything further that could be achieved in the bill without either duplicating the existing machinery or restricting access to justice in a way that would be unacceptable. So I'm pleased to say, however, that amendments in Group 15 about the requirement to review the bill will include that we will review the provision allowing applications to be made to the sheriff, and I hope that that would be enough for Pam Duncan-Glancy and indeed Maggie Chapman, who's also expressed an interest in this, to be reassured that we will look and see whether the existing machinery which has worked well to date would also cover the issues that Pam Duncan-Glancy raises, and I hope on that basis that she'll not push her amendment.
This late.
Thank you. I call Pam Duncan-Glancy to wind up and press or withdraw Amendment 51. Ms Duncan-Glancy.
Thank you, Deputy Presiding Officer. And in the interest of brevity, I will be brief and as clear as I can and quick. I don't accept some of the concerns that were raised by my colleagues opposite around the fact that the deterrent of potentially having civil proceedings against someone will stop somebody using the person of interest power. I'll come to where I started on this, which is that we believe the person of interest power in this bill is entirely proportionate and we support it. Indeed, we voted against narrowing the person of interest power at stage 2 because we think it's incredibly important that it is there. But this amendment, I believe, allows us to bring some proportionality to that and ensure that where someone does use that, they have to bring evidence. And so the point about being worried about not being able to do it because of the level of evidence is not actually, I think, an accurate one, because in order to bring an accusation of a fraudulent claim or coercion or that someone didn't understand the application, evidence is required anyway. And so the point of this amendment is to say that the basis of that evidence was actually not founded and there wasn't enough evidence there to prove that it was in fact a fraudulent or an unclear application. On the Cabinet Secretary's points about existing legislation, I think those points are important, and I welcome the fact that they're in the review, but I still think the burden of proof is therefore left on the trans person, and I think that we have to be really clear that in this situation we need to ensure that the burden of proof does not sit with a trans person to prove where someone is trying to deliberately prevent them from accessing a GRC. And so that's why I can't accept that the existing mechanisms are enough. I will look forward to how the review sees this. On that basis, Presiding Officer, I will move the amendment.
Thank you. The question is that Amendment 51 be agreed to. Are we all agreed? We are not agreed. There will be a division. Members should cast their votes.
That is absolutely nuts in my mind. And civil cases are not cheap. So
no, but it does say that they will be paid for, compensated. But I don't think. My guess,
she did say that.
Yeah, that's part of it. So that if it is vexatious, that the courts would pay. I can't remember the wording, but in my experience, they don't usually pay anything to justify.
Yeah. So basically, you're putting more hardship on people who are already one of the lowest socioeconomics on average. Yeah, no. Yeah, they need this amendment to go through. I mean, it's not a be-all and end-all to the whole thing.
Point of order, Megan Gallagher, who joins us online.
Needs this amendment.
Thank you, Presiding Officer. My laptop froze and I'm unsure if my vote was recorded. Can I please confirm if it has been? Thank you.
Thank you, Ms Gallagher. I can confirm that your vote was in fact recorded. Thank you.
Thank you.
The result of the vote on amendment number 51 in the name of Pam Duncan-Glancy is yes 26, no 98. There were no abstentions. The amendment is therefore not agreed. With that, we move to Group 30. Point of order, Rachel Hamilton.
Presiding Officer, thank you. Under Rule 9.10.6, I would like to submit a manuscript amendment to the Gender Recognition Reform Scotland Bill, which would leave out Section 15A. As I understand it, Scottish Parliament guidance on amendments reads, and I quote, "If no amendment to leave out the section or schedule has been lodged in advance, any member may lodge a manuscript amendment to leave it out." I can submit the wording to the Presiding Officer if necessary and if it's not already been done. I hope this can be permitted, and I would like to briefly explain why I intend to lodge this manuscript amendment. Section 15A was agreed to as an amendment by the Equalities Committee at Stage 2 of the proceedings on the Gender Recognition Reform Scotland Bill. I, along with my colleague Pam Gosell, abstained on this amendment, which was voted on the 22nd of November 2022. The date is important to remember here. The rush deadline for submitting amendments to the Gender Recognition Bill was 12 p.m. on Tuesday the 13th of December 2022. Just after this deadline, the Court of Session published its ruling on the judicial review from For Women Scotland regarding whether holding a gender recognition certificate changes the person's sex for the purposes of the Equality Act. Lady Haldane ruled, and again I quote, "I conclude that in this context, which is the meaning of sex for the purposes of the 2010 Act, sex is not limited to biological or birth sex, but includes those in possession of a GRC obtained in accordance with the 2004 Act. This clearly has a substantial impact on how the Equality Act 2010 is to be interpreted for the purposes of those who hold a gender recognition certificate, which is what the Gender Recognition Reform Bill relates to. But Parliament has not had the ability to decide on this section since this Court of Session ruling, and no amendments could be submitted in time for the Stage 3 deadline, because the ruling was made public after the amendment deadline. Given the importance, Presiding Officer, of this court ruling in interpreting this Act, I think it is important that the Presiding Officer accepts the amendment in my name so that the Parliament is able to debate the substantive effect of the Court of Session ruling in relation to how the Equality Act is to be interpreted, as I said,
it's not
in
like
relation
a GRC
to this
is
Act.
new.
I seek, Presiding Officer, to
This
move the
has
manuscript
been
amendment
debated.
in my name
This
to
is-
leave out section 15A. Thank you.
Thank you, Ms Hamilton. As manuscript amendments are a matter either for the convener or for the presiding officer, I'm going to have to suspend this session of the Parliament for the time being.
Oh, fantastic. So they're suspending it because they're trying to put a delaying thing in. I don't know what section 15 is. Because of the 4 Women Scotland ruling, which went very much against them.
Which blows my mind that they would even bring it up, because it was so against.
Again, they're just trying to ruin the bill.
Yeah,
absolutely trying to ruin the bill. I wonder how long they're going to delay for.
And I don't even get why they. I don't understand why they care so much.
Oh, that's an interesting question.
It's something that will not affect any of these people.
Because they've been told it will. Because they think it. Again, in terms of they make it out to be something it's not. They claim the GRC is something that it's something horrific that will change women's life everywhere.
Yeah,
that will in no way make a difference.
Yeah. It's like there are lots of really, really important women's issues to fight about, and this isn't one of them.
Oh, we were talking to Beth on Katie's stream on Monday.
Okay, yeah.
And she commented on the fact that one of the major feminist groups in Scotland didn't, in any way, shape, or form, go to fight the abortion protests.
Really?
Yeah. And the number of the gender critical feminist groups that are not fighting for people trying to
for women's rights.
Yeah,
because they're not feminists.
No.
They don't they're upper middle class twats who sit around drinking tea and coffee, hopefully getting a chance to chinwag with J.K. Rowling, who have never had a real issue in their entire fucking lives. That's what it is. They're busybodies. They're the neighbours who peek through the curtains. At everyone else.
It's I think it's something that's not going to affect them ever. Did you see completely? Just because it was funny and it reminded me. Did you watch the Marriage Act go through the states, and there was a senator or congresswoman that cried because they were doing this to her, allowing gay people to get married, was doing this to her. She cried. Right?
I did see it. Yes, I do. I do remember that now.
Did you see what happened yesterday?
No.
Because he put out a video.
No.
When the bill was signed in by Biden, he invited her gay nephew. Which was funny as all hell, because he's apparently a TikToker that went viral because of it, because obviously she stood up And he wants to get married.
Yeah. So she's going out of her way to try and stop her nephew from getting married.
Yeah.
See, this is the thing. These people are just such assholes. Like, if you're so against gay marriage, don't have a gay marriage.
Yeah.
It's very simple. Just stay out of other people's fucking marriage.
Yeah. I don't understand the...
It's really simple. Not your fucking nose in other people's business.
Oh, I don't get it. I don't get it. And
it blows my mind.
I think Labour's getting to a point where they're going to have to come out strongly on this, given especially all the revelations over the last few days.
Yeah.
They can't sit on the fence on this for much longer.
No, but they'll try.
But the problem we've got at the moment...
They're worried it's what we'll lose in the next election over there, but you see, they're going to lose that election anyway because they're fucking disorganised.
The problem is they will lose that election if they let this... If they sit on the fence until the election.
Till the election.
They could have the fight now.
Yeah, you need to fight it now, and
by the time of the election...
if you can prove how dumb and stupid that the Tories are for even making this an issue, they can win votes on that.
Yeah. The problem is they need to kick a load of people out. But the problem is that it's looking more and more like the people they need to kick out are fucking Tories in disguise. That are only in there to try and cause trouble.
Yeah, exactly. It's just, yeah. I mean, we had the same thing over here with our last election, but the best part about it was our big turfs who tried to stand for the Liberal Party over here didn't get voted in. Because, look, the Labour Party here just turned around and said, "You're fucking bigots. No one should vote for a bigot." That was pretty much the campaign against those particular seats. It was like, you're bigots. No one should vote for a bigot. So those people didn't win the seats.
No.
Over here, being a bigot might get more bigots to vote for you, but everyone has to vote. Yeah. Sane people who can see that this person's obviously just a bigot, go, yeah, we're not voting for them.
How many people don't vote?
Very few. I mean, it's a requirement here.
Yes, but how many people don't vote properly?
As in informal voting. It's less than 5%.
That's not bad.
It's pretty good. Well, I mean, our voting system is fairly easy. Even though we have a preferential system, technically, as long as you pick your first 3 candidates, your vote is still legal.
Mm-hmm.
So you just have to pick your first 3 preferences, because that's enough for the preference to hold enough weight, because any person after that those votes probably aren't going to make much difference to the final outcome anyway. Unless, of course, you're a real fringe voter. But generally speaking, there's going to be more than 1 or 2 votes in the end, so it's not going to make that much difference. But they will count votes as long as you definitely mark off your first 3. And for the our Senate, our upper house, which your lords, which you don't get to vote for, but we get to vote for ours. You can vote, tick basically a party box that picks the voting layout for you.
Yeah.
Based on what your party would choose for that.
How popular is your new monarch?
Your new monarch? I don't believe in our monarch. In the monarchy. I said, and people went off at me for it because she just died, that the Queen's died. Now's a really good time for us to become a republic.
Yeah.
You don't fuck around afterwards. You do it now.
The problem is
that's a bit heartless. Why? Why is that heartless? She's dead anyway. What difference does it make to her? It's like,
I just couldn't get over the level of propaganda on every piece of media.
Yeah.
That to instill.
I tried to ignore it.
Oh, I ignored it completely. But watching it, and the fact that we had every bus stop with King Charles on, King Charles and his photo. Yeah, I don't think I've ever seen anything quite so dystopian.
Do you have Charles coins yet?
Have what? No.
Yeah.
24, I think.
24.
I mean, I think they're hoping that he'll die before it comes out.
Before they have to issue any. But they still have to issue whoever the next.
Yeah, but you've got to imagine that.
I'm not going to make assumptions on who.
Andrew,
will be next
who's next? Harry? No, not Harry. That would be annoying. I don't know.
Andrew.
William?
No, I don't know. Who's Charles' eldest?
Not Harry. Harry and I don't know. I actually don't know.
I can't remember. But I mean, they could die in an accident before Charles dies, and then it would go on to. No, because they've changed the way the bloody thing works now, haven't they?
I can't remember who'd be king. I don't think has Harry actually given up.
I don't know. I think Charles shouldn't have taken it. To be perfectly honest, he should have let somebody younger take it.
The problem is he couldn't. I mean, he could get it and then abdicate, but he would still have to get it.
Could he just refuse and it would go to the next?
No.
He can't.
No.
That is ridiculous.
Yes.
That a monarchy is ridiculous. Hereditary anything like that when it comes to politics is just ridiculous. I'm sorry, and I can't believe my country is dumb enough to bend the knee at, well,
no.
people.
It's worse than that, isn't it? Your country doesn't just have a hereditary monarch. It has somebody else's hereditary monarch.
Yeah, it's worse. Not only that, I mean, at the point where our Gough Whitlam got sacked, which is, a fair while ago now, like, before most of the people in the chat were born, probably. But when Gough Whitlam, our Prime Minister, was sacked by the Governor-General, effectively, your monarch, through the Governor-General of Australia, had more power over Australian politics than she did in the UK.
Yeah, but don't forget, technically...
Charles...
Go on.
Because Charles can't sack your government.
Yes, he technically can.
Can he?
Yeah. Oh, no, technically,
Really?
we're pretty much within limits, technically, the king has pretty much absolute power. He can dissolve the parliament, no problem. Done.
He can dissolve the parliament.
Yeah.
Okay, so, but we had the same thing. What? So technically, the Queen... I mean, I don't think it's possible now. That there has to be more stipulations on it, because we were, oh shit, that was bad, and it nearly caused a civil war. that whole thing, sacking a sitting parliament, is just But,
well, it's the problem I've got with to be honest, it's my biggest problem with the monarchy. Not that I particularly agree with the idea of a monarchy, but my biggest problem with it is it actually offers no oversight.
No.
If there was somebody there that was there solely to protect a constitution or a system of government, so that the people could petition to turn around and say, this government is not doing what we want, that would then dissolve it and deal with it. I mean, you're almost talking about a president there. But that doesn't really matter that much. The problem is right now, if the monarch was to do that, they would be abolished by Parliament the next day. So there's nothing there. There is no protection from the monarch for the people. So what's the point? To look pretty,
Yeah.
for the tourism. Well, we
Yeah,
can have all that
tourism.
tourism without them having a
But
constitutional
nobody
role.
wants to go to the UK to see Charles.
Ah,
You'd be better off with Meghan Markle as Queen.
and we get more American tourists.
You would.
I mean, we could make a fortune just from the coronation.
She'd be really cool because she'd tell all the bigots to fuck off too. Probably in that language.
Oh.
And Harry's like his old man. He just says what comes not his old man, his grandfather, and he says what comes in his
Oh,
head.
I was
So
going to say,
that
his
actually
actual
looks
dad.
kinda cool. No, he's actual. Charles is a bit like that now, isn't he? He just
No,
says
no,
what
I
comes
wasn't
in his
referring
head.
to Charles.
His actual dad. You're making assumptions there.
Let's put it this way. Gingers are not very common within the royal bloodline.
Yeah, that's true. Hey, they need better bloodlines.
Oh, they really do. They are. I don't know how we got here. I think Scotland will go republic as soon as it gets independence.
Oh, yeah. They'll probably beat us. I cannot believe how hard it's been for this country to come to the thing of we should become a republic. There's nothing stopping us from still being part of the Commonwealth and being a republic, because the Commonwealth isn't about accepting the Queen as your head of state anymore.
No, not really.
So we could stay out of the Commonwealth, but not treat the Queen as our head of state, which would be ideal, I think, for Australia.
Mm.
I think there probably needs to be some changes. I wouldn't like to have an American-style presidential system.
Standing now,
You give too much power to one person when that sort of thing happens. But I'm sure there's a compromise that could be done that would give us the oversight. And it would work, but yeah, it's just ridiculous.
The British monarchy knows all
How long
about
is this suspended for, by the way?
We don't know. Last time it was half an hour.
Oh, wow.
It's while they argue. I'm watching here the Twitter feed from Beth, who's in there.
Oh, Beth is there.
Yes.
How did Beth manage to get in there?
I don't know. I probably got a ticket very early. Because she's been tweeting. She might not actually go. She might not actually be in the chamber. She might be outside watching it. I don't know. But I do know that there were lots of them that couldn't get tickets.
Why is Joanna Cherry there?
Because she's a GC personality. Oh. They were trying to pass her off as an independent expert.
Really?
Yeah.
That's like saying J.K. Rowling is a great adult author.
I've lost my mouse. Oh. When are they going to get back? Buddy, plenty of guns, he'll fill you up. I thought everyone had guns in America, even if they were illegal. I thought you had your legal gun and your dozen illegal guns.
Certainly don't have that here.
No, you only have. Do you have a legal gun?
I think I only know 2 people who own guns, and both of them are from farms.
I was going to say the only person I've known particularly with a gun was a farmer.
I don't know. I used to know somebody who carried a gun, but they were a police officer. So that's a little bit different. And even then, not all our police officers carry guns all the time either. So.
Well, most of ours. Well, I'm disturbed at how much I've seen guns around in police hands.
Yeah, don't you have to have special training? You do actually have to have the special training to be able to carry a gun in the UK if you're an officer.
Yes.
Yeah.
But again, most people.
I know it's the same here.
Sorry,
just yawning in my microphone.
Most of the police you see with guns here nowadays are automatic. They're big guns, not like pistols.
Yeah. Why am I reading the comments? Oh, I have to read the comments over there because you're using OBS.
Yes. Yes, I had. Well, I hadn't actually. I didn't know what I intended. I intended to sit and play games. but I couldn't concentrate and do anything else.
Fair enough. I totally get that.
I'm
Phoebe's not around, is she? She'd probably have some good things to.
I'm assuming she's in work. I've had to close Twitter because I'm fairly certain that Twitter was one of the things that was causing the stream. I think the problem with Vodafone is not the bandwidth, but the number of connections. So me having things like Twitter and Discord open over here, I think, are causing problems because it's been a lot more stable since I closed Twitter.
Ooh. But just letting people know that the Cunt of the Year awards, because we had our nominations last night for me, midday your time. Jeff has the polls up on his channel now. So Godless Summer.
Who's winning?
Has the polls. I haven't looked yet, so shall I go do that?
Yeah, go on.
So I need to vote too. I can't even.
Have a look. Okay. Oh, well, here we go. Should we go through them? Oh, I clicked the wrong tab.
Yeah, we can do.
We've got to fill in time. How long do we know? How long? That's West again. I should have made a note of what time it went down. Okay, so we have polls. Let me link to this in the chat if anyone wants to view. Okay.
It's in his community, isn't it?
Wait there. Say again? About 20 minutes ago.
Yeah.
Apparently. So if yesterday was anything to go by, it'll be another 10 here. Another 10. Right. So there are 3 polls. We have the first one. Alex Jones. Oh, Alex Jones. Okay, this is a thing, not a person. Oh,
Okay,
I see. I've got it.
All right, so
right,
we've got
event
3
of the
different
year.
ones here.
Okay, event of the year.
We added a new thing this year because there were a singular event, cunty, that was I hope that's okay, me sweary. Sorry.
Yes.
There are singular events that were cunty which you couldn't necessarily attribute to one particular person or call that person particularly a cunt for the entire year. So this is that's why we went with that. So obviously that the first one is Yi and Ferrente's interview, the one where you basically showed if you thought to be a Nazi lover. So.
That went well. Oh, they've just got a leaked thing from Scottish Feminist Network of the trans people that they're targeting.
Oh, really?
Yeah.
So if we talk about that, then where is that?
The problem is that there is somebody inside their group that is sending us screenshots. And they don't know who it is, and it's driving them nuts. Right, okay, let's do event of the year. So Alex and the Yi interview. The FIFA World Cup.
Which is the whole guitar and all that.
The fall of AAI and the disclosure document.
Yep.
And the Russian invasion of Ukraine.
Which is actually a gift that keeps giving.
It is, but the problem is keeping people interested. And they don't seem to be willing. Why does no one willing to stand up and actually want to fix it?
And then, of course, the Russian invasion of Ukraine, which whilst Putin himself is also a nominee in the World Stage division, the invasion was more than just Putin, and it's been a cunty thing that's basically been all year. So, so yeah.
Which did you vote for?
Oh, you want to know my votes for each of these?
Oh, I do, yes, very much so. And what?
I voted for Ukraine for this one. Because I didn't vote for Putin for the first one.
We'll get to that one in a minute. See, I'm very tempted to go with FIFA in the World Cup.
Yeah, that would have been my second pick, was FIFA.
Just because
that was
I've
pretty
followed
dreadful.
it.
It really was.
Yeah. The unwillingness of people to
Oh, and apparently I'm junk shopping again.
Is that my connection or yours? I can't tell. Probably mine.
Oh, who knows? You can hear me fine, so it's probably yours.
Probably. We'll know when the Scottish thing starts again and see whether they can hear that. Right, I'm going to go with FIFA. And guess what? Guess who's winning at the moment? FIFA. 67% to FIFA, 33% to Russia.
And none of the others have any votes.
Nope. Okay.
As much as I like, the fall of AI is just it's a gift that keeps giving.
Yeah. The problem I have with it is it's very local to
really
us.
vote for that. Yeah, it is. It's a local one,
And I could see that winning for that reason.
Would have we if there hadn't been these two really big issues this year.
Okay, next one. International Cunt of the Year. Vladimir Putin, Elon Musk, Matt Walsh, and J.K. Rowling.
Yeah, for her second nomination in a row. She came in second last year for the international.
Why do you think she deserves it?
Oh, because she's just more of the same this year, just being a cunt. And she's actually doubled down a lot this year with the way that she's been a cunt, because she started the whole really cunty thing of starting sending her followers after other people. And she knows she's doing that. She's deliberately picking out people, highlighting them, and basically saying, "Oh, you should go and attack this," without wording it in that fuzzy, nice way that assholes do. But she's gone out of her way to do that several times. I mean, a recent example is the quoting that she did to get Jessie Gender attacked.
Yeah.
It's like, but she's done that consistently this year. And then what? Her whole big personal wank issue with the starting a... Now, I've got nothing against starting a new women's refuge. More of them we have, the better. But she only started that to shit on trans people.
Yes.
She didn't really start it to help any.
No, it was done. It's done for publicity. I'm not convinced it will ever see anybody.
Oh, I don't even think they'll finish making it. It's a pure publicity thing. Matt Walsh was nominated mostly on his documentary, Women, or Is a Woman?
Yeah.
That was the core grounding of Matt Walsh getting his nomination there. He's not as big a name as the other people there, so he's unlikely to get the vote in the end. I'd hazard
the problem is,
even though he's more known within our community.
Elon.
Oh, the obvious. I mean, he actually is the gift that keeps giving at the moment.
I am fascinated.
Even though it's incredibly frustrating.
He seems genuinely hurt that he got booed.
Oh, well, he is. I mean, his partner left him for a trans woman, and his child transitioned. He has an absolute hate boner for anyone LGBT.
Yeah.
And he dug himself into this hole, tried to crawl out of it, and then ended up having dirt tipped on top of him. It is hilarious to watch. I leaving Twitter over it. It's like he is digging him. He's so far down in this hole that his partners who helped him buy Twitter will end up buying him out, and it's going to be ended up all owned by Arabs. You know this is what's going to happen. They've already told him to step away from it. His stupid ass poll the other day about, would you all like me to step away?
He'd already made up his mind.
His partner's already told him to.
Yeah.
like, what?
I mean, Tesla's fantastic. People are cancelling Tesla's orders over and over again.
It is amazing how much just that one little act of wasting $44 billion, that look, more money than the gross domestic product of a lot of countries, he spent buying Twitter.
Here we go. AA says the one thing that Matt Welsh has is that the right-wing Conservatives will actually watch the movie. While they get that JKR, they will never read her books because they're considered satanic.
Yes, that's true. That is true. And of course, Vladimir Putin's there because, for the same reason that the whole Russian invasion of the Ukraine is, he legitimately is a cunt.
Yes. I mean, they reckon he is actually the richest person in the world.
Really? Well, that wouldn't surprise me.
Yeah. The worst thing is you really get to a point here. None of his money's in rubles. This is the problem. You get to a point as to how do you judge wealth in terms of having access to it.
Yeah.
Because his access to it has, in a lot of respects, been cut off.
Yeah.
I actually don't know who to go for here.
I voted for J.K. Rowling, but that's because I hate the bitch.
I know.
I want to vote for Elon, but I just can't stop laughing at him.
Yeah, ignore Daisy.
The person Elon's going to hurt most is Elon. Which is brilliant. Karma. Brilliant karma.
The C1 camera. Look at that. There you go. There's a head. Oh, that's a head that's too small. What's that? The camera. Oh. No. She's too low. I need to zoom my camera out, really. No. Having none of it, are you? She currently can't walk. Because they took her for a walk yesterday. She is trying to limp on 3 legs. As in, she has 3 that aren't working.
Oh. Poor thing.
It's one of those questions where, which of these affects my day-to-day life the most? And now, it's Musk. But in the grand scheme of things, it's not going to be Musk. So I'm very divided on that one.
Yeah.
Right.
Yeah, I mean, from a day-to-day life, but as I said, my problem with it is I see the writing on the wall for Musk with this anyway.
Exactly. That's the problem.
He is going to be the person who gets hurt the most from this. We have an intermediate thing of it's a pain in the ass Twitter at the moment. But ultimately, Musk is the person who's going to get hurt most from Musk's own decisions. And he is going to end up absolutely fucked financially. And he deserves it for being a fucking idiot. I mean, his whole launch of his Tesla truck was hilarious.
Yes. I should say on stream. Hello to Paul the Potato and hello to Serenus Edmonds. We're currently waiting for the Scottish Parliament to come back to us.
Yeah, so we're talking about the Cunt of the Year Awards, which will be on Jeff's channel this year.
Yes.
So.
Right, so the Community Cunt of the Year, which lots of people may not know. We have got John Richards.
So these are people who are more tied in with our community, either through atheism or skepticism or whatever. People who have more of an attachment to us. So, so the first one on the list is John Richards, and that's because of his involvement with AI. And John's just a laugh a second, isn't he?
He is someone that keeps giving, and I can't believe he has so little self-awareness. I mean, he's an arsehole.
He doesn't. An idiot at all. It's just
he doesn't seem to give
amazing.
I see. He has made me think a lot less of Chris.
Because Chris didn't stand up to him the way he probably should.
And he got into bed with John for a while as well.
He did. Not anymore. I know things that Chris has said now about him, so...
Yes, Chris very much seems very anti-John now.
Oh, he is. And then, of course, the second... We'll save the second one on the list for probably to talk about last. Eric Hovan made the list this year. His dad made the list last year. Eric's making it
What's
this year.
Eric done that's particular?
Mostly, well, the most recent thing was all his bullshit after the defense of marriage, after the marriage equality stuff that recently came out, where, I mean, you saw what Eric was saying and he was being a dick, basically. But he's been on that route for a lot of the year, and we just thought, we got to have Hovan in there. If it's a community thing, we've got to have a Hovan. So, and Eric's the one who's... Of the two of them, Eric's the one who's really made the effort. To be fair, Eric would probably love to win it.
I was going to say, Kent's been relatively quiet. Relatively quiet.
Well, he kind of had to because he ended up in court, didn't he, for his brutalities issues. So he kind of had to shut up again. But Eric's raised his game a bit. He might even, if he keeps going the way he is, he might actually be a real contender next year. He's not going to win.
So you don't think he's got a chance this year?
He's got a chance this year.
Dr. Price?
Now, Robert Price was mostly about his absolute bigotry. He did really show his colours as did Robert Price.
See, I can't remember what he did. What did he say? He came out.
I don't remember it exactly, but it was on whose channel was it? I've got a mental blank. I am so sorry, everyone.
No,
and he wasn't my choice for this.
But he's a deserving
nomination. Oh, he's very deserving. I mean, for those who don't know, he comments a lot on mythicism. He's a mythicist. And but he was interviewed on this thing where he went down all these tropes of fucking racism to the nth degree, and yeah, he's not a nice person behind all of that, and he's just dug himself in deep ever since then. So it's like, yeah, not a nice person, but
so Matt.
I think they all pale in comparison to the last nominee, which is Matt Powell. And Matt Powell specifically got his nomination, and it wasn't me who nominated him for what he did with Bree and other people in the trans community with his lovely video on that. But he's consistently done that throughout this year towards anyone in the LGBT. It's so much even showing up comment sections where you can get them more harassment from harassing more people. The level of cuntiness that Matt Powell's lifted himself up to this year has been impressive effort on his part.
So can we assume you voted for Matt?
Yeah, I definitely voted for Matt.
Matt's the bigger cunt.
He definitely is.
Right. My issue is whether or not, it's the same problem I have with Eric being there, as to whether or not he's part of the community.
Oh, they community or community adjacent.
Uh-huh.
So it's somebody who our community it would be interacting with as well. So that works. Because although to be fair, the winner of this last year was Jimmy Snow, who is technically a part of the community. But yes, we excluded people who'd won previously from being nominated.
So who was who did they want to nominate?
Had to do better. There were two. we weren't going to use personal mention, but there was whether community come to the edge just over the whole balls with
You broke up then.
yeah. Oh, sorry. Far from my microphone.
That's not you. It's me. No, it's just breaking up continually. It's just bugging me. You're still playing.
Yeah.
Oh, good. It's not just me, says Sandy. No, it's me. I'm playing, yeah.
Let us know where we can get Sandy, and I'll try and reclaim my train of thought.
Junkshot would be proud. No, it's my internet. It's having a hissy fit.
Because you've got this window open.
Which one?
The one with Jeff's wife.
Why have we got a Detective Pikachu? Excuse me. Hopefully, we've been told we can actually get fibre here now.
Oh, that'd be nice.
So we could actually get a decent stream, which would be very, very nice. But I'm stuck.
So what have you got at the moment? Wi-Fi?
Right now, I'm over mobile.
Oh, that's sucky.
Because that's the only way. That's the only way I've been able to stream for the last 3 years. But normally it's not.
I've got
no. Normally
fibre to the node 100 megabit. I've only got 50 megabit connection. But it seems to be fast enough for what I do. So, although I believe we're being updated fibre to the curb soon. So
we are getting fibre to the house. But I'm stuck at the moment.
I want to pay for the fibre the rest.
No, we're stuck with because I need the static IP addresses for the servers, and so actually migrating over is not a simple process. Otherwise, I'd have done it about 6 weeks ago. They announced that we could have it, and I'd have done it the day it came out. I need enough fibre so that I can stream out at 4K on half a dozen streams. Then I'll be happy.
All right. It sounds like people are hearing us. Like, okay. So in this community cunt of the year thing, there was what we talked about nominating was Matt Buckley because of the whole thing with the stuff. His whole reaction to it. Not that he was wrong, but that after he'd given up the people who'd left the atheist experience shit, but going about the Matt earned all dirty little republic, and that's a pretty cunty move. So, but we decided that we wouldn't nominate him on that because it's a minor issue, really, in the scheme of being cuntiness compared to other people. And there will be an honourable mention for the International Cunt of the Year, and that's going to be Jeremy Clarkson.
But just for the last week?
The last week, pretty much, yeah. Just for the last week.
But he's a cunt all the time.
But he still doesn't get up there. He's the cunt that Elon Musk is. We started going through all of that.
No, I thought I thought it'd be about half an hour, and we've been over half an hour now. Why is that duplicating things? You were still you were Catholic? He exceeded his baseline in cuntiness somehow.
Yeah.
That doesn't surprise me. Oh, come on, Scotland. I'm worried now that... I mean, the point is, the whole point of what they're doing is to delay this. Is to try and wreck it.
Yeah. I don't think that's going to be stood for. Although if they leave it long enough, what happens as we approach Christmas?
I don't know. They're trying to get it done before Christmas.
Yeah, if they can't spend it till after Christmas. Or do they have to start it over again? Is there...
I don't know. I'm assuming you don't have... It's only between sessions that you have to restart things. So I think they can just allocate more time for it at this point.
Yeah, and it happened one time in January.
Yeah.
But they're delaying it, basically. It's all late tactics.
I mean, if you...
Because they have numbers to stop it.
No.
With numbers to make... Possibly they get through a couple of changes.
The problem is Labour seem to have supported some of those amendments. They still failed, but they only just failed. Which puts them in a difficult position. Because if one of those fails, the government, I think, would have to withdraw the bill. If one of those succeeds, some of them. But most of the really nasty stuff's gone.
Depend on the motion that got.
Yeah.
See, like, if it was a good... If motion that was possibly put up that was okay as a motion, then it probably wouldn't let it go through.
If it wouldn't wreck it, yeah. I mean, this is what...
15A, wasn't it?
15A. Trying to withdraw that. I wonder what that would mean. The final version of the bill. Review it.
So who's around in Twitter on the chat who might want to come in and talk with us?
I know. The Glasgow subway. Marshalled list of amendments, but that's not the actual bill, is it? Can I see the actual bill? (27 minutes) 30 minutes. What the hell? See, this is how bad this internet connection is right now. It says it's going to take 2 hours to download, then 45 seconds, then 7. What?
Do you want me to download it? Give me the link. I'll download it. That way your downloading isn't going to screw your thing up.
Oh, it's downloaded.
That's ridiculous. Yeah, because we lost you for a little bit whilst you were downloading that.
It's ridiculous. Right, that's the list of amendments. Are you going to see? Tell me what the actual bill says in this document. No. Yeah, Caroline said that it was buffering. Are we back?
Yeah, we're back.
I would, but I haven't been talking to fight, just a staunch no bullshit thing. I want to tell you about one idiot on the work crew who decided to take a photo of my 64-year-old ass and say to someone else, I'd tap that. Such a nice person. You can come in, and as it currently stands, we are waiting for them to come back, so you're welcome to come and tell us about an
Come in, Sandy. You may as well come and talk. Hey, look, all these non-trans women in Parliament think that they've got a...
Yeah.
I was going to say dog in this bone.
I do like that they point out here that not one trans person has got to speak out on this.
Yeah. Isn't that normally the way for a minority? Anytime any change is made for a minority rarely get...
Yeah. You're reliant upon someone else.
Yep. Which is why trans people need allies. And allies do need... don't be afraid of... talk to trans people. Find out what things that are needed. But don't be afraid of talking. Not necessarily talking over. You leave space for the trans people to talk, but don't be afraid of talking because you might to somebody. Because others need to talk.
I think that problem comes down to though is
doesn't necessarily work.
Yeah. Okay, Section 15 would destroy it. If they remove Section 15, exclude is dead.
That's why she wants to exclude it.
Registration of is amended as followed. Basically, it basically says that you can't change birth certificates. You can't. Oh, yeah. It's ridiculous.
I'll say that by moving Section 15, you wouldn't be able to change the birth certificate, which makes the whole thing
well, you wouldn't.
pointless.
Relates to insert the information, add the subsection, the information for the number of made the registrar. Yeah, it would be. That's fine. The total number. It's all reporting of a single number. In fact, no, maybe it doesn't. Maybe it's just reporting. Or is it 15 plus? No, it wouldn't. It would just make it so you can't report it. Ah, repost it. Da da da. Da da da. Da da da.
Dun, 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 dun.
Oh, I'm pleased I found the act. No, then I've got fun with things. Oh, come on. See, when Sandy comes on, I can go to Lou then, without feeling guilty about leaving you.
Don't wander off. Someone actually told me you were wandering off. I didn't realize.
Oh, the phone was ringing, and then the phone stopped ringing, and then my mobile rang. Sandy wants to be president. She doesn't. But we should make her president, is the point.
Yeah.
This meeting has been
not
suspended.
Because it's like 1:45.
I know. I was wondering. It's actually earlier than I thought.
I'm surprised I'm awake now. I've had a long day. And I haven't been particularly well most of the week, so.
We have my daughter here.
Oh, cool.
Sunday night and Monday. And
my name's...
Then we'd have the first president who's a verified felon.
Wow. Soon to be verified. I'm sure. Well,
I think the only reason that I think some of them have been verified felons. I'm just not sure they've been convicted felons.
Yeah. And there's definitely been addicts.
Yeah. Sandy, come in. Why?
Yeah, Amber's gonna need somebody else to talk to when I go to bed.
It wouldn't matter. Apparently, you can't get rid of a fucking bad president. You wouldn't be a particularly bad president.
Maybe they should instigate rules over all Republican state.
Oh.
Kind of comment that you cannot make on Twitter.
Twitter is becoming more and more.
Who was it? I was reading who got a 12-hour for saying that Ron You should stay dead.
Oh, it was Beth. She's the one in Scotland at the moment.
So how is she posting?
It was a 12-hour ban that happened last night. So, I think the ban came out of effect. She got back on just after the session started.
Yeah. I remember reading it. I couldn't remember who written it. It was like, what the hell? How do you get banned for that?
It's insane.
That's on the same level as when I got that 12-hour ban for saying we should exterminate all viruses.
Yeah.
That was an odd one. That one.
That's really
challenged that, and apparently some human looked and still thought I was in.
That's completely insane.
We just said human beings don't look at challenges.
Yeah. Oh, what are they doing? I can't believe it. I can't believe they've managed to delay this for so long now. And we're still in amendment stages.
Yeah. I don't think I'm going to be that. Get back. Might decide to call it.
The benefit of sitting in the public gallery with gender-critical activists is I can look at their reactions to the above tweet in real time. See, they're trying to get people banned as we go. They're real arseholes.
Hey, Sandy.
Go to the loo. Leave a quarter and flush it when you leave. Hi, Jen.
Hello.
How you doing?
Screwed up because I forgot to mute my other stream. I've done that now. Right. If you got an echo, I'm sorry.
That's okay. It's not, but it's fine. Right, I will be back in about 4 minutes.
You'll be back. From outer space.
Where's my logo? Let me go to my settings. If I stop cam, which isn't showing you any, I want my logo.
You got your logo? Yeah.
Right, I'm trying to find my logo. Audio avatar, edit audio avatar. Okay, so now we're going into a little tech session because Critical Cupcake had to go to the loo. Hey, Jen, how are you doing, darling?
Yeah, I'm doing all right. A bit wrapped at the moment, but I had a long day down in Albany doing shopping and stuff like that. And yeah.
We're still here.
Yeah, I'm still there.
That's good.
That's all that matters.
There's my Celtic heart.
Sometimes maybe I'm not quite all here, but that definitely I definitely have moments like that. Hey, but I'm 50 in a week and a bit, so there's always that.
Can you believe I live in such an area that, I don't go on the job sites very often, and I had to take a thumb drive over. I'm going to tell you a story about the redneck who took the picture of the 64-year-old woman's ass.
Jesus. Hey, be proud.
Age boys over there saying never gonna grow up. They're just not gonna do it. Now we've got a third accent to the mix.
Yeah.
Are y'all understanding
and
Southern
three
okay?
consonants.
Oh God. Yeah, no, I tell you what. I mean, if it wasn't so serious to the person that reported it to me, these people around here just don't grow up, especially guys on construction. We've got one.
Unfortunately, have to deal with those sort of shit. Oh, we got one in the chat.
I got them 6 find info my butt. Damn it, they showed up on these comments, on their comment stream. I wasn't fast enough to beat the bot. Oh well. Are we still live? Talk to me, Jimmy.
Wow, yeah, we're still live.
I want to know why I can't get an Asshole of the Year award.
You don't try hard enough, Sandy.
Well,
I must admit, it was a lot harder to fill those nominations this year than it was last year.
How about a special category award? Most likely to delete your channel. How about that one?
Yeah.
I can have that one, right? I think I only did it twice in 2022. I might have done it 3 times.
You probably still made more content than I did. I think I posted 3 things in this year, and there won't be anything before the. Well, no, maybe I will try and do something before the end of the year, just because. Just for the fun of it.
I hear something in the background.
Is it an amber? It is an amber.
I've just discovered that my green screen sweater is about 6 sizes too big.
It looks like it's plaid. I love it.
It's huge.
Oh, when I first saw it, when I was watching on my phone, I just thought you were a sweater.
No, this is because I'm using this. Everything was set up for Twitch. I've got slobs for Switch and OBS for YouTube. And I decided, well, I'll do it to YouTube.
So you were twitching?
Only playing a game. I wouldn't really call it twitching. I'm just trying to force myself to sit in a chair. So I stream it on Twitch in slobs. So it's just easier. It's just all integrated and goes. But none of the filters and anything work. My green screen doesn't work properly. I don't know why. It shouldn't. There's no reason. I just copied the settings from normal OBS, but all of a sudden I'm transparent, not completely see-through.
Weird.
So it's screwy. But it is what it is.
Oh, what's got posted now?
You need to know about the new the stuff on the NHS. The NHS gender exploratory therapy, or conversion therapy to normal people.
Yeah.
God, I hate the way they name that stuff. It's so dishonest.
Yeah.
Well, yeah. Because if they named it honestly, they wouldn't be allowed to do it.
Excuse me, I've got to go cuss now.
You're allowed to cuss here.
We were saying cunt earlier. You can say cuss here.
I think in terms of monetization, I'm fairly certain this stream is. I don't even know if this stream's monetized, but I'm fairly certain it's the number of cunts is far above whatever threshold they've got.
Do they have a threshold?
Yes.
I didn't know that.
Yeah, when you select, when I'm doing the single episodes, I've got to select whether or not there is brief swearing not within the first X number of seconds of the start. That's why I keep saying, I don't understand why people still don't have delays before the start of their streams. I mean, no, I didn't now, but I wasn't doing a thingy stream. But if you want to keep a stream that's going to stay up, you need to basically have nothing for the first few minutes.
Really?
Yeah, because they care about whether or not there is bad language or talking about something you shouldn't do.
At the beginning.
Yeah.
So that's how I can keep people from finding good content. All I've got to do is say something really offensive or use certain words in the first minute, and and YouTube won't promote me. Is that how I do it? Oh, good.
So in my discussion in my video about masturbation, I should have saved the orgasm for the end of the video instead of doing it at the beginning.
It's
they wouldn't have they wouldn't have stayed for the ending, so therefore he would have gotten flagged.
I mean, they're all dudes. They don't hang around. They wouldn't have lasted the 15 minutes that the video. You ever met a guy he lasted 15 minutes?
Well, yeah.
You got the time to eat the pizza.
To be fair, so have I, Sandy. I've known a couple of guys who are actually.
It was rare and
yeah, it was rare.
Rather tiring, but yeah, they exist.
How long have they been down for now? Surely they've got to pull it.
I don't know. I'll have to go through chat to find out.
Yeah, that's what I was just doing.
Been a while.
So I just understand, even as an old person, how in the hell they want to regulate.
Say again?
I don't understand. I don't understand how they want to regulate all this in the first place.
Yeah, I don't see why it has to be so. Well, I mean, given that birth certificates are illegal, are a executive procedure, you know, it's a legal thing that has to happen. Then you have to have regulations if you're going to make changes to it. But that's understandable. But it doesn't have to be difficult.
No, and I don't. And to be honest, I don't understand why gender is recorded on the birth certificate.
Oh yeah, that would be the one way to solve the whole problem. Get rid of gender markers off birth certificate.
I haven't seen.
I mean, we're losing gender markers on lots of documents now. I mean, we still have them on our driver's license in Western Australia, but you can have an X on there as well as an M or an F, so you can choose to be, not have an assignment on that. And there's a couple of other states where they don't even have a sex marker. So
it's not. I mean, driving license is the perfect example. There is just nothing relevant.
No point. There really isn't.
I mean, the situations where it's relevant should be.
Look, I can't even think of a reason why it's relevant apart from misogyny.
Driving license or elsewhere.
It's like the whole argument about trans women in sports is just misogyny on top of itself again, but it's missing the entire point that separating sport and gender is the worst way to separate sport.
Yes. And this is the problem. This is the thing. They don't seem to want to do it in ways that would be meaningful.
Yeah. Because, I mean, you want to make sport fair. Because that is their whole argument. You can't have trans women competing with cis women because it's unfair. You want to make sport fair. You don't separate by sex. You separate by the things in the individual sports that makes the most difference. So you'd be talking about height in certain sports or body build, body type, not gender per se, because gender's not
and all of a sudden,
the biggest thing.
Women end up being able to compete on a fair playing area with men that they would be considered better than them.
Yeah, because the particular physical attributes that the only reason why some men compete better. Yes, okay, there is an advantage with testosterone, but you can actually balance that out too by having a some form of handicap, and then you could make all sports way more fair and even. But nobody wants that because what they actually want is bloodthirsty competition, because that's what puts bums on seats and makes money.
Yeah.
it's purely down to bigotry why they don't want trans women competing. It's not about fairness or safety or any of that bullshit, because any of the sports where safety would matter are inherently unsafe anyway.
Yes.
Yeah,
and I don't understand
we can't have
why
trans women in rugby because people might get hurt. People get hurt in rugby anyway.
Yeah.
You dipshits. It's a contact sport. People get hurt in contact sports.
I don't know.
The
We're at this
trans women
point
who
as
were
well.
competing before did not cause more injuries.
The deception seems to be what's wrong. I'm all for. No, I'm not all for. But I'm mostly for steroid hyped sports, as long as it's honest. The honesty and fairness there is what's important. And that's where the cheating occurs. The cheating occurs with people.
So what you could do is you could have a division for people who want to shoot up steroids.
Yeah.
That would be fair.
Yes. Yep. But there's no reason. I've got no problem with someone wanting to. I mean, the reason I say that I'm not 100% for this,
apart from their own personal health.
Well, yeah, I mean, other than the fact that steroids make you nuts.
But this is my point. My point is, I don't want anyone to feel they have to do it to compete. That's my issue with it being available. Means that there is the potential for people feeling they have to, or pressure.
The whole thing is just a ridiculous situation where. And most of the that makes this whole argument about who can change their best to get even more ridiculous.
Wait there. That's what says they did an old drug Olympics on SNL. Didn't we have them in the 80s?
I'm probably going to have to head, people. I'm so sleepy, and I'm going to keep Rob awake if I stay up any later. So I should.
I thought you were in a shed.
I've had fun. No. This is the back room on the house, and that is soundproofing. But if I get too noisy, it still gets through. Some of it still gets through because the roof's not properly insulated. So I got to be careful. Still, but yeah, it's cool.
It's okay. Thank you very much for coming on.
No, it's not a shed. No, this is not a shed. This is thick pinboarding that's foam covered to add to insulation, to noise insulating. It's actually got a gap behind it so that it actually helps cut back the noise.
Yeah.
So it works pretty well.
You need to do it on the ceiling.
And it was free. No, that was hard enough to put up. I nearly killed myself doing that. Yeah. Well, woman here with bradycardia. My heart rate is typically below 40 beats per minute.
Doesn't this mean that you need? Doesn't this mean that you need to thrill yourself to get it up?
No. Because if I raise my heart rate up above 80, I feel like I've run a marathon. So it's really hard balancing act with the way my heart rate works and that to manage it.
I'm on the opposite end.
But I won't do it. So.
Yeah, I'm on the opposite end of the spectrum. I balance life for you, Jen, because my heart rate's always high.
See, my heart rate was high, and now it's stuck under fucking 50.
Are you sure you didn't have a minor heart attack like I did?
No. I'm not sure how they'd know.
Only because I had the medical records showing when it happened, and I had scans as well of my heart. So.
Do you need a scan to do it? I had a beepity beep.
Yeah, I had a CT. What? I had a CT. You know, the one they normally give you the drug to slow down your heart rate. Except I didn't need the drug because if I lie down, I can get my heart rate under 40 beats a minute. When I fall asleep, it drops to about 30.
Have you considered diving?
Diving?
That's what I'm trying to think of. One of the things. That's one of those things where you've got to slow your heart rate right down. Free diving, sorry, not diving.
Yeah, but I don't deliberately slow it down.
But could you take advantage of it being slow? Is the question. Probably not.
No, probably not, because I get exhausted because I've also got the anemia. My slow heart rate means that I'm not, my blood, I mean, I do take iron tablets, but my blood oxygen level is usually sitting around about 97 and will drop down below 95. You know that point where you start getting lightheaded?
Go!
So I've got to be really careful.
We're back.
Oh, wow. Oh, I want to know what they
I have
decided
given
before I go to
very
bed.
careful consideration to the member's request to lodge a manuscript amendment.
They're going to tell us?
As members may be aware, at this stage a manuscript amendment may be moved only with my agreement. In deciding whether to allow an amendment, I must take into account the disadvantages to other members of the lack of notice.
Is it noted?
The guidance on public bills says that agreement should not normally be given to move a
Can't hear the
manuscript
theme.
amendment which could equally
sorry, I'm
well
not
have been
transmitting it back
lodged
out to
before the
StreamYard.
deadline. While I accept that this amendment could not have been lodged before the deadline,
okay.
a manuscript amendment could equally
That's why
have
the
been
link's
lodged
in the
at
side,
any
Sandy.
time ahead of today's proceedings, after the judgment was given last Tuesday. Seeking to lodge today gives no notice to members, and on that basis, I do not intend to let it be taken. I note that we now come to a group of amendments dealing with the Equality Act, and so not allowing this amendment to be moved does not prevent members debating the issues that Ms Hamilton raises. We move to Group 13, which is point of order, Jeremy Balfour.
Thank you, Presiding Officer. It is now 4:10. Is that on? The Scottish... Presiding Officer, I'm
So
not
they're
quite
going to
sure
stop working.
I think I've got the time right. I wasn't sure that was wrong.
Midnight they went
now
till last
4:10 and 26 seconds. But the Scottish Parliament's Business Bulletin, as provided by the motion at midnight this morning, states that portfolio questions were due to commence at 3:15 p.m. This was a defined time and not the usual follow-on business, as in the case for most bulletins. We are now past 3:15, and MSPs have not been offered a chance to ask questions to Cabinet Secretary and Ministers. We've not even been told even if we will get the chance to do so. Can I remind the Chamber that the Gender Recognition Bill is not an emergency legislation, and it should not supersede all other business. Ministers being held to account by elected representatives is the bread and butter of this Parliament, and we cannot let be the sideline once again so that this bill can be rushed through before Christmas. I personally have a rural affairs question today, which I am looking forward to asking, and I would seek your clarity with regards to the business bulletin. When will portfolio questions take place? If, Presiding Officer, you do not know, will you perhaps ask business managers to meet urgently to discuss the matter, as it's important for members around the Chamber and the constituents that these questions are asked today?
This one's 6
Thanks,
years,
Mr Balfour, for his point of order. The Business
6
Bulletin
years.
does
How is this
indeed
rushed?
reflect the agreement of the cross-party
in what
parliamentary
world is
bureau.
that rushed?
We will proceed with this business at the moment, but business managers will liaise in due course and we will come back to members. We move to Group 13, which is interaction with the Equality Act 2010, the concept of sex and single-sex services. I call Amendment 54 in the name of the Cabinet Secretary, grouped with amendments as shown in the groupings. Cabinet Secretary to move Amendment 54 and speak to all amendments in the group.
Thank you, Presiding Officer. And let me just begin by addressing some of the points raised by Rachel Hamilton, because they are relevant to this group. Let me first of all say the ruling, for absolute clarity, made absolutely clear that the Scottish Parliament cannot modify the Equality Act. As I've previously set out to Parliament, we welcome the outcome of the petition of Forum in Scotland Limited for judicial review, which is that the Scottish Government's statutory guidance on the gender representation on public boards Scotland Act 2018 has been held to be lawful and the petition dismissed. But as this Chamber is aware, these remain live proceedings with the possibility of an appeal, and I won't therefore comment in detail. But what I will say is our position has always been consistent with that of the Equality and Human Rights Commission, on this matter. And as I set out at stage 2 of the bill, that for the purposes of the Equality Act 2010, sex does take into account the legal effect of a GRC obtained in accordance with the Gender Recognition Act 2004. Nothing has changed in this ruling. It is the status quo as was the case before. Yes.
Rachel Hamilton.
Thank you, Presiding Officer. I was clearly disappointed that my manuscript amendment wasn't accepted, but understand the Presiding Officer's view. I want to ask the Cabinet Secretary if a gender recognition certificate, which now confers on you at least some of the protections afforded by the Equality Act, and given that I wasn't allowed to debate the implications of my potential manuscript amendment, can the Cabinet Secretary confirm what protections for women are granted to those with GRCs and which protections are not under the Equality Act?
Cabinet Secretary.
Well, as I said at the beginning, the ruling has made absolutely clear that the Scottish Parliament cannot modify the Equality Acts. Therefore, there are no changes whatsoever to any of the protections under the Equality Act. They remain the same. Lady Haldane was absolutely clear about this. The bill does not amend the legal effects of obtaining a gender recognition certificate, which are set out principally in Section 9 of the 2004 Act. Therefore, the judicial review ruling does not impact on the bill. I want to go on to the rest of the amendments in this group. Following discussions, I've answered your point. Yes, I will. Yes.
Michelle Thompson.
The Cabinet, I thank the Cabinet Secretary for giving way. Now, Roddy Dunlop KC makes the case that this matter doesn't grant or lose people rights, and I don't disagree with his eminent view. However, it does clearly introduce considerable complexity on existing rights, and the practical function and effect, particularly on women, has consistently been ignored, and I'm sure that element of it will subsequently
No, it hasn't
be
been ignored.
legally
It's been discussed
tested.
at length.
Does the Cabinet Secretary agree with that?
Cabinet Secretary.
Well, what I would say to Michelle Thompson is that the case has maintained the status quo that has been the position since 2004, so 20 years, that the purpose and effect of a gender recognition certificate is to be able to change your birth certificate in line with the acquired gender. That is the purpose and effect of a GRC. This bill changes none of that, and we couldn't change the Equality Act even if we wanted to. That is just not possible. I want to move on to the rest of the amendments because there are a lot of amendments I want to comment on. Following discussions with members, I have lodged Amendment 54 in my name, which places a duty on Scottish ministers to publish guidance on the operation of the Act. This was an ask of members, which I'm happy to provide for, and the amendments says that we will do this in consultation with human rights organisations. And as I've also made clear to members, this amendment is within the legislative competence of this Parliament. Before I speak to the other amendments in this group, I do want to remind members that responsibility for the Equality Act is reserved to the UK Parliament, just as immigration and nationality, including asylum, is reserved, as we debated in Group 3. So, to be clear, as I said earlier, any amendment agreed to today, which may be out with competence, puts the aims of the bill as a whole at risk. And while some people, while some people may oppose this bill, every member in this chamber has not just a responsibility but a duty to make competent law, and I know that every member takes their role as a legislator for our country seriously. I'll give way. Yes.
Daniel Johnson.
I'm very grateful to the Cabinet Secretary for giving way, and she's quite correct that obviously any bit of legislation that sought to alter the impact or effect of reserved legislation would not be competent. However, this Parliament does regularly legislate using definitions defined in reserved law. So, such as the point in 2016 when we altered the franchise of this Parliament, we made an explicit reference to the Immigration Act of 1975, and indeed we've done so on a number of other occasions. We're not altering the definitions or the things that are specified in that law, but we use the definitions and clarify how this Parliament and how our legislation seeks to use them. That doesn't put our laws in breach, it doesn't call into question, it doesn't fall foul of the Scotland Act. So if we do it in those legislative circumstances, why can't we do it in this one?
Cabinet Secretary.
Well, I'll come on to that point in my remarks, if you don't mind. The bill already provides the reassurance that members sought that this does not modify the Equality Act. And this was done through a Stage 2 amendment that we agreed with Pam Duncan-Glancy and which covers the Equality Act in its entirety. Not just now. To pick the Equality Act apart by stating further that the bill does not modify some provisions of that Act when there is already patently provision in the bill that it does not modify the whole of the Equality Act causes confusion within the law. Provisions that do that now on top of Ms Duncan-Glancy's amendment I think are unnecessary and unhelpful. In addition, it's for, and this is really important, it's for the Equality and Human Rights Commission as a reserved body in terms of its statutory functions to provide guidance on the effects of the Equality Act 2010, and it's for Scottish ministers or the Registrar-General to provide guidance on the effects or operation of the bill. Therefore, I cannot support any amendments in this group apart from my own for those reasons. Yes.
Stephen Kerr. Stephen Kerr.
Apologies, Presiding Officer. So I'm just anxious to know, before we vote on any of the amendments that are in this section, I'm quite anxious to know, I think in very clear terms, will the Cabinet Secretary confirm that someone who is issued with a GRC would have access to single-sex spaces? Can we just have a very clear answer about the implications?
Cabinet Secretary.
Not if the organisation providing those services use the exceptions under the 2010 Act. They could be excluded, as I have said so many times in this chamber. Nothing changes. So if an organisation had a service that they wanted to restrict to being single-sex, then they could do that in the same way as they can do now. This bill changes none of that whatsoever, and I hope that gives members the reassurance that they require. There are a few amendments in this group on guidance. Amendment 111 in the name of Jackie Baillie would place a duty on Scottish ministers to issue guidance on the impact of this Act, and in particular on the provision of single-sex services and what would be considered a proportionate means of achieving a legitimate aim in that context. And that refers to particular sections of the Equality Act. Amendment 120 in the name of Rachel Hamilton and Amendments 73 and 74 in the name of Sue Webber are similar. Amendment 117 in the name of Polly McNeill would place a duty on Scottish ministers to provide guidance on the effect of having a GRC, in particular to set out how obtaining one impacts on the rights in the Equality Act. And her Amendment 129 places a duty on Scottish ministers to consult each Scottish public authority regarding the operation of the exceptions in Schedule 3 of the Equality Act. And Amendments 118 and 119 in the name of Claire Baker would place a duty on Scottish ministers to issue guidance on the impact of the bill on Section 22 of the 2004 Gender Recognition Act and Schedule 9 of the Equality Act. The Scottish Government cannot provide legal advice to external bodies. Guidance on the test of a proportionate means of achieving a legitimate aim, as required in the Equality Act, is for the Equality and Human Rights Commission. The Scottish Government will always promote and encourage observance of the Equality Act, but it is properly for the EHRC, not the Scottish Government, to provide guidance on the effects of the Equality Act. I'll take Claire Baker.
Claire Baker. Can we have Claire Baker's microphone, please? Bear with us a moment, Ms Baker. Ms Baker, can I ask you just to remove your card and replace it? Thank you.
Thank you, Cabinet Secretary. In a briefing in advance of Stage 2, the EHRC said that in relation to the UK and the Scottish Government, that they must provide and ensure clarity for employers and service providers on the law. This would suggest that the EHRC do think there's a role for governments to provide clarity on this.
Yeah, but what the HRC also know that in terms of the operation of the Equality Act, it is for them to lead. What I have set out is in terms of the guidance of the operation of this bill, which of course has a role for us as ministers. What we said about the Equality Act, however, to go further and to maybe address some of Claire Baker's concerns, is that if they want to revise the guidance in the light of this bill, or this act, should it pass, then we would work with them in doing that. But we've got to respect them as the lead organisation for matters that impact on the Equality Act. Now, the EHRC provides guidance already for individuals, organisations and the public sector, as well as a statutory code of practice, which assists service providers with understanding the relevant issues. And this includes already published guidance for service providers looking to establish and operate a separate or single-sex service. Yes.
Pam Duncan-Glancy.
I thank the Cabinet Secretary for taking an intervention, and I understand the statutory responsibilities that the EHRC have over the Equality Act. But I wonder if she'd accept that, for example, in a letter recently from Minister Kevin Stewart to health boards, there was recognition that protocols would need to be in place to support people, trans people and others, in order to be able to provide services. On that basis, surely the Cabinet Secretary can accept that it is acceptable for the Scottish Government to direct devolved bodies on how to provide services and organisations how to deliver services to, on the basis of any piece of legislation.
Well, as I've just said, the guidance on the operation of this bill is absolutely for us to set out. And I've already acknowledged and accepted that we will do that. But that's different from the operation of the Equality Act, which has the lead of the EHRC in statute. They're the statutory body. So we can't lead on that. They have to lead on that. What I have said, though, is that we'll work with them on doing that. But they have to be the lead body. I can't be any clearer than that. And I agree that it is important for clear guidance to help people and organisations understand their own rights and responsibilities as set out in the Equality Act, which is why, as I've just said, I've said to the HRC that I'd be happy to work with them should their guidance require to be updated following the bill. And we will highlight where additional guidance would be helpful, and I'll repeat that commitment now. Amendment 112 in the name of Ash Regan specifies that nothing in the Act affects any provision to which Section 9(3) of the Gender Recognition 2004 applies. As we have set out on a number of occasions, the bill does not amend the effect of a GRC as provided for principally in Section 9 of the 2004 Act, and therefore I cannot support an amendment which says the bill does not amend a section it obviously does not amend. I also don't support her Amendment 113, which specifies that nothing in this Act affects specific sections of the Equality Act, nor do I support the similar Amendment 130 in the name of Jackie Bailey, which specifies that nothing in this Act prevents the provision of a service only to persons of one sex under Schedule 3 of the 2010 Act, modifies the protected characteristic of gender assignment, or modifies the definitions of sex, man, woman in the 2010 Act. Amendment 133 in the name of Jamie Green places a duty on Scottish ministers to publish a report no later than 3 years after the Act has come into force on a review of the impact of this Act on the Equality Act. This is important. As I've already said, the bill as amended already states, for the avoidance of doubt, that this bill does not modify the Equality Act in its entirety in any way, and to pick the Equality Act apart in this way causes confusion within the law, particularly when there is already provision added to the bill at stage 2 that, for the avoidance of doubt, it does not modify the 2010 Act. Yes.
Liam Kerr.
I'm genuinely grateful, and I'm genuinely struggling, Cabinet Secretary, so I wonder if you can make this very clear for me. What I'm struggling to understand, if obtaining a GRC under the Haldane judgment means that a man with a GRC is a woman, then what is the legal basis, going back to Stephen Kerr's intervention, for excluding that category of person from a single-sex space?
Cabinet Secretary.
Trans women can be excluded from a single-sex space. That is in the Equality Act as an exception, and nothing has changed with this bill whatsoever. As I said, the judgment is entirely in line with the position of the Equality and Human Rights Commission, literally the body that oversees the Equality Act. Our position is exactly the same as theirs. Well, very briefly.
Ash Regan.
I thank the Cabinet Secretary for taking intervention. I do think this is a very important point that we need to be allowed to debate. So the government's position, as I understand it, which I happen to not agree with, but the government position is that exemptions are still operable. So I'd like to know what assessment the government has done on the chilling effect on what could often be quite small single-sex service providers.
Cabinet Secretary.
Well, I don't believe that that will be the case in terms of a chilling effect. But in recognition of any concerns, what I have said is that in terms of the guidance of the operation of this bill, that we will set out that guidance, but it is for the Equality and Human Rights Commission to set out the guidance to public bodies to make sure that when they are applying those exceptions, and it has to be on a proportionate basis, that they are doing so and keeping themselves on the right side of the law. That is very clear. The guidance, I think, is very clear, but if it has to be reviewed, if the HRC thinks it has to be reviewed, that is a matter for them, and we will assist them with that. I'm going to make some progress, if you don't mind. I don't support
Members, sorry, Cabinet Secretary. I think it's fair to say that members have been very good so far in listening to one another, and I'd like us to continue with that. Cabinet Secretary.
Thanks. I don't support Amendment 121 in the name of Rachel Hamilton, which would place a duty on Scottish ministers to report on the impact of the bill on the provision of single-sex services every year. I don't think that is disproportionate reporting requirement. I don't support Amendment 61 in the name of Pam Gosal, which would place a duty on ministers to report on the impact of the bill on self-exclusion from services. Exceptions in the Equality Act enable single-sex services to exclude trans people or treat them less favourably where it is a proportionate means of achieving a legitimate aim. Those exceptions apply whether the person has a GRC or not, and this bill does not change that. There is no impact to measure from the bill, and any self-exclusion that does occur is more likely to be caused by misinformation and concerns. Amendment 123 in the name of Pam Gosal would place a duty on Scottish ministers to report on the impact of this Act on the funding of single-sex services. It's not clear to me what the funding of such services has to do with the bill about applying for legal gender recognition, and I see no possible impact and therefore can't support such an amendment. Amendment 128 in the name of Polly McNeill, and I'll let Polly McNeill in a minute. In the name of Polly McNeill is an avoidance of doubt provision that nothing in this Act affects any requirement to collect data on sex as defined in Section 11 of the 2010 Act. I don't believe this amendment adds value for the reasons that I have explained on the other amendments, and therefore I won't be supporting it. But I'm happy to take an intervention from Polly McNeill.
Thank you, Cabinet Secretary. It was following on from Ashley Adams' intervention where you answered that the exemptions can be used, and that is of course correct. But I wondered if the Cabinet Secretary might want to offer an opinion then as to why rape crisis centres, for example, who have tried to use the exclusions, have experienced a great deal of resistance to this. Many organisations who have tried to use the exemptions, which are lawful, don't seem to be able to use them, and I wonder if that gives the Cabinet Secretary cause for concern.
The majority of
exemptions, if all of this boils down to, well, in any case, you can exclude anyone, but incidentally,
the rape crisis centres,
you can't
not one of them, apart from the ones
trans
that have been
status,
started by
make it a bit difficult.
Who is harassing
anyway,
rape crisis
on
centres
that
right
point,
now?
surely she must know
that
loads of organisations are really the end of the tether because they're trying to use the exemptions
in place.
and they're
They
not
don't
able
need to exclude.
And
yet they are being harassed on a daily basis. The Samaritans have been harassed. They've gone through weeks of harassment now from gender-critical people because they won't exclude.
As long as their policy is within the law and follows the guidance and is proportionate. We can't dictate to each organisation what their policy is. They have to follow the guidance and they have to keep themselves on the right side of the law. I want to turn finally and importantly to Amendment 127 in the name of Jackie Bailey, which provides that paragraph 28 of Schedule 3 of the 2010 Act on exceptions from gender reassignment discrimination continues to apply to activity or conduct carried out in Scotland, even where an individual holds a Scottish GRC. Now, members asked me yesterday about the degree of risk of amendments, and I think, to be clear, this would be at the top of the risk to the bill list for reasons that I'll come on to. It is trying to clarify the effect of reserved legislation, and we can't do that in a devolved bill. Let me just say a little bit more, because this is important. Whatever the intention of that amendment, and I'm sure it's well intended, in legal form the provision would legislate to continue the effect of reserved provisions of the Equality Act. And we believe the amendment is at serious risk of being out with legislative competence. The amendment specifies circumstances where paragraph 28 of Schedule 3 of the Equality Act on gender reassignment discrimination applies, stating that it continues to have effect where a person holds a GRC. That is consistent with our understanding of the effect of the Equality Act, but that Act makes no mention of GRCs. This amendment purports to clarify paragraph 28, which is reserved law, and so there is a serious risk of the amendment being out with competence. This amendment is different in its effect from the provision already in the bill, and this might be Daniel Johnson's point, which states that the bill does not modify the Equality Act. That provision states plainly that this bill does not modify the Equality Act, whereas this Amendment 127 seeks to clarify what the Act does. Now, I hope members will remember that the disputed section of the Gender Representation on Public Boards Scotland Act 2018 was found in the first judicial review on appeal to have impinged upon equal opportunities as a reserved matter. Very briefly.
Daniel Johnson.
So again, I'm grateful to the Cabinet Secretary for doing it. So explicitly why I was giving the example that I did, because it actually confers rights upon individuals based on the status defined in law. So in very much the same way, borrows on a definition in reserved law in terms of functions being legislated by this, which is similar to this. So I again, don't understand why this legislation falls foul of that, but previous legislation does not.
Well, there has been previous legislation which has been in the same bracket, and I understand that ministers at the time of the Land Reform Bill, for example, had to write to members on the same basis. The difference, as I've just set out, was the provision already in the bill, which I know some members have said, so if we were able to put for the avoidance of doubt at stage 2, what is the difference? Well, the difference is that the provision already in the bill states that the bill does not modify the Equality Act, but that provision states plainly that this bill does not modify the Equality Act, whereas, as I said earlier, this amendment seeks to clarify what that Act does. Now, I would like to re-emphasise a point that some members mentioned yesterday, and that is if a provision of the bill, as passed, is subject to legal challenge, it is absolutely not the case that the rest of the bill can proceed meanwhile. The entire bill would be referred and therefore delayed and put at risk, and I have to be clear with members about that. So I hope that those who support this bill, a point I made yesterday as well, there will be some members in this chamber who don't support this bill, and therefore it will not be of concern to them. But I know for members who do support this bill and don't want a delay, we should not be putting barriers in the way, and we should not be putting this bill at serious legal risk. So I would urge members to support my Amendment 54, not to support the other amendments in this group, particularly 127, for all the reasons that I have set out.
Thank you. I call Jackie Bailey to speak to Amendment 111 and other amendments in the group.
Thank you very much, Presiding Officer, and can I apologise to the Chamber in advance for the length of my contribution, but there are substantial issues to consider. There are 3 amendments that I have lodged in relation to the protections that exist in the Equality Act.
Saying on Twitter,
Amendment
I think we're due another stunt from the
Amendment
Scottish Feminist Network
127 and Amendment 111. When Scottish Labour supported the bill at stage 1, we were clear that significant improvements were needed if it was to respond to concerns expressed, in particular by many women's groups and individual women, in order to have public confidence. At every stage, we've sought to work with others to deliver these changes, and we continue to do so this afternoon at stage 3. Now, at stage 2, Scottish Labour was successful in placing reference to the Equality Act on the face of the bill, and that was supported by the Scottish Government. But they didn't go far enough and rejected an amendment from Faisal Chowdhury and continue to reject amendments today. We recognised that concerns remain, not least following the intervention of the UN Rapporteur on eliminating violence against women and girls, who said that amending the application process for a GRC makes upholding the protections for women and girls in the Equality Act very important. Hence the amendments before you today. Now, Labour is proud to have passed the Equality Act in 2010. As reserved legislation, we know that it cannot be changed by this Parliament, but we believe it is important that service providers and public bodies have clarity about their legal obligations under the 2010 Act and this legislation. For that reason, to provide clarity and reassurance, I have lodged a number of amendments, taking first Amendment 130. This amendment references the exceptions within the Equality Act that allow for the provision of single-sex spaces and services and makes clear that they continue to apply. It states plainly that nothing in this new legislation changes or modifies the exceptions that exist in the Equality Act under Schedule 3 or modifies the definitions in the Equality Act for both the protected characteristics of sex and of gender reassignment. It repeats exactly the language in the Equality Act, nothing more, nothing less. And the purpose is to emphasise the primacy of the Equality Act of 2010, ensuring single-sex spaces are protected where it is necessary to do so. Now, I know that there have been concerns that providers are not clear on the legal position with the use of these exceptions, or that these exceptions have been used appropriately. What this amendment therefore does is clarify that despite any changes brought about by this bill, service providers can continue to offer single-sex services in accordance with the legal test in paragraph 28 of Schedule 3, and by doing so, those tests are met. They can also exclude trans people from these services in certain circumstances. Subsection 2 of the Amendment 130 also states that this bill would do nothing to change the Equality Act definition of gender reassignment, which does not require a GRC. The effect of this subsection is to emphasise that it continues to be a defence to the charge of gender reassignment discrimination, that a person was excluded from a single-sex service where it was done in accordance with the tests set out in the Equality Act. Now, my understanding is that Lord Haldon made clear in her judgment that sex and gender reassignment are distinct and separate protected characteristics, even if not mutually exclusive. So should a trans woman be excluded from a single-sex service on the basis of her gender reassignment, the exception in paragraph 28 would apply to allow for this to be permissible. And I see that the Cabinet Secretary is nodding. I'm happy to take an intervention.
Stephen Kerr.
Does Jackie Bailey agree with Lord McConnell, who at the weekend wrote, if I might quote from his words, "There are really serious concerns about safe spaces for women, especially those facing and dealing with the trauma of abuse, violence and rape," has been highlighted in the debate. And picking up on the point that was made earlier, the chilling effect of what happens when there is an attempt to apply these exceptions for any organisation is a very real thing.
Jackie Bailey.
Can I thank the member for the intervention? That's exactly why we're bringing forward these amendments today, and I hope that he and his party will support them, because Amendment 130 is intended to put beyond doubt that this continues to be the case in Scotland. And I am aware that the Scottish Government's rationale for opposing amendments that pull out specific sections of the Equality Act is that it somehow weakens the bill. And I genuinely don't get it. The Government, I don't believe, has convincingly set out how changing the procedure for applying for a GRC is weakened simply by noting that existing reserved legislation remains unchanged. Amendment 130 and my... give me 1 second. Amendment 130 and my other amendments are carefully worded so that they do not interpret the Equality Act. They merely reference the relevant sections, literally word for word. I give way to the Cabinet Secretary.
Cabinet Secretary.
As we passed the amendment at stage 2, which of course was done jointly with Pam Duncan Glancy, it was to put beyond doubt, for the avoidance of doubt, that Nothing in the Equality Act was changed by this bill. Does Jackie Baillie not acknowledge that by then picking out parts of the Equality Act beyond that catch-all just leads to not just confusion, but actually could lead to legal misunderstandings, interpretation, which could be really unhelpful in terms of this bill?
Jackie Baillie. I think my Amendment 130 has exactly the opposite effect. It is about spelling out clearly an area of concern that has been raised with members across this Parliament, and that's why it's so important. Let me turn to, if I could make some progress, please. Right. Let me turn to Amendment 127, which seems to have caused much controversy. This amendment makes clear that the exception in the Equality Act, which allows for the exclusion of trans people from single-sex spaces, continues to apply as before, even if someone obtains a GRC under the new application process set out in the bill. The Cabinet Secretary actually stated exactly the same thing last week in the Chamber, almost word for word, when responding to an urgent question. So my intention in lodging this amendment is to give clarity and reassurance to service providers that they can continue to make use of this exception where appropriate to do so and where the necessary legal tests are met, as set out in the Equality Act. The Scottish Government, allow me to make some progress, the Scottish Government have suggested that this amendment may be trying to interpret the Equality Act, but again, it is carefully drafted so that it references exactly the exception in the Equality Act, does not add or take away from it. There was Ruth Maguire.
Ruth Maguire.
I thank Jackie Baillie for taking the intervention. You mentioned service providers and the importance of them knowing the law. Would you agree that it's also important that funders know what service providers are and aren't allowed to provide?
Jackie Baillie. I absolutely agree. It's not just service providers, it's funders. It is also the general public having an awareness of what this all means. So I welcome that intervention. Now, the Scottish Government are saying that by accepting this amendment, the bill is at risk. And I genuinely do not find that argument persuasive. I don't want to do anything that risks this bill. But we know that the government itself have experience of this through the UNCRC fiasco, when amendments that they were warned about but pushed through led to a Supreme Court referral. We know that the Cabinet Secretary met the other day with the UK Minister for Women and Equalities to discuss this bill. I'm not sure of the content of the conversation, but it would be helpful to the Chamber if she could confirm whether there was a discussion that centred at all or even touched on the amendments raised in her letter the other day. Because if passing this amendment was as serious as described, surely it would have been discussed. I will indeed.
Rachel Hamilton. I thank Jackie Baillie for taking the intervention. Surely at this point, I'm trying to work out whether Jackie Baillie is trying to argue that Labour's original amendment at stage 2, which it was in the name of Pam Duncan-Glancy, which said, for the avoidance of doubt, nothing in the Act modifies the Equality Act 2010. Now, bear with me, because how can that solve the issues that relate to the interaction between the Gender Recognition Act and the Equality Act? And I hope that's my understanding of what argument you're trying to make, because it simply says that things will stay the same, but they're not, because of Lady Haldane's court ruling.
Our additional amendments are absolutely recognising the court ruling, but actually leaning into what is already in the Equality Act. So if you wish to protect single-sex spaces, if you wish to exclude, those provisions are already there. Lady Haldane's judgment does not change that at all. And that's why Amendment 130 is just so important. Let me go back to trying to conclude this, Presiding Officer, because I've got a lot more to say. But I genuinely don't accept, with the greatest respect, that Amendment 127 would put this bill at risk. It's not adding or interpreting the Equality Act. It merely states that paragraph 28 of Schedule 3 of the Equality Act 2010 continues to apply to activity or conduct carried out in Scotland, even in circumstances where an individual holds a gender recognition certificate obtained under the Gender Recognition Act of 2004 or a confirmatory gender recognition certificate obtained under Section 801 of that Act, so i.e. a Scottish GRC under these new application processes. The salient phrase in the amendment being continues to apply. To say it does more is disingenuous, and the evidence for this is that the same argument is not being applied to Amendments 130 and 111. Now, I know the Scottish Government don't like Amendments 130 and 111, but they haven't written to me saying that they would risk the bill. Now, Presiding Officer, you know I'm a reasonable person. Amendment 130 and 111 don't appear to cause the government the same problems. They weren't mentioned in their letter, and therefore I would consider withdrawing Amendment 127 if they would be willing to accept 130 and 111. Would they, I would genuinely be willing to give way to the Cabinet Secretary just now if she wants to indicate her support for Amendment 130 and 111.
Cabinet Secretary.
I can't do that for all the reasons that I've set out already, that the Equality Act, for the avoidance of doubt amendment, that nothing changes, is clean, clear. To start unpicking any piece of legislation and to select parts of it into another bill is not clear and is not helpful. But what I can say is that she's right insofar as the list of risks to the bill 127 is up there for all of the reasons that I have stated and have made clear. And it's not the case that 127 just reflects the wording of the Equality Act. The Equality Act does not refer to a GRC. So Jackie Baillie is just not correct on that. And I hope she does decide not to move 127 for those reasons.
Jackie Baillie. I think that was quite a long intervention, but my assessment of what the Cabinet Secretary said is that she has a preference for 130, and I hope the Chamber will listen to her on that and support it. But finally, let me turn to Amendment 111. This amendment requires the Scottish Government to produce guidance on the application of the legislation for devolved service providers and public bodies. The wording of this amendment matches closely the amendments on guidance which the Government itself has lodged after my discussion with them. The difference is that my amendment makes clear that this guidance should include the provision of single-sex spaces and the circumstances in which you can exclude, again, lifted from the Equality Act. So if the Cabinet Secretary wants to give me an assurance on the record that her amendment would cover this, then I would absolutely reflect on that. But I didn't hear that in her opening statement. Throughout the passage of the Gender Recognition Reform Bill, we have repeatedly warned the Scottish Government of the dangers of allowing a policy vacuum to develop because it leads to uncertainty for service users and for service providers in Scotland. These warnings have largely been ignored, and we can see many different organisations attempting to navigate a path through the interaction of these acts, trying to respect everyone's rights and protections. But the silence from the Government is not appropriate, and many groups have spoken to us about the dangers of differing interpretation of the legislation. With Amendment 111, we're making it clear that it is the Scottish Government's responsibility to provide clarity by setting out clear guidelines for the operation of this legislation with regard to the 2004 Act and the Equality Act of 2010. We believe that service providers' responsibilities will be made clearer and easier to implement. Now, the Scottish Government have suggested, and they've done it again today, that it's not within their remit to produce this guidance. It is the job of others, and they will work with them. That's great. But I reject that assertion that they don't have any remit to do this. The amendment is drafted so that this guidance does not need to be statutory. It's already the case that this government have provided guidance to schools, to Scottish health boards. In fact, Scottish health boards have themselves issued a variety of guidance covering some of these issues. If that is possible, then it's completely within the Scottish Government's remit to publish guidance for devolved bodies, and I would argue that it would in fact be preferable.
Graham Simpson.
I thank Jackie Baillie for taking the intervention. I've listened very carefully to her, as I always do. It sounds like these very sensible-sounding amendments in this group are pretty fundamental to Labour's case. So if these amendments don't pass, particularly 130, will Labour not be supporting this bill?
Jackie Baillie.
I absolutely welcome the intervention from Graham Simpson, but, you know, I want to see these amendments passed. I hope everybody across this chamber listens to the very reasonable, proportionate arguments made and passes these amendments. And you can wait to stage 3 to find out what we do as a consequence of that. But I am confident that these amendments are competent. They will help to highlight that whilst this legislation simplifies the process of obtaining a GRC, which is absolutely welcome, the rights of women, girls and trans people continue to be protected by equality legislation, and that public authorities in Scotland will finally have clarity on the actions that they should take to ensure everyone's rights and obligations are upheld. Presiding Officer, in bringing my remarks to a close, let me be clear on 3 things. Amendment 127 and indeed Amendments 130 and 111 do not reinterpret the Equality Act. They state that it continues to apply in Scotland. That is a fact. The Scottish Government do not seem to have the same concerns about Amendment 130 and 111, so I would consider withdrawing Amendment 127 if they could find their way to supporting the other amendments and make that clear. Unfortunately, they haven't done so. So I would encourage members to think about this, because these amendments directly address the concerns of women and women's organisations while still protecting the rights of trans people seeking a gender recognition certificate. They deliver, word for word, the Equality Act provisions. They seek the practical provision of guidance where it would be a genuine dereliction of duty to leave a vacuum. They respond to the UN Rapporteur on eliminating violence for women and children's concerns, and I specifically asked if she would be reassured by these amendments, and she said yes. We have responsibility as parliamentarians to ensure that we pass the best possible legislation. If we're serious about giving single-sex spaces protection, whilst protecting the integrity of the bill, this is the opportunity to do so.
Thank you. I now call Ash Regan to speak to Amendment 112 and other amendments in the group.
Thank you, Presiding Officer. And just for the Chamber's information, I don't intend to to move 112, but I will move 113. So one of the roles of a government is obviously to protect its people. And the current GRA regime, as we all know, was put into place to ensure that legal recognition, to reflect that. And trans people are protected, rightly so, under the Equality Act provision on gender reassignment. So the existing regime is fully compliant with human rights law. And a recent High Court judicial review in Northern Ireland ruled that the GRA regime strikes a fair balance between the needs of the applicant and the community as a whole. The bill before us today, in my view, does not strike that balance. It does not protect the rights of everyone. Instead, it introduces a hierarchy of rights where women's rights are demoted. And I say that not to be provocative or to be unnecessarily controversial, but because that is the only conclusion that can be drawn from a review of the interactions between these 2 pieces of legislation, I think demonstrated by the quite long debate we've had on that point prior to this. And the Court of Session ruling last week, in my view, has now put this beyond doubt. Self-ID does grant new rights, as it will grant a GRC to almost anyone who wants one. And this is not just an administrative change. This is not just a change in process that has no real-world effect. There are currently around 600 GRC holders in Scotland, which, is quite a small number, and the government expects this to increase tenfold to 6,000. This will grant somewhere in the region of, although we're not entirely sure, 5,000 or more people who are, and the most important point about this, not currently eligible for a GRC, and also the rights that are conferred by it. Now, these people may well be trans. However, my strong contention is that not all of them will be. I'll give way.
Maggie Chapman.
I thank the member for giving way. When she says that the people, the 5,000, over 5,000 people are not currently eligible, does she accept that actually there will be people in that group that are eligible but have chosen not to go through the process because it is demeaning and humiliating?
Ash Regan. Excuse me, Ms Regan. I appreciate that there's great interest and that those observing from the gallery are very interested in the proceedings, but it is the case that we would ask that members are not applauded from the gallery. Thank you. Ms Regan.
Actually, I do accept that point. There probably will be some, probably a small number, who've maybe chosen for, whatever reason that they don't want to apply for a GRC. But I still think the general contention is fair, that this opens the process up to a vast number of people who would not currently be eligible under the normal scheme with the safeguarding that I think that entails. And I also take issue with the point that the member raises, that all trans people think that the current process is intrusive or degrading in some way. That is not, I'm sure some people do feel like that, but that is not how some trans people have described it to me. And one GRC holder said to me that she was completely happy with the process and indeed felt that the longer process was entirely appropriate considering the profundity of the change that was being undertaken. So, if we are saying that we think that some of the people that are applying for GRC may not be trans, we're not going to be able to tell. And we've had a debate on that already about how we would be able to tell if there were some fraudulent applications or not. And this now creates a situation where members of a dominant group in society can now self-identify into the rights of an oppressed group. And this is absolutely unprecedented. Now, my amendments in this group won't resolve this problem. And they won't put this beyond legal doubt, I don't think. I tried to lodge a number of other amendments, and I was advised by the Parliament that amendments that altered the effect of a GRC were inadmissible, and we've had some debate on that already. But I think that as the group of people that can now access the GRC is so expanded, and that I think we're all admitting that it may be open to being abused, that in not allowing this Parliament to make changes to the effect of a GRC, that we are now being asked to legislate in such a way that I don't think can possibly lead to good law. And therefore, it's my strong belief that many of the amendments that we are discussing today will not materially alter the issues that we are all facing. And I also contend that despite the information that's been presented to the committee, that states' obligation to protect vulnerable rights holders was not given enough consideration. And that is, of course, a contention that has been backed up by Reem Al-Salem, the UN Special Rapporteur on Violence Against Women. And it's claimed that the impact on women and girls had been assessed and that there was no impact. And I strongly disagree with that. I have searched and I cannot find the analysis that addresses and evaluates the impact from the context of women and girls as vulnerable rights holders. And that is consistent with other jurisdictions where the data on the impact on women is not being collected. In Ireland, when self-ID law was being reviewed, the impact on women was considered to be out of scope. But if you don't collect the data, you will not be able to assess the impact. And on that basis alone, I believe we should not be proceeding. There are many examples around the world of violent and sex offenders in women's prisons, now, of course, including here in Scotland. Examples of flashing and voyeurism in women's single-sex spaces, and women self-excluding from services in places where self-identification into women's single-sex spaces has introduced. And I assert that for those who are looking, the impact is there to see. And women's single-sex spaces are important. And the issue is whether, of course, people are male and not whether they are trans. Male people, as a group, are a risk to women. I see the Greens are sighing at that reference.
How is that relevant?
But male people, as a group, are a risk to women, and I think we all accept that. So the ability to exclude people of the opposite sex, if they hold a GRC, I think will now be impossible on grounds of sex. And inevitably, making use of these exemptions will be much more complicated.
It isn't.
And it will be much more off-putting to organisations, many of which are quite small, some are charities and so on. So this bill may not spell it out, but I believe that we shouldn't delude ourselves. It comprehensively undermines the single-sex exemptions. And we're being conditioned to accept male-bodied people in women's single-sex spaces. Why? Who does that benefit? And I would say to my fellow parliamentarians that it boils down to this. Do you think women will be more or less safe as a result of this law? And if you have any doubt at all, that it will make women and girls less safe, then you cannot vote for it.
We will suspend for a moment.
Right, so trans people...
I would just remind...
So trans people just clapping someone making a comment is fine, but them trying to equate all trans people with men and cheering is okay. Wonderful. Oh, I wonder how long this is going to be. Hopefully it should only be a minute.
As parliamentarians, the public expect us to engage critically with the arguments. They expect us to balance different viewpoints and rights. And they expect us to ask the hard questions and understand what we are voting for. And it is a huge responsibility, and it cannot be delegated. The people of Scotland are watching, and we often say...
Oh, it's gone weird again.
...that we use legislation to send a message. And I believe that's true. I believe that is sometimes what we're doing. But I'm very, very sad to say that the message today that's been sent out
why have you got nuts again?
To women and girls in Scotland is that you don't matter. So I'm going to vote as if women do matter, and I'll be voting against the bill.
Thank you. Before I call Pauline McNeill to speak, under Rule 9.8.5a, I am minded to accept a motion without notice to propose that the next time limit be extended to 2 hours.
Move, Presiding Officer.
Thank you, Minister. The question is that the time limit by which the debate on Groups 13 and 14 must end be extended by 2 hours. Are we all agreed? We are agreed, and I call Pauline McNeill to speak to Amendment 117 and other amendments in the group.
Thank you, Presiding Officer. I speak to Amendment 117 in my name, 128, 129, supporting the excellent amendments in the name of Jackie Bailey and others in the group. I'll try not to repeat what's been said. There's obviously quite a bit of overlap in this group, probably one of the most important groupings, I think, of the bill itself. So I want to begin with tackling the issue of the Scottish Government's position that all they have done is reform the process part of the 2004 Gender Recognition Act. I don't believe that that is the case. The Scottish Government has consistently argued, therefore, there is no requirement to issue guidance or clarify the effect of holding a gender recognition certificate under the proposed reforms in relation to the 2010 Equality Act. In fact, the Scottish Government have insisted right up to this point that it is the responsibility, and you heard that again today, of the Equality and Human Rights Commission to issue guidance on the effect of having a gender recognition certificate. And the problem with that statement is that the Equality and Human Rights Commission, as Claire Baker mentioned earlier, have then and now repeated their view that the Government has amended the bill to such an extent that there now needs to be clarity on the operation of the 2010 Equality Act. Now, in my view, this is based on the fact that the 2022 bill, as we are looking at now, is quite different. Just last week, Again, they said the same. The law concerning matters of sex and gender can be complex, and clarity is essential for public bodies, employers, service providers and people across the country who rely on it. Again, Reem Assalam, who gave evidence to the Equality and Human Rights Committee, said the same. She said to the Cabinet Secretary in relation to prisons, she said the guidance is not good enough. Now, what more convincing did the government really need to get to this stage and argue that you've now conceded that you'll then talk to them? I'll give way to Cabinet Secretary.
Cabinet Secretary.
Polly McNeill might be aware, I'm not sure, that the Prison Service is already reviewing its guidance, but have been managing transgender prisoners for many years, some of which are placed in the women's estate, some in the men's estate according to risk. But yet she is aware that they are reviewing their guidance to make sure it's fit for purpose in the current day.
Polly McNeill.
Yes, and I do welcome that review from the Scottish Prison Service, and they have consulted more widely, and I'm pleased to see that. But I'm not comfortable with the notion that this is now out for consultation. Why, we're still being criticised as the Parliament for not having the guidance in the first place. That makes me uncomfortable with looking at the provisions in the bill while this is not in place, because it's a central issue to be debated in this grouping that Jackie Bailey has addressed also, and that is the confusion. Ruth Maguire's question about funders, for example. There is massive confusion. I want to address this in some detail, if you don't mind. Under the current and proposed system, so it now appears that it's quite impossible for organisations to legally distinguish between those born females and holders of a female GRC. And the government successfully argued this in court. And I think that whilst that judgment may be overturned or not, it has added to the confusion about this particular aspect, particularly of this phrase legal sex. Now, this will undoubtedly lead to confusion of the organisations that are left with the challenge of trying to interpret what that law means. So in stage 2, the briefing of the Equality and Human Rights Committee noted that the proposed form will have significant implications for the operation of the Equality Act in Scotland, to the extent that they say the expansion to a larger group will have meaningful consequences in relation to the operation of those provisions. So I don't think that members should dismiss it lightly, that whatever you think of the reforms, this particular reform will apply to a larger group of people. And we have the guardians of the Equality Act. I mean, let's be clear, the Equality and Human Rights Commission are the guardians, if you like, of the Equality Act, are saying that makes a significant difference and has meaningful consequences. They say in relation to education and schools, sex discrimination, including equal pay between men and women, gender pay gaps, and measures to address disadvantages experienced by women. And my contention in this bill is it does not simply just reform that part of the 2004 Act, which I was a vocal supporter of and still am a vocal supporter of reform. But I believe that by removing huge elements of the process and arriving at a framework now which is a self-ID model, then the operation of the Equality Act does leave some things to be considered. And this is what I'm going to... Yes, I will, yeah.
Thank you, Pauline McNeill. Thank you, Presiding Officer. Does the member agree with Joanne Lamont when she says that the proposed safeguards are utterly risible? Thank you.
Pauline McNeill.
Well, I think what the Parliament has been trying to achieve, actually, to be fair, in the last day or so, is actually to debate some of the safeguards, and some of which I think we have achieved. So, yeah, I would agree with that. But I wasn't really talking about safeguards per se. I think this is a really, really important, it's certainly a really important point for me, because my contention, as I said, the bill doesn't simply just reform one part of the GRA. It actually kind of changes the whole nature of it, which is why we as legislators have got to be clear now that if we pass the bill tonight, tomorrow, whenever that's going to be, that we are pretty clear, absolutely clear, how it interacts with the Equality Act. I believe that, just give me a minute to get my train of thought back, please. I believe that the Scottish Government have instead stripped out these elements, as I've said, so if we, plus removing all the requirements from the process of acquiring a gender, as I spoke to in previous groupings. also means that there's some clarity required. So I believe that's why the Scottish Government must publish detailed guidance on the effect of having a GRC. And I want to speak more to this about what there might be legal challenges to Lady Haldane's judgment and what it might mean. So I do think that given what I've just described, which is a vastly different bill, it's not just a tinkering with 2004, then I think the obligation is for the Government now to indicate what the effect of having a gender recognition certificate is. I'll give way to Rachel Hamilton.
Rachel Hamilton.
I thank Pauline McNeill for allowing me in. I'm really interested in the arguments that you're making, and you and I have discussed this issue
through the chair, please,
at
Ms.
length.
Hamilton.
Sorry, Presiding Officer, but I just want to ask Pauline McNeill if she believes that the Lady Haldane's court ruling that Pauline McNeill is talking about has blown apart the SNP claim that obtaining a GRC does not grant access to the rights and protections of women, because their argument, the argument that the SNP made in court, now confers access to the rights and provisions and rights and protections to women. So they've blown apart their own argument by arguing against that it doesn't confer rights and protections to women.
Pauline McNeill.
Oh, okay. I'm not going to second-guess the judgment and what might happen, but I want to say this in response. I was going to say anyway. So the phrase we've heard, nothing in this bill changes anything in the Equality Act. Now, that really depends what your perspective is, in a sense. Because for me, I've always assumed the Equality Act, when it refers to sex, although it doesn't say so, I've always assumed it means biological sex. But for some people, they think it's legal sex. And what Lady Haldane seems to be saying is that's legal sex. Up to this point, I thought it was biological sex. My point is, there's a great deal of confusion on what this judgment now means. So that is, I guess, my point, which is, it's the Government's job, who are the movers of the legislation, to take into consideration the judgment and to tell providers and the general public what the effect of having a GRC is. I can't answer what the effect is because I'm a wee bit confused myself, to be honest now. I want to deal with this question of having a GRC, not having a GRC. So we've heard this argument, well, you can, it doesn't really make any difference whether you have one or whether you don't, because you can be excluded under the exemptions. I think there is a significant level of confusion about this, and it does take time to get your head around this, about where this really does matter. So in March of this year, Cabinet Secretary said that the bill does not introduce any new rights for trans people. It's about simplifying and improving the process for a trans person to gain legal recognition. So I do agree that it does make the process simple. What I'm not clear about is whether it gives any new rights or not. Now, I did want to say something else in relation to the Haldane judgment. There are many commentators already saying that the For Women Scotland judgment would be likely to destabilise existing categories and frameworks for the purposes of reserved matters and equal opportunities. And a particular article by Michael Foran, who writes for the UK Constitutional Law Association. Now, I realise it's just one academic, but this has been discussed, obviously, since this judgment was only passed on the 13th of December. But here's the important part, I think, for the Government to consider. He and others are now of the opinion that the possession of a GRC clearly does matter for the assessment of whether exclusion is objectively justified. Now, I'll deal with this argument in a minute, and it's one that Jackie Bailey made very well, which is the law requires you to judge whether or not it's proportionate and legitimate to exclude anyone, and rightly so. You have to say why you think it's proportionate. Some commentators are saying that given we've just had this judgment, what we don't know is that the possession of a GRC is going to make it potentially more difficult to make that objective judgment. Now, I'm only posing the question. I'm not saying that it is. If you give me a second, I will, because I want to make this point thoroughly. I'm not saying that it will, but the fact that people are already questioning the judgment in this regard, and given that it's the Government that have, in a sense, got to answer this question, because you're the ones that are saying, no problem here, it will be totally in line with the Equality Act, and you can use the exemptions. While some people are now saying, well, having a GRC might not be seen as objective to exclude somebody who has one. I'll give way to Jeremy Balfour.
Jeremy Balfour.
Thank you, Deputy President. Would the member agree with me? We've had this judgment for just over a week. Most of us haven't read the full judgment, let alone understood it. Academics are still working through the implications of it. No doubt lawyers are looking at appeal points as well. So there is real uncertainty of what this interpretation will mean going forward. Would she not agree with me that actually the best way forward here would be simply to pause the process until we get some legal certainty, so we're not all trying to second-guess, while most of us aren't practising day-to-day lawyers?
Polly McNeill.
Well, I think it's a fair point that none of us are practising day-to-day lawyers. We're trying to make our best understanding of it. But what I'm saying is, that's my understanding. But I would like guidance from the government in terms of, they're the movers of the legislation. I'm really trying to get that now and not wait, which is why I've moved these amendments. I now want to deal with the exceptions in the 2010 Equality Act, again that Jackie Bailey addressed, because they are so fundamentally important, I think, to this legislation. And that's Amendment 129, requiring the Scottish Government to consult each public authority about the implications of this Act for the development or modification of the authority's policy on the operation of the exclusions. So in December 2021, just a year ago, the House of Commons Women and Equalities Committee reported on the Gender Recognition Act stated that concerns raised about the interplay between the Gender Reform Act and the Equality Act fell into three broad categories. One, a lack of confidence or understanding among service providers about how to apply exceptions. Two, the need for better guidance to assist service providers with exceptions. And three, how a system of self-declaration might affect the provision of single-sex services. In a year on from this, I don't think these questions have been answered. And fundamentally, this is the most important point I'd like to make to the Cabinet Secretary. If service providers don't feel they have confidence to use the law, what is the point of the law? And I think, again, you must provide these organisations with that confidence, or I don't think you can continue to rely on this issue that you can just organisations can just make use of. And I want to draw some examples on that point. So, Cabinet Secretary is aware. I've been trying to get a copy of this letter that Pam Duncan-Glancy raised earlier for ages to see what was actually in it, and I do concede at the time I did see on the record that I could only read the Times report, but I read it for myself and that I accept the letter is quite different. But what concerns me about Kevin Stewart's letter, and it illustrates my point, which is he wrote to health boards in October of this year, noting that he had been asked questions about the processes and policies Scottish hospitals were using when managing inpatient admissions of transgender patients to NHS inpatient services, and that some boards had clarified that there is currently no specific protocol for the management of this patient group. There was nothing in the letter about the law. Nothing in the letter about the exemptions. Now, surely at least the government would accept. What's the point in writing to health boards without telling what they're allowed to do, but putting the onus on them when actually it's the government? I really think this is. I think it's atrocious, to be honest. And I think the government have got to still live up to the responsibilities here. Well, that's why I ask that the government support my amendment and talk to organisations on the ground who have to implement this public policy. I mean, I think this is the most lacking aspect of the legislation's impact, and that is the public policy sphere, if you like, about how you apply these exemptions. Yes, I will, yeah.
Cabinet Secretary.
So, Polly McNeill will be aware that the AHRC recently issued revised guidance, and I think that was partly to take into account some of the issues that Polly McNeill is talking about. So I'm not sure what different guidance we would provide in those circumstances, because actually I think the revised guidance is the right guidance. And to cut across that, even if we could, and we can't because it's reserved, would just cause confusion. I don't think there's anything fundamentally wrong with the revised guidance that the HRC have issued.
I wonder then if the Cabinet Secretary would address my central point then, which is, why do ministers not write to health boards and tell them what the guidance is? Why are you writing to health boards and putting the onus on them to tell you? Because here's the problem. Here's the problem. They don't have the confidence to use it. And I want to give another example of this. In Ayrshire and Arran's policy on trans users, there appears to be no mention of the exemptions framework. Can you see the trend here? No one in the public sector is mentioning the exemption. I don't understand why the government are not more concerned about this. Because it really is in the interest of all users, it's in the interest of trans patients, it's in the interest of all patients, it's the interest, if you believe in the policy and the legislation, to sort this out. And this is the worst example because it's a total misreading of the law. It isn't even the law. The NHS policy in Ayrshire and Arran refers to multiple occasions the fact that certain scenarios or practices may be in breach of the legislation. They don't name the legislation. In Appendix 4, this policy states that placing a trans patient in a single occupancy room to avoid potential difficulties is discriminatory. Well, it's only discriminatory if they have not justified it by being proportionate and legitimate. Compared to the situation, they say, of placing a black, disabled, elderly or lesbian, gay, bisexual patient in a single occupancy room. And the policy further states that female patients who raise concerns about trans women being put on female hospital wards were comparable with races, and they have been told that they will be removed. Now, look, I'm not being too hard on the health board here because I think they probably think they are trying to do the right thing, but this is a disaster in public policy terms. So I'm really actually quite annoyed we've got to stage 3 before the government's acknowledging any of this. I want to close with single-sex services, and Jackie Bailey did 2 seconds. OK, yeah.
Liam Kerr.
I'm very grateful, and may I say I'm enjoying the member's contribution. I think she articulates my concerns as well very well. But it does lead me to wonder if the member doesn't get the amendment sought today and the clarifications that have been asked for from the Cabinet Secretary, and so the ambiguity and concerns that she's articulated remain. Does the member nevertheless intend to vote for the bill? And if so, can she help me understand why?
Well, any good legislator, I have come here today to really press the Cabinet Secretary for some answers. And actually, I sat through the whole of the stage 2. I mean, my contribution to this is very genuine. What I'll do when the time comes is something you'll find out, because at the moment, I'm really trying to test the government on these important policy issues. I want to improve the situation. Probably Jackie Bailey's covered the issue of single-sex services, so I won't. It was just a reiteration of some of the services, such as rape crisis centres, have clearly found it very difficult in some instances, and I don't think that's good enough. It's not good enough for rape crisis centres to feel the threat of being called transphobic for using the exemptions where they can clearly show that it's proportionate and legitimate. The government must stand up for these services who choose to do that. Lastly, my amendment on data, sex and gender, I just want to talk about this briefly. I think we need better data. I think that the UN rapporteur on LGBTI, forgive me, I can't remember his name, made this point quite well, that we do need to have more data on the population, the trans population, to ensure we've got better policies affecting them. But we do need to collect data on the basis of biological sex. Reem Asalim says that she's afraid that the collection of sex and data has been recently deprioritised, and she says it's led to the conflation of data results. So we've seen the introduction of recording policies that conflate sex and gender identity in a single category. And whilst I recognise the Chief Statistician published a report on data collection in respect of sex and gender identity and trans status in September 2021, he proposed voluntary questions around the capture of sex and gender. And it's clear many organisations are not tracking such information in relation to service users. Statistical evidence has been compromised by a lack of separate data on sex and gender identity, meaning information can be easily tracked. Police and other services need to collect data on sex and birth-declared gender identity separately in order for services to undertake rigorous risk and impact assessments when considering proportion and legitimate concerns. So, in conclusion, Presiding Officer, I apologise that was a long contribution. One of the reasons why I wanted this moved into another grouping so that I could address it. In conclusion, I am clear in my own mind that if you want the legislation to work, it is quite different. You have to resolve these issues without going to the heart of competency. You have to give confidence to public service providers. Otherwise, as Jackie Bailey says, the term proportionate means of achieving a legitimate aim is an absolutely meaningless phrase in law if you cannot tell your public sector providers what it actually means in the first place. Thank you very much.
Thank you, Ms McNeill. I now call Claire Baker to speak to amendment. Point of order, Douglas Lumsden.
While the debate's been taking place, I noticed there's members at home trying to make interventions, but speakers aren't able to see that while they're speaking. Are you able to tell us, or are they meant to be told that there's interventions, or are they just meant to notice that on the screen while they're speaking?
Can I thank Douglas Lumsden for that? I was not aware of that. I will ask for that to be looked into. Certainly it should be the case that those who are participating remotely should be able to make that clear to members who are speaking in the chamber. But I'll ask for that to be looked into. Thank you very much, Mr Lumsden. I now call Claire Baker to speak to Amendment 118 and other amendments in the group. Ms Baker.
Thank you, Presiding Officer. So Amendments 118 and 119 in this group focus on the need for guidance on the operation of occupational exceptions, which considers Section 22 of the 2004 Gender Recognition Act and Schedule 9 of the 2010 Equality Act. So Section 22 of the Gender Recognition Act 2004 makes the disclosure of protected information related to an individual's trans status a criminal offence unless it is to prevent a crime. And Schedule 9 of the Equality Act 2010 allows occupational exceptions based on both gender reassignment and sex, when it is a proportionate means of achieving a legitimate aim. So at stage 2, I secured an amendment which is being incorporated into Amendment 90 today, which requires the Government to consider the need for further exceptions to the offences under Section 22 in devolved areas. And if they decide not to, they have to specify why not. And Amendments 118 and 119 complement this as they address the issue of guidance. Presiding Officer, I had intended to bring forward amendments which would have given the opportunity to debate the appropriateness of Section 22 of the 2004 Act, if the offence should be civil rather than criminal, if malicious intent should be identified, for example. But these were ruled to be out with scope. And that is why I find the debate around the Equality Act challenging. The Government is correct that the bill is not adding or taking away any rights for trans people, but they don't recognise or think it is relevant that the significant changes being proposed to the process changes the context in which those rights are being granted. The rights contained in the 2004 Act and being upheld in the 2010 Act by the EHRC and the ruling from Lady Haldane reflected a social contract between the individual and society. It has been described as a key to a lock. I appreciate this bill moves the process in another direction. This bill is about the individual making the decision alone. And while the argument there's an argument that it impacts on no one or it concerns no one else. But by making the changes to this process, the rights afforded by the 2004 Act will be extended to a potentially very different cohort of people, as the process is being made simpler and easier, demedicalised and less bureaucratic. And in this context, we need to have clarity over the operation of the exemptions and exceptions in the Equality Act. So the 2010 Equality Act facilitates the delivery of single-sex services when it is proportionate and legitimate. But the current lack of clarity is leading to confusion over how the law is interpreted. This confusion is there both for providers of such facilities and for users being aware of what they can or cannot expect or what they are entitled to expect under existing equality legislation. In the 2019 consultation on the draft Gender Recognition Reform Bill, the Scottish Government themselves highlighted a situation which requires clarity. The consultation said that some people in an organisation, for example in the HR department, may know about a person's trans history, but those actually taking the decisions on staff deployment, for example line managers, may not. The consultation goes on to say that when there is a legitimate case to use the general occupational exemption, it would be appropriate for information about a person's trans history to be shared in a strictly limited, proportionate and legitimate way. However, it is not clear how this statement can be made in relation to Section 22 of the 2004 Act, which makes it a criminal offence to share protected information. This has led to confusion from employers and in public bodies. For example, a Scottish Health Board and an FOI said, unless the practitioner consented, to exclude them from carrying out female-only care would be a breach of Section 22 of the Gender Recognition Act 2004 and a criminal offence. There are also restrictions under the Equality Act 2010 around requiring staff to disclose their gender identity and staff selection on this basis. Presiding Officer, this is not accurate. A health board can exclude on the basis of gender assignment, regardless of whether or not someone holds a GRC. They can exclude someone from delivering female-only care under the 2010 Equality Act. The lack of clarity around the effect of Section 22 is having a chilling effect. It suggests that public bodies believe that Section 22 prohibits information to the extent it prevents them from delivering female-only care, although the government consultation in 2019 said that information can be shared. So I believe it is incumbent on the government to provide guidance on occupational exemptions to service providers, which clearly sets out the interaction between this piece of legislation, Section 22 of the 2004 Act and Schedule 9 of the Equality Act. While the Equality and Human Rights Commission have issued guidance on occupational requirement and exceptions, the interpretation of that guidance in public bodies across Scotland continues to lead to confusion. I do not believe that it is out with the boundaries of the Scottish Government's powers to provide clarity on these issues. In their briefing for the Stage 2 of the bill, as I said earlier, the EHRC said in relation to the UK and Scottish Governments, they must ensure clarity for employer and service providers on the law. The Scottish Government should recognise their responsibility to provide guidance which employers could use on the occasions that they wish to exercise an occupational exemption, which they are able to do with the support of the Equality Act when it is proportionate for a legitimate aim. It would also provide clarity for service users, as it would emphasise the EHRC guidance and make it clear the circumstances in which they can expect an occupational exemption to be considered. This would provide much-needed clarity for the provision of single-sex services. I would ask members to support Amendment 118 as it requires the guidance to be subject to parliamentary approval. This is a complex area that I think would benefit from parliamentary scrutiny, and 118 would provide for that. So we have a number of amendments before us today on guidance, most of which I understand the Government aren't going to support. So, Presiding Officer, I've got two final points. One is, if the Government's guidance, which is Amendment 54, will not cover the areas that MSPs are raising, can they clarify which areas will be covered by their guidance? And secondly, I was struck by the UN Special Rapporteur on Violence Against Women and Girls, the evidence she gave to the Equalities Committee on Monday. And here I'm going to highlight her views on the shortcomings of guidance. She said it would be helpful to issue guidance, but frankly, on its own, that is not enough. That would be a bandage solution to wider and more systematic flaws with the process and the draft legislation as it stands. I suggest again we go back and address all these different pieces because they're all linked to each other, and that we do not suggest this would be a magical solution to some of these issues as a result of non-binding guidance. Some things must be clarified and spelled out in law. That is what women's organisations and many victims expect. My amendments are asking for guidance, and I think this would improve the implementation of the bill, and I am urging members to support it, but I have to say I am concerned that guidance will not resolve the challenging issues that myself and others have raised this afternoon.
Thank you, Ms Baker. I now call Rachel Hamilton to speak to move Amendment 120 and other amendments in the group. Ms Hamilton.
Thank you, Presiding Officer. I move the amendment in my name. My amendments in this group would place two requirements on ministers that I believe offer them an opportunity to clarify the interaction between this bill and the protection of single-sex spaces, and provide reassurance to both providers and users of those spaces. Amendment 120 requires ministers to provide and publish guidance on how this bill will affect single-sex services, whilst Amendment 121 requires ministers to prepare and publish a report on the impact of this Act on the provision of single-sex services. These amendments aim to provide clarity on the operation of single-sex exemptions within the 2010 Equality Act.
None of this has anything to do with this bill.
In relation
Nothing
to
changes
this bill.
in the Equality Act.
Many people have quoted Rima Salem today, the UN Special Rapporteur on Violence Against Women and Girls, and she provided evidence to committee on these matters. And she said that women could self-exclude from female-only spaces as a result of this bill. So far, women have received absolutely no reassurance from the Cabinet Secretary that their rights will be protected within this bill. The debate around this has been, I believe, repeatedly shut down and brushed aside. Mr Salem also said... Sorry, do you want to make an intervention? Oh, right. Thank you. Mr Salem said that the Sorry, do you want to make an intervention?
Could front benches desist from speaking across the chamber? Ms Hamilton.
What did he just say?
Ms Hamilton, could you resume your seat, please? Ms Hamilton, could I ask you to resume your seat, please? Could I invite Mr Brown and Mr Finlay to desist from speaking across the chamber while Ms Hamilton is speaking? We've conducted this debate so far in a courteous and respectful manner and expect the chamber to continue in that fashion. With that, I invite Ms Hamilton to resume your remarks.
Thank you, Presiding Officer. Mr Salem said that the Scottish Government's proposals would open the door for violent males who identify as men to abuse the process of acquiring a GRC and the rights associated with it, and that the Scottish Government does not provide for any safeguarding measures to ensure that the procedure is not, as far as can be reasonably assured, abused by sexual predators and other perpetrators of violence. These include access to both single-sex spaces and gender-based spaces. Today, the Scottish Government have failed to provide clarity and reassurance to provide many of us who are asking and users of single-sex spaces, despite the many opportunities that have been presented to them to do so, and the out-of-hand rejection of a number of colleagues who have continued to push this concern that they have, that's not represented by them, it's represented by others out with this building, out with this chamber, people who are very concerned. I also want to highlight evidence that was taken by the committee from the HRC and many members of the public, MBM and others who expressed similar views that this issue must be addressed in the bill. I want to commend Ash Regan, Jackie Bailey, Pauline McNeill and Claire Baker for their contributions. We will be supporting all the amendments that they have put forward. And I'm not going to repeat many of their very clear arguments that they have articulated very well. But in her closing, I would like to address some of the issues that haven't been addressed today, which is the impact of Lady Haldane's ruling. And I would like the Cabinet Secretary to tell me how protections on the basis of sex are impacted by Lady Haldane's court ruling. For example, can a woman raise a sex discrimination case if their comparator is a male who has a female GRC, or the positive measures by all of us here across chamber who want to reach gender balance in public boards? And does the Haldane ruling mean that gender balance on a public board could be 50% men and 50% trans women, effectively extinguishing
none of this is relevant.
Protections
this is part of the Equality
women.
Act that they're not discussing.
Thank you, Presiding Officer. I think I moved my amendment.
You don't need to move it at this stage anyway,
okay.
Ms Hamilton,
sorry.
but I'm much obliged.
Thank you.
Before moving to the next speaker, can I just respond more fully to Mr Lumsden's earlier point of order? Thank you again for raising it. I've asked officials to check. They have confirmed, as indeed has broadcasting, that the remote system is working as appropriate. It does, however, rely on members noticing this appearing on the screen, and therefore it's maybe a useful reminder that there will be members who are participating remotely who may wish to make an intervention, and therefore if the colleagues could be aware of that, I think that would be helpful. With that, I move to Pam Gosal to speak to Amendment 61 and other amendments in the group. Ms Gosal.
Thank you, Presiding Officer. Firstly, like others, I would like to thank all the organisations who have sent briefings through to help inform this debate. I would also like to thank all the hundreds of emails and letters and cards we have received, which I am sure everybody has received in this chamber. And lastly, before I start my amendment, the debate, I wanted to thank all the parliamentary staff for, obviously, last night staying on. But looking at the time, I think I'm going to thank them ahead of time. That looks like we will be here again in another late night, so thank you. Since day one, I have made it clear that my goal is here to seek balance. No good legislation ever comes from betraying the rights of one group to the convenience of another. In other words, while I truly believe that improvements to the gender recognition process would be beneficial for trans individuals, this should not come at the expense of women and girls, vulnerable individuals and children who require the protection of the law. At stage 2 of the bill, my colleagues and I tried to make amendments to uphold some form of safeguarding against bad faith actors, which are not included in the SNP government's flawed legislation. We even tried to postpone this legislation, given the evidence that came to light in the form of recent ruling by the Scottish Supreme Civil Court, further damning evidence outlined in a letter from the United Nations Special Rapporteur on Violence Against Women, and most recently polling which suggests 2/3 of Scottish electorate opposes the key principles of this bill. But clearly the Scottish Government is charging ahead and not listening to many voices pleading for this bill to be postponed.
John Mason.
I thank the member for giving way. I mean, so far her remarks have been quite general, but does she think that self-exclusion might particularly impact on ethnic minority women and people from religious minorities?
Pam Gosal.
I thank the member for asking that question. Absolutely, it will affect, and you will see some of my amendments later on, how I talk about that. I've mentioned it many times in the committees, but I've also mentioned it many times in this chamber, that we must have a balanced right for everybody. And coming from a BAME background, I will be speaking about this and letters we have received, so I hope the member will be eager to listen later on. Thank you. Today I stand here hoping the Parliament will support my amendments, which seek to offer even just minimum reassurances for women that this Parliament is committed to upholding their rights. At this stage in the process, it has come down to making minor amendments in the hope that there will be at least some form of reassurance for women, some form of comfort that their rights are under the 2010 Equality Act and not being completely eroded. At stage 2, I propose amendments which would have required Scottish ministers to publish information on the impact of the Act on single-sex spaces and services. Yes, to no surprise, they were voted down. At stage 3 today, I ask that Parliament supports my amendments 61 and 123. Amendment 61 places a requirement on ministers to prepare and publish a report on the impact of this Act on self-inclusion from activities or services no later than 1 year after Section 2 comes into force. I ask that the report includes information on self-inclusion by both women and men and in different activities or services. Amendment 123 places a requirement on ministers to prepare and publish a report on the impact of this Act on funding for single-sex services and to consider what steps, if any, the Scottish Government consider necessary to ensure appropriate funding is available to single-sex services. Presiding Officer, for years this Parliament has been making genuine progress in its attempts to ensure that victims feel heard, to ensure they have a safe space, to ensure they have the support network. But this bill risks doing the opposite. It risks marginalising already marginalised women. It risks re-traumatising victims. Vulnerable women, particularly victims of domestic violence, may forego seeking refuge in domestic abuse shelters, whereby they might encounter biological males. This amendment therefore calls for data collection to obtain a figure on how many women are excluding themselves for such activities. This is highlighted by the fact single-sex victim support services are so few and far between that Vera's Place, which opened its doors last week, is set to be the sole single-sex support service for victims of sexual violence in Scotland's capital. It begs the question, why does it take the feminists like J.K. Rowling to step in and provide a solution to an identified problem, while the SNP government sits on its hands and denies such problems exist. On Monday at committee, I asked Reem Assalim, the United Nations Special Rapporteur, whether, given that ring-fencing funding was out with the scope of the bill, the next best option was to place a requirement on ministers to review the impact of the bill on funding for single-sex services. Mrs Assalim agreed that placing this requirement on ministers would be justified. I also refer you to her letter from Mrs Assalim, where she writes, "In the case of Scotland, it has been difficult to determine the exact scale of self-exclusion, given that hard and comprehensive data is lacking for several compelling reasons." She later says, "General Recommendation number 28 makes it clear that in complying with their obligations to eliminate discrimination against women under Article 2 of the Convention of the Elimination of Discrimination Against Women, state parties should provide for mechanisms that collect relevant sex disaggregated data, enable effective monitoring, facilitate continuing evaluation and allow for the revision of supplementation of existing measures and the identification of any new measures that may be appropriate." Presiding Officer, it is vital that service providers in Scotland are enabled to provide single-sex services. While Reem Assalim believes funding must be ring-fenced for a certain proportion to be single-sex, to balance the needs of different demographics without placing them in conflict, I was told that ring-fenced for a certain proportion of single-sex and gender-based services out of scope of this bill. She did make it clear, however, that it is not our job to question why some women want to access to women-only spaces, but it is our job as states and as organisations to reduce the barriers for access, and this is what is required by an intersectional approach. Therefore, I propose that the Scottish Government, at the very least, monitor and review the impact of this Act on self-inclusion and funding for single-sex services. I would urge all members to back Amendments 61 and 123 in my name. I, of course, support other amendments such as 111, 120, 121, 72, 73, 127, 130 and 92, which seek guidance on and the protection of single-sex spaces and services. I also support amendments 117, 128 and 133, which seek guidance on the effect of this Act, how GRC impact the Equality Act 2010. I will also be supporting Amendment 112, which states that this Act does not affect the provisions in Gender Recognition Act 2004. I also support Amendments 118 and 119, which requires ministers to issue guidance on the disclosure of protected information related to GRCs for the purpose of occupational requirements. I also lend my support to Amendments 129 and 136, which seek to consult interest groups such as public authorities and women and girls. However, I will be voting against Amendment 54 in the name of the Cabinet Secretary, which requires ministers to consult and provide guidance on this Act to bodies they deem to be promoting equality and human rights, because ultimately it's clear that from this consultation on this bill alone, many groups remain feeling unheard. So I do not have that complete faith that the Scottish Government will consult on a fair basis.
They just aren't willing to compromise. They just
Thank you, Ms
scream
Coastal. I understand my earlier
trans
response
women are
to
not
Mr
allowed
Lumsden's point of order wasn't
women's
entirely
spaces.
audible
That's
in
it.
other parts of the chamber, wasn't picked up by the microphone. So just to clarify, the system for remote interventions is working, but it does require members to be keeping half an eye on the screen. So I hope that reassurance is helpful, and I think entirely appropriately and timely. The next speaker is Sue Webber to speak to Amendment 72 and other amendments in the group, and Sue Webber joins us remotely. Ms Webber. If you could hold on a second, Ms Webber, the audio doesn't appear to be working. I will investigate that and try and get you up and running as soon as possible.
Is that one better?
That is much better, Ms Webber.
Fixed it myself. There you go. Right. Thank you very much, Presiding Officer. And yes, thank you for bearing with me with those interventions. I was trying to get in previously. I have 4 amendments in this group which seek to compel Scottish ministers to provide clarity to women and girls about when services can be single-sex and when they cannot. Pretty much the practical operations of the bill. Amendments 72, 73 and 74 seek to do this through Scottish Government-issued guidance, while Amendment 92 seeks to enshrine this through secondary legislation. So I move the amendments in my name. Starting with the guidance amendments, Amendment 72 sets out a duty for Scottish ministers to provide guidance in relation to service providers being able to offer their service exclusively to those who are female at birth, irrespective of whether their person has a gender recognition certificate. And now we've all heard today that the recent Court of Session ruling confirms that under the Gender Recognition Act 2004, an individual obtaining a gender recognition certificate has their sex changed for all purposes, including under the Equality Act. However, we have heard consistently and continue to do so today that the Scottish Government appears to maintain that this does not apply to the provision of certain single-sex spaces. And if that is the case, it would be very useful for them to highlight in which circumstance it is still lawful to exclusively provide a space or service just to those who were born female. For example, a domestic abuse charity, or indeed for somebody to request that a service be exclusively provided by someone who was born female, like a carer. I mean, I have received correspondence from a severely disabled female who relies on extremely intimate care, intimate personal care, and she would like to ensure that her carer was born female. So we need to understand how this would transpire so she can maintain her dignity. After all, she's entitled to this too. The bill retains the purpose of the original Gender Recognition Act 2004, so the effect of obtaining a gender recognition certificate is the same in law. The public deserve clarity over when it is lawful to either provide or request services exclusively for women who are female at birth. And Pauline McNeill has spoken about the confidence that the public are needing and the current confusion that is existing. So that is why I have another amendment, 73, which specifically compels Scottish ministers to provide guidance as to how this bill will interact with the exceptions that are outlined in Schedule 3 of the Equality Act. It's of no use for SNP ministers saying that the bill will have no impact on the exemptions in the Equality Act, when stakeholders have been very clear that they are unsure how these exemptions apply to their specific organisation. So perhaps when the Cabinet Secretary responds to this today, she can name examples of where it is proportionate to discriminate against those with a GRC for the purpose of providing a single-sex service, because the current providers do not have this information. And legislation, after all, we're sitting here, some of us in a state of confusion, is never written in a language that most people or organisations can interpret without lawyers, and therefore share with their service users or indeed customers. Language that explains in plain English what it means to them specifically and importantly in practice. The Cabinet Secretary insists that the guidance is clear, but I'd suggest it's the very opposite, given the interventions in the Chamber that make it clear that this is not the case. Organisations, public, private and third sector, need clear guidance which they can trust is lawful, telling them whether they can still provide single-sex spaces or services, and that is what Amendment 74 aims to achieve. The guidance should be as comprehensive as possible, covering as many different organisations that will have to confront the problem of whether they are legally allowed to exclude those with a gender recognition certificate from accessing female-only services. And any ambiguity must be removed. Pauline McNeill spoke about that in NHS Ayrshire and Arran. If I get the health board wrong, apologies, I was kicked out for a moment. And my last amendment, Amendment 92, offers the Scottish Government, an alternative path to achieving the goal that I seek, although it's not contradictory with my earlier amendments, and both can be passed. Instead of producing guidance, Amendment 92 would, as part of the regulations commenced in Section 2 of the Bill, require those regulations to set out to the service providers and users what they are lawfully able to provide or request service for those who are female at birth only. We are here to make good law, and as part of that, we have to provide certainty to the public about the legal implications of all legislation that passes through this chamber. Ambiguity must be removed. And I do not believe this certainty has been provided by the SNP ministers throughout the passage of this bill. And last week's Court of Session ruling makes it even more difficult for members of the public to discern whether single-sex spaces must include those with a gender recognition certificate or otherwise. Despite my many other objections to this bill, I hope we can all agree on the need for legislation that is clear and in plain English, and I so hope you will all support my amendments today. Thank you, Presiding Officer.
Thank you very much, Ms Webber. I now call Jamie Green to speak to Amendment 133 and other amendments in the group. Mr Green.
Thank you, Deputy Presiding Officer. Can I thank members for their contribution thus far? I think it's actually been a very thought-provoking debate and, for the most part, courteous. I think that's an incumbent duty on all of us to lead by example on this subject, as contentious as it may be. It's also entirely possible to completely disagree with someone, but absolutely respect the passion with which their speech was made. That's a respect that's been afforded to me in my contributions, and I think it's a respect that I also owe other members for their contributions. Similar to other amendments in this group, and I don't want to rehash any of the arguments that have already been made, my Amendment 133 touches on this issue of the bill and any perceived interaction with the 2010 Equality Act. The basis for that is to address concerns that many have that the legislation might infringe or impact on the 2010 Act. Of course, not everyone agrees with that premise. Many organisations have written to us to say that they do not believe that it impinges on the 2010 Act. They do not believe that this will affect people's access to single-sex spaces. I was particularly struck by the contribution that we were given by organisations such as Women's Aid Scotland, an organisation I have a lot of respect for, who have been actually trans-inclusive for a very long time, irrespective of whether those who come for help hold or do not hold a GRC. And it's because of the type of work that they do that I respect their opinion. Who am I to question it? Moreover, we received communication from the Equality and Human Rights Commission, who were also particularly clear in their view that nothing in this bill affects the Equality Act 2010. I presume that underpins the amendment that was passed at stage 2. However, there's always a however in this debate, there are many people who do believe that it does. My reporting requirement on this simply asks the government to vindicate that position, their position, the position of many organisations, indeed my own position, that if this bill does not affect the 2010 Act, then let the reports show that, because we can then come back to Parliament in 3 years' time and say that we were right. That's the point of it. But here's where I do think there is an issue. There clearly is a deficiency of clarity. We've heard evidence from a number of stakeholders. We've heard evidence today and in the past about a number of scenarios that we should discuss, and we're right to discuss. What happens in GP surgeries? What happens in the provision of care in public bodies, in sports organisations, in youth groups, in religious places? These are all points which have been respectfully made by members, well-intended points made throughout the debate. Today we heard them from Pam Duncan-Glancy, from Rachel Hamilton, Claire Baker, Pam, Gossel, Polly McNeill, who's not here at the moment. But I respect what they had to say, because there is a perception that any changes that we do make as a result of this bill may have a knock-on effect. Now, I know what the Cabinet Secretary will say, and I probably agree that none of this is new. People already hold GRCs. People are already able to be excluded from certain spaces under existing legislation. They have been able to be excluded for a very long time, and indeed many people are excluded from those places. I believe this bill does not change that. Others disagree. But here's the but, and it is an important but. Despite my support for the changes that the bill proposes, and let me assure the Chamber that support has not come easy, it remains clear that there is ambiguity and there remain concerns. Now, we have a job to do. We have a job to listen to those and listen respectfully to those concerns. We have to ask ourselves, is it a reality that there are organisations out there in our constituencies, people that we have heard from, who are afraid about breaking the law by being exclusive? Do they fully understand the guidance that already exists? The Cabinet Secretary said that that guidance is wholesome, fulsome, robust and quite clear. But from what I've heard in the Chamber today from contributions, it clearly isn't. There clearly are people who are nervous and unsure about the guidance. Are they clear? Are they certain? And are they comfortable with using existing laws and legislation? Are they comfortable that by being exclusionary, they are not breaking the law? That's a point that Pauline McNeill spoke to at great length. The question for us is, how do we fix that? My amendment, as you can see, really takes no side in the debate over whether this bill does or does not interact with the 2010 legislation. But I do struggle with the opposition to my amendment that somehow a reporting requirement will unpick the 2010 Act. I ask simply, in what way will reporting unpick the 2010 Act? I do not know genuinely the answer to that opposition. And I am genuinely trying to be helpful, as I've done in many other groups, as I hope members would concur. Jackie Bailey made some excellent points in her contribution around Amendment 111 specifically, that she believes that robust, clear and well signposted guidance may put to bed some of that ambiguity and concerns. In Sue Webber's words, just given, plain English guidance. She's right to talk about a policy vacuum that we've allowed to exist and get worse over many years. She's right to talk about interpretations of existing legislation or variations of interpretation that exist across different bodies. We have let that happen. Whilst this bill, in my view, does not change any of those rights, any of those exclusions, any of those interactions, clearly some people think that they do. And by having this debate and by revisiting the 2004 Act, it is inevitable that those old arguments are brought back to the fore. And I don't think we should be afraid to tackle them. What we have to do is consider, are there small organisations out there who are struggling to interpret either existing legislation or what this new legislation might mean for them? I think the answer is yes. There are organisations out there who really do want to do the right thing for trans people who present to them. I firmly believe that. They also want to do right for existing service users as well, and that's to be respected. I cannot be accused in any way of wanting to unravel this bill through any amendments that we're looking at today. I really can't see how anyone who's listened to the debate over the last 2 days could accuse me of wanting to unravel the bill. Far from it. It couldn't be further from the truth. But where I do think is there must be a middle ground through this, whether that's through guidance, whether that's through reporting, yet in a second, through some of the amendments proposed in this group, which on the face of them seem quite sensible, unambiguous, helpful, useful. I think we have a duty to look at them and the merits of each amendment as they are presented to us today. And I've listened to those arguments that have been very well made. I'll give way to the member.
Daniel Johnson.
I'm very grateful to the member for giving way. And can I first of all commend him on the tone and the way that he's engaged with the debate, full stop. But more critically, for those who advocate this change, those of us who believe that it's important, clarity is really important. And that's what the word that has been used time and time again. So for those that seek to benefit from these rights, they need clarity about how and when they do it. But also those that seek for the continued protections of the Equality Act, they need clarity too. Is that not ultimately what everyone, whether they're coming side of advocating for this or indeed caution on this, should be seeking to promote and ensure is within this bill?
Jamie Green.
Can I thank Mr Johnson for his intervention? I don't disagree with a word he's just said. I think clarity is an easy thing to request. It's not always easy to achieve, though. And that's part of the problem that we have. How much of this do we have to put on the face of the bill? How much of this would appear in secondary legislation? How much of this will appear in guidance? I don't think it's actually enough to say it's not our responsibility as government to produce this guidance. These are independent pieces of advice that public bodies will deliver for their own service users. I think that is taking a step back, a step too far back. I think government has a duty to help offer that clarity and guidance where it can. I think more could be done. I would very much welcome, in summing up, if the Cabinet Secretary commits to some of that improvement, and I don't think it's unreasonable to ask for it. The question that we're facing, though, is whether we do put some of this on the face of the legislation. I guess what I have been nervous about, and I won't pretend I haven't been, is that by referring to some of these other pieces of legislation, reserved or otherwise, and I think the member made it was either Mr Johnson or Mr Maher made very valid points about other pieces of legislation that do refer to reserved legislation and reserved matters, but they haven't been unpicked in any way. But some bills have been unpicked. And as I said, it's no great secret that nothing I want to pass today should result in unpicking this legislation. I want to see the improvements that this bill seeks. But in doing so, it is really important that we do it in a way that does find that much-needed compromise that I spoke about right at the beginning of today and indeed yesterday. All I would say is ask members, implore all members and the government to try and seek that compromise where it is possible and not to resist for resisting's sake. Thank you.
Thank you very much, Mr Green. I now call Daniel Johnson to be followed by Jeremy Balfour.
Thank you very much, Deputy Presiding Officer. And can I thank members that have spoken so far? I think this has been a very thoughtful section of the debate. I mean, ultimately what we're talking about are matters about people's identities, how they live their lives. And when it comes to those matters, nuance is important, context is important. Those are points that I made during stage 2 when I was moving amendments regarding guidance for very similar reasons to the ones that Jackie Bailey moves hers this afternoon. It's really important that we understand individuals' perspectives, that we ensure that they have the help and support that they need, and that we understand the complexity and sometimes even the contradictory nature some of these rights and perspectives have. And the thing about the Equality Act is it delivers that. It's a bill that actually takes something that's very complicated, but delivers that nuance and it delivers balance. It doesn't do so by trumping one set of consideration another. It does so in a respectful and reflectful way. But the issue I think we're contemplating this afternoon is the fact that the practical effects of the Equality Act and the legal structures and mechanisms sometimes don't necessarily accord, in particular with regard to single-sex exemptions. And I think I would just highlight, first of all, I think I like on what Jamie Green has just said. My understanding is that the legal mechanics are not altered, either by this bill or indeed by Lady Haldane's judgment. But I think what is at issue here is that perhaps the distinctions that people think exist within the Equality Act don't quite exist in the way that they think they do. That while it is possible to distinguish between people who were born with a gender at birth in terms of the single-sex provision, but actually the way that that is delivered through the Equalities Act is by making those exemptions on the basis that that person is transgender, not on the basis of their underlying biology or physiology. Now, that has the same legal effect in practice. And that is, in fact, the way that the Equalities Act that we are also familiar with and has been so successful in the 12 years since it's been implemented works. But I think what we do in passing this bill, I think raise questions both in terms of the scale and context, I think as Pauline McNeill and Claire Baker very rightfully pointed out, but ultimately also, and I think in the interventions that Michelle Thompson made and also Ash Regan, it's about the confidence of people to actually draw down the rights that they enjoy over those, how they will continue to be able to do so, and indeed for those that we entrust to oversee systems in both the public sector and elsewhere to actually implement those rights. And those things are important because the context has changed, and in two fundamental ways. First of all, the scale and scope of the people that can enjoy transgender certification will be expanded. So people will be having to make these decisions more often. they will also, we're entrenching within law the principle of self-identification. That, therefore, I think means that we've got a much more complex set of circumstances where someone may be seeking to uphold their rights. So this is complex. We're adding to the complexity. And for those arguing and advocating for this bill, that's not a problem. In fact, we should be celebrating that, because this is nuanced. It is complicated. And actually, we should be reflecting that nuance and the complexity, but we ultimately must also be providing support to those that we seek to uphold the law and implement the law in doing so, because it is more complicated. Because ultimately, what is really at issue here is that when we're seeking to implement safe places, some of the detail and nuance is critically important. And that nuance being around a person's anatomy or biology or physiology, however we want to describe it. Now, I think those contexts are very narrow indeed. But when those contexts come into play, when they are of importance, those details are incredibly important. And it is therefore vitally important that we have the clarity that we've just been discussing so people can make those determinations. And I think the very fact that we are discussing this, there's been such a loud public debate, so much controversy, has had the chilling effect that we discussed. People lack the confidence about how and when to apply these principles. And that is ultimately why we must give people that confidence, that we must give them the confidence about what has changed and what has not changed, about how they apply that. And ultimately, that is a primary responsibility of government, because this government has a responsibility to ensure that public bodies uphold the law, not just within the scope of the law that we have competence to legislate in this place, but over law as a whole, be that Scottish law, UK law, or indeed international law. And just because the law refers to a bit of legislation does not mean that we seek to legislate on it. Just because the law relies on a definition made elsewhere does not say that we are seeking to exert competence. And just because we confer rights on people that are defined or administered by laws set elsewhere does not mean that we seek to change that law or legislate upon it. And I think that is important, because it's clear that we've done that in the past. We have given rights of people to vote who have particular immigration statuses. We have given rights to other people on the basis of what has been defined in other bits of law. And those bits of legislation have not been unpicked. It's a legitimate thing for us to do. It's legitimate for us to rely on those definitions. It's legitimate for us to seek to be clear about how public bodies uphold the law, whether that be UK law or Scottish law. And indeed, I would say it's a duty of government to do. So that is why Amendments 111 and 130 in Jackie Bailey's name are so important, because they provide that clarity. And why we need them over and above the EHRC is because context is important. If you read the EHRC guidance, while it is useful, it doesn't explain how this will work in schools. It doesn't explain how this will work in prisons. It doesn't explain how it will work in hospitals. And I think we are all surely aware that
it
those
doesn't say anything about where this is explained in all these places, because it doesn't affect these places. That's the Equality Act.
And that is why the government, in its duty to
this
help
changes
public
nothing.
bodies
This just changes
uphold the law,
how you get
with the law,
something administratively.
must produce
That's
guidance
something
on how
already
this,
exists and is
law
already
will
explained.
interact with the Equalities Act. This is fundamental, because ultimately, if we don't provide that clarity, we are doing a great misjustice to the principles that this bill seeks to promote. It will make it harder for people to both enjoy their rights, whether they're transgender, or indeed people seeking to enjoy the rights of single-sex exemption. So if nothing has changed, let's make that clear. We need the guidance. We need these amendments. Thank you very much, Deputy Presiding Officer.
Thank you, Mr Johnson. I now call Jeremy Balfour to be followed by Maggie Chapman.
Thank you, Deputy Presiding Officer. Can I agree with Paul McNeill? I think the amendments we've been debating within this grouping are perhaps some of the most important amendments that we will be debating over the next couple of days. I would like to start, with your permission, Deputy Presiding Officer, by quoting a constituent who has been watching this debate at home on television, and she's asked a specific question of the Cabinet Secretary. Her email says this: as a charge nurse on day shift, short-staffed as usual, I am sent a clinical support worker, not a registered nurse, from a staff bank, who I have not met before and is obviously male. A female patient on the ward has stated that she only wants female staff to provide intimate care for her. The CSW from the staff bank intends to accompany another female and give that individual a bed bath. I reiterate, the patient has requested female-only care. I do not know what to do as a staff nurse. Do I protect my patient or do I protect the NHS from being sued? Could the Cabinet Secretary please clarify the situation for me? This is why, Presiding Officer, I stand to speak on some of these amendments, because we have heard from other speakers that there is clarity, but there is an individual serving our society here in Lothian who doesn't know what to do. I'm not sure I fully agree with the previous speaker, Mr Johnson, that there is clarity in regard to what the law is. I think we've heard from Paul McNeill, from Jackie Bailey, from others, that there is not clarity in the law.
Daniel Johnson.
I'd be very grateful. My point is really that fundamentally the mechanics of the law have changed, but actually the nature of the debate does require greater clarity, because I think we've reduced that clarity. So actually I'm agreeing with the member.
Jeremy Balfour.
My apologies then to Mr Johnson. And if we were debating these amendments 6 or 7 days ago, 7 days ago, 8 days ago, I think there would have still been lack of clarity. But the decision from the Court of Session has put greater insecurity around what we mean by these definitions. No lawyer worth their salt is going to jump to a legal judgment within 7 days of reading it. There needs to be time for reflection. There needs to be time to work out what her ladyship was saying, and there needs to be time to work out how will this actually work in practice. How does this relate to other areas of the law?
Cabinet Secretary.
Just in case I forget to come back to this, because it is an important point that Jeremy Balfour has raised. First of all, I would point the constituent that he was referring to the guidance that is specific for employers that EHRC have produced. And that's important because the genuine occupation requirement exception under the Equality Act does provide that a person must not be a trans person where there is a requirement due to the nature and context of work, if proportionate. Now, that exception could be used in the health service, for example, where intimate health and personal care is provided. The judgment, Lady Haldane judgment, changes none of that. That is the position under the Equality Act. It was the position 2 weeks ago, it was the position last week, it's the position today. None of that changes, and I hope that he can reassure his constituent on that matter.
Jeremy Balfour.
But I think, Cabinet Secretary, you missed the point. What does the staff nurse do to get that patient washed and dressed if that is the only choice they have at the time? I'm not going to get into a big debate about staff shortages within our NHS at the moment, but we all know that there is a limited number of staff on each ward, and that doesn't give the guidance of what does the charge nurse do there and then on that shift. And clearly, any advice has not been given down from NHS Lothian to these people in charge of wards to decide. So I don't think, with respect, that clarifies it. So, as I was previously saying, I think we do need a moment to pause. Surely our primary purpose within this Parliament is to make good law, to make law that actually helps everybody within Scotland. And until, for me, there is clarity from others with better legal understanding than myself around the judgment, I do think this is an opportunity for us to pause. If I can move briefly to the specific amendments, Deputy Presiding Officer. Amendment 54, as we've heard in the name of the Cabinet Secretary, we require the Scottish Government to produce guidance about the operation of the Gender Recognition Reform Bill. In preparing this guidance, Scottish ministers would consult statutory bodies concerned with promoting equality or human rights. This all sounds well and good, but I will not be supporting this amendment. That is because the Scottish Government's track record of consulting bodies concerned with human rights has been constantly one-sided, as we've seen out the progress of this bill. Women's rights organisations have told us that they feel ignored throughout this process, and we have seen people like the UN Special Rapporteur for violence against women and girls have their voice ignored.
How is it you have ignored
in favour of another male UN
organisations
that the Scottish Government prefers to listen to?
That aren't included.
So I will not be supporting the Scottish
all
Government
has the
amendment,
women's organisations,
but I will allow them to
that have been
dictate
heard
who they deem to be promoting equality and human rights for the purpose of producing
women's
guidance.
organisations. They're not.
As I
The
said, I will
majority of
vote
women's
against this
organisations
amendment.
are massively
Amendment
for this.
111 in Jackie Bailey's name would require Scottish ministers to produce guidance on the operation of this Act, on the provision of single-sex services, and the amendment specifically mentions settings such as schools, healthcare facilities and prisons, for example. I'm very happy to support this amendment because these public service providers need clarity, as I've said a moment ago, on this Act will impact them and whether setting services can be provided so that those born women and girls only. Again, I think there is lack of clarity due to the decision in the Court of Session last week around these issues. Amendment 112, I understand, is not being moved by the member, but actually I think it is a good amendment and I would have supported it if she had moved it. Amendment 113, also in Ash Regan's name, further clarifies that nothing in this bill affects the definition of sex in the Equality Act of 2010. And while this is important, but it is stated, I know, again, as a result of the recent Court of Session ruling, those who have a gender recognition certificate are included in the definition of sex. And this is something the Scottish Government has failed to address in the terms of single-sex space provision. Nevertheless, it is important to put on the face of the bill that the definition under the Equality Act is not altered to avoid confusion for the public. Amendment 117 in Polly McNeill's name is another amendment requiring the production of guidance, this time in relation to the effect of having a gender recognition certificate. Again, the public deserves certainty on this point, because the Scottish Government are expanding the number of people who can apply for certificates, so it will be inevitable that organisations will interact with people obtaining gender recognition certificates. So specifically is essential. Amendment 129 also requires Scottish ministers to consult public authorities on the implications of this. Now, we have heard different comments from the Scottish Government, but the Scottish Government consult all the time with public bodies and organisations, and I still haven't felt clarity on why they simply won't do it on this occasion. Amendment 128, also in Polly McNeill's name, puts beyond doubt that nothing in this Act affects any requirement to collect data on sex, which is also a sensible amendment, and I will support. Amendment 118 and 119 in Claire Baker's name again require Scottish ministers to produce guidance on occupational exceptions to the offence of disclosing information about a person's gender recognition status for the purpose of any occupational requirement. Amendment 118 is slightly stronger in the guidance that would require the approval of the Scottish Parliament, but both are, in my view, good amendments that will be needed given that new occupations will be forced to interact with holders of a gender recognition certificate, and it should not be an offence for them to disclose someone's gender recognition certificate status if it is part of their job. Amendment 127 in Jackie Bailey's name is one of the amendments that the Scottish Government has requested to be withdrawn. The reason is they claim it would change the effect of the Equality Act, which of course is a reserved issue. Now, I am absolutely clear that no amendment should be supported if it were to legislate on reserved matters, but it is far from clear that the Scottish Government interpretation of Amendment 127 is correct. After all, it seems to restate what is already set out and is already stated in law. And I hope the member will move it. As I understand it, the effect of the amendment is that it puts on the face of the bill paragraph 28 of the Equality Act, which allows for discrimination against those who have undergone gender reassignment surgery when providing a single-sex service, even if an individual holds a gender recognition certificate. Now, the Cabinet Secretary will often say that this bill has no effect, and she said it again this afternoon, will have no effect on the ability of single-sex service providers to exclusively provide their services to those born as a woman only, but she now claims that making this clear in the bill would put it at risk of a legal challenge. So the question is, Cabinet Secretary, which is it? Because her positions are seemingly contradictory. So I will be supporting this amendment unless the Cabinet Secretary can provide a compelling evidence it would be an incompetent amendment, which I highly doubt she will be able to do. Finally, Amendment 130 from Jackie Bailey would also secure protections for single-sex services in the bill by stating that providing a service only to persons of one sex is lawful if it is in accordance with Schedule 3 of the Equality Act. I'm also happy to support the amendment on the basis of protecting single-sex services. Even I don't think this will give it adequate protection, but it takes us further down the road. As I said at the beginning of my remarks, from a constituent watching this debate this afternoon, there is lack of clarity. I believe without these amendments, and if this becomes law, there will be lack of clarity about how this will work in practice. Bad law is bad for Scotland, is bad for our citizens, and is bad for this reputation of the Parliament. I ask that you support the amendments I've supported.
Thank you, Mr Balfour. I now call Maggie Chapman to be followed by Carol Mockin.
Thank you, Presiding Officer. At stage 2, the bill was amended by Pam Duncan-Glancy to include an avoidance of doubt clause that put on the face of the bill clearly that this legislation does not modify the Equality Act 2010. Indeed, because the Equality Act is UK government legislation, this bill cannot modify it. I would say to those who have argued that it was only last week that we knew, following Lady Haldane's ruling, what sex in that Equality Act 2010 means, I would say this. Those familiar with transgender law will know that in May 2021, 19 months ago, in their book entitled A Practical Guide to Transgender Law, Nicola Newbegin and Robin White clearly define exactly the same meaning. So last week's judgment should not have come as a surprise to anyone. And the Cabinet Secretary has committed to publishing guidance that many people seem concerned about on the operation of this legislation, as her amendment outlines. The only other point I want to make in this grouping is this. If you support the principles of this bill and want to see those principles enacted, then please do not vote for any amendment that risks its legislative competence. It is one thing to have challenges to a piece of legislation made, and we accept that that will happen, but it's one thing to have those challenges made and not upheld. It is quite another to have any one of those challenges upheld. Trans people, because this is who this bill is for, trans people should not have to wait more than the 6 years they have already waited to see this bill enacted because of months or even years of legal wranglings or further delays. Thank you.
Thank you, Ms Chapman. I now call Carol Mockin to be followed by Graham Simpson.
Thank you, Deputy Presiding Officer. When I originally thought to speak in this grouping, I wanted to speak to just my colleague Pauline McNeill's amendment. However, having listened very carefully to the debate, I really want to say I can't not speak about some of the other points from some of the very considered speeches that have been made. I can't mention everyone, obviously, but I do appreciate the effort that people have put into speaking in this grouping. I want to, in particular, speak about my colleague Jackie Bailey's contribution, where she spoke about how, as legislators, we have to make sure the public has confidence in what we have done, and I think others have contributed to that. and clarity on legal obligations for particularly public bodies around the obligations in the Equality Act for both women and for transgender people, and others have mentioned that. My original contribution was talking about the fact that we have talked a great deal about obtaining a GCR, but the amendments in Polly McNeill's name in 117 and of course other contributions from members quite rightly highlight the issue as to what extent does a GRC affect the rights obtained under the Equality Act. This is the crux of much of the opposition to the bill as it has gone through, and in many cases people worrying about what will become of the rights and freedoms of women, especially in settings of refuge and treatment. The 210 Equality Act makes clear that the delivery of single-sex services, when it is proportionate and legitimate, is protected. But the bill before us seems to cloud that understanding, as we have heard, which is an outcome that benefits no one and gives no public confidence. As members have given evidence and clarified in this debate, the Equality and Human Rights Commission have said the Government have amended the 2004 Act to an extent that clarity on the operation of the 210 Equality Act is necessary. And I'm not going to go back over those arguments because they've been made very well from other people. I will do.
Liam Kerr.
Again, I think it's a very measured and interesting contribution, like Polly McNeill's one earlier, but that leads me to pose the same question to the member, that if the member doesn't see the amendments that she's calling for today, so that the ambiguity and the concerns that she's rightly articulating remain, does the member nevertheless see herself voting for it? And if so, can she help me understand why?
Carol Mochan.
I thank the member very much for that intervention. I know he has done this with other members. Can I be absolutely clear that I have come to the Chamber today to go through all of these amendments? I have spent hours and hours and hours because this is an important debate. So I will be considering every amendment, and I thank members who have indicated where they are and are not supporting, but I have been considering every amendment as we go, and I will continue to do that. One of the points that I wanted to put on record is that I have been concerned that it seems some believe even asking questions around these as we have gone through this, asking questions around these matters, and it is of itself offensive. But I want to say that I am glad tonight that we have had this debate, and I thank members here in the Chamber for being able to discuss these matters. I think that has been a very important point in terms of the public and public confidence. I would argue that the reason these matters keep being discussed and debated is precisely because we do not have clear answers on the provision, and as such we must amend the bill to reflect those interests. And so I would ask people to support amendments that contribute to that. Deputy Presiding Officer, I agree with my colleague Polly McNeill in the interpretation that the bill does not that the bill does affect the Equalities Act, or at least the operation of the Equalities Act is unclear, and people have made that point very well. And so, for me, I think it is important that we approve in this Parliament some guidance, and what would be expected is that that would be done as part of amendments to this bill. Thank you, Deputy Presiding Officer.
Thank you, Ms Mochan. I now call Graham Simpson.
Thank you very much. I think this has been a really good debate in this section, some very considered comments indeed, and I'll be supporting most of the amendments in this group. Of course, the point of having a debate in stage 3 is that you should listen, and if you hear things that persuade you, you could change your mind, and that applies to Cabinet Secretaries as well. So I hope the Cabinet Secretary has listened to the very considered points that members across the Chamber have been making and will perhaps revise her previously stated position on some of these amendments. I was inspired to stand up just now by Jeremy Balfour, actually, because he read out something that a constituent had sent him, and I've also been sent something by a constituent who has concerns about single-sex services for those who've suffered trauma resulting from particular forms of abuse or assault. And they say they have PTSD and have benefited from trauma services. I'll just read out what they say. They say, "I know how important trust is within the trauma service, both in relation to who is there with you in waiting rooms or in counselling or therapy sessions. The Equality Act allows someone with protected characteristic of gender reassignment to be excluded from a single-sex service, but the change in GLC changes the starting point." This is all their words. Everyone with a GLC would be presumed to be permitted within the single-sex service because, as the judgment last week confirms, the GLC changes a person's sex for the purposes of the Equality Act. Exclusion of those of a different biological sex but with a GLC is more difficult. And I will end it there because I think that's a very powerful contribution and it in fact is one that has been made, maybe not in such personal terms, but by many members, and that's exactly the kind of thing that the Cabinet Secretary should be addressing, and I hope she does. I hope she reflects on this debate and changes her mind.
Thank you, Mr Simpson. I now call on the Cabinet Secretary to wind up.
Thank you, Deputy Presiding Officer. Can I just first of all say that I have listened, and I think there's been some very good and thoughtful contributions, and I think, though, that it remains the case that despite some of the intent behind the amendments, that doesn't change the effect of those amendments. And someone, I think it was Jeremy Balfour, actually said that bad law is bad for Scotland, and I think that's my point. That's why I've set out my concerns about the amendments within this group. Not the issues behind some of those amendments, but the effect of those amendments, and many of which seek to unpick the 2010 Equality Act and give prominence to some parts over others, when we already have, as agreed at stage 2, a very, very clear amendment that, for the avoidance of doubt, nothing in the Equality Act changes. And I'll come back to the Equality Act in a minute. Before I do, I just want to come back to Jackie Bailey's Amendment 127. And I've said very clearly that the provision would legislate to continue the effective reserved provisions of the Equality Act and refers to circumstances which are not described in the relevant part of that Act. It's not the case that 127 reflects the words of the Equality Act, because the Equality Act doesn't refer to a GRC. So I also think it's not about trading amendments, that if if we accept 130, then Jackie Bailey won't move 127. It's about getting this legislation right and not having the law of unintended consequences by having amendments that put the bill at risk. And people will have to make a judgment based on all of that. Yes, of course.
I appreciate the Cabinet Secretary's time and what's been a lengthy debate, and I hope the Cabinet Secretary takes face value and puts some trust in what I'm about to say. At no point, and I hope the Cabinet Secretary knows this, am I trying to unpick this bill in any way or jeopardise its future. But it remains to me still quite unclear as to how improving guidance to public bodies and services and improving reporting and putting the onus of that reporting on the government physically and manifestly will unpick other pieces of legislation and put this bill at risk. And if she can answer that question, I'd be hugely grateful, because it is an issue I've struggled with. Cabinet Secretary.
So let me be very clear. Guidance and reporting are really, really important, and they're key parts of this bill, but we can only do that in relation to devolved competence. What we can't do is review the impact of the Equality Act, because that lies elsewhere and the responsibility for that lies elsewhere. However, I'm trying to go as far as I can with this, and what I have said already is that we'll work with the EHRC on guidance, and we will work with them if it helps to be clearer, to provide that clarity to public bodies. If public bodies, and I've heard quite a lot of members, just in a second, talk about public bodies requiring clarity. Now, the clarity relating to the Equality Act has to be led by the EHRC, and we've already referred to many parts, whether it's the advice to employers that they provide or the advice to public bodies. So they have to be in the lead of this. They are literally the guardians of the Equality Act. But what I'm offering to do is to work with the EHRC and indeed to help work with them to help provide that clarity. But they have to lead that process. Yes.
Daniel Johnson.
I'm very grateful to the Cabinet Secretary for giving way, but can she please provide clarity? Because if she's contending that if a bit of legislation that we pass in this Parliament refers to UK legislation and seeks definitions in terms of what is in it, that becomes incompetent, then we have got a significant number of problems in legislation we've already passed, because that is what we do all the time. Is that what she's contending, that using a definition in criminal rights on the basis of UK law is not competent?
What I'm saying is the amendment that we
before you
passed...
continue, can I just invite, I know there's a number of members that have recently come into the chamber. There are a number of conversations that are starting to get a little on the loud side. I appreciate it. I know it's been a long grouping, a long debate, but if we could bear with us for the next short while, I think that would be polite to the Cabinet Secretary and others who are contributing. Cabinet Secretary.
No, I'm not saying that, because the amendment passed at stage 2 refers to the Equality Act, but Amendment 127 goes further than that. As I've explained on a number of occasions, that's not the case that it just refers and reflects the wording of the Equality Act, because the Equality Act doesn't refer to a GRC. 127 goes much further than that, and that is why I'm asking people to consider that very, very carefully before voting on that amendment. I want to make some progress. A number of members have referred to the issue of the Equality Act and the effect of a GRC, and I want to be absolutely clear again for the avoidance of any doubt. Let me just be really, really clear about that. The provisions of the 2010 Act are not modified by the proposals in this bill. And as I said, we've agreed an amendment at stage 2 that puts that beyond doubt. The bill doesn't change the legal effects of a GRC as they are currently set out in the 2004 Act, nor does the bill change public policy around the provision of single-sex spaces and services. The Equality Act allows for the provision of single-sex services in certain circumstances and the exclusion of trans women in those circumstances where that is proportionate or a proportionate means of achieving a legitimate aim. Whether they have legally changed their gender or not, that power exists, and there are examples given in the guidance in the Equality Act that help to make that clear. And we support the provision of single-sex services. I've said that over and over again, and are clear that all organisations need to absolutely take account of the Equality Act to ensure everyone's rights are protected. And the Equality and Human Rights Commission, as I said, has published not just guidance but a statutory code of practice which assists service providers with understanding the relevant issues. I also, in terms of occupations, I laid out to Jeremy Balfour where they have got explicit advice to employers. But, as I've said, if the members feel that there is more work that needs to be done in that area, then I am absolutely prepared and keen to work with the Equality and Human Rights Commission in doing that. I also want to be very clear on this as well. I want to be really clear on this as well. And that is, just a minute, I want to be really clear on this as well. And that is that the position of the Haldane judgment is absolutely consistent with that of the Equality and Human Rights Commission. Now, members across this chamber have often cited to me the views of the Equality and Human Rights Commission, and they are, as members have said, the guardians of the Equality Act. and they have said exactly what we have said, that the purposes of the Equality Act 2010 takes into account the legal effect of a GRC obtained in accordance with the Gender Recognition Act 2004. Nothing has changed from that judgment whatsoever. That has been the position previous to the judgment, and it is the position now. I'm happy to give way.
Douglas Ross.
I'm very grateful to the Cabinet Secretary for giving way. I understand she was reading from her notes, but my colleague Sue Webber has twice tried to... No, I'm just saying the Cabinet Secretary couldn't have seen a message that came up on the screen. I hope we can maybe look at a process where the presiding officer could indicate, but would the Cabinet Secretary take a virtual point from my colleague Sue Webber, who has now tried to intervene?
Cabinet Secretary.
Happy to do that if there's a virtual point of order, if that would be helpful from Sue Webber. Yes.
I think it would be up to Sue Webber as to whether or not she wants to press for another intervention. It's not for the chair to indicate, as we would not indicate.
Okay. Yeah. Right.
Intervention, yes. Sue Webber.
Thank you, Presiding Officer, and thank you, Cabinet Secretary, for taking my intervention. I was wondering if you could give us some examples, specific examples, of where it is proportionate to discriminate against those with a gender recognition certificate for the purposes of providing a single-sex service.
Cabinet Secretary.
Happy to do that, because in the Equality Act 2010, in the guidance, the specific example that is given is if there is a service that provides support to victims of sexual assault, for example, then they say that is absolutely valid and proportionate to exclude trans women, whether or not they have a gender recognition certificate. So I hope that answers Sue Webber's point. Now, the guidance is there to help organisations to address the circumstances of where that is proportionate. And the guidance, the revised guidance, goes into a lot of detail in recognition that sometimes some organisations may have challenges with that. I want to make some progress on the guidance. The guidance, and I should say again that the Scottish Government guidance in law would make that statutory guidance, and I think it was Claire Baker asked what aspects of the Act were covered by the guidance. All aspects of this bill will be covered by the guidance. Also, we've committed to review Section 22 already. Previously, we committed to review that, and the guidance will cover the operation of the Act, including Section 22. So I hope that gives some assurance to Claire Baker. Polly McNeill referenced a number of things, one of which was the UK Government Women and Equalities Committee. And of course, though, that committee reviewed these issues in some detail, and of course they themselves concluded that the UK system should be reformed along the lines of what this bill seeks to do. And I think that is important to note. Presiding Officer, there have been many issues comments made around areas surrounding this bill. And I just want to say this. I have listened to organisations both for and against this bill. I've met with women's organisations who are for and against this bill. And of course, it's worth noting that many of the women's organisations that are providing services to some of our most vulnerable women actually support this bill, and that's important to note. And I just want to end on this as well. I've been in this Parliament for near on 20 years now, and I want to say this, that at the heart of many of the policies and legislation that this Parliament has given its attention to has been absolutely the protection of women and girls, whether that's through legislation on domestic abuse, whether it's through our groundbreaking Equally Safe strategy. And in fact, the work on the misogyny legislation is underway, and they're going to consult on that very soon indeed. So I think it is fair, I will in a minute, I think it is absolutely the case that women across this chamber, previous, current and I'm sure future, have put the safety and the interests of women and girls at the heart of the work that this Parliament carries out. I'll give
Bailey. Jackie Bailey.
Can I absolutely agree with the point made by the Cabinet Secretary? Successive governments have indeed done as she describes, which is why I'm genuinely confused as to why she won't support Amendment 130, because she agrees that these are the provisions in the Equality Act that she supports. She outlined them. They do no more than repeat those, and these are the very issues that a lot of women and a lot of women's organisations have said they have concerns about. So in the spirit of what she said, surely we can approve 130.
Let me be really clear with Jackie Bailey. I absolutely accept the intent behind her amendment. But the intent behind her amendment and what she seeks to achieve is already covered in the amendment agreed at stage 2, that for the avoidance of doubt, absolutely nothing in the Equality Act is affected by this bill. And I cannot be clearer than that. And I would have thought, as a point of unity, we could agree that to reinforce that, because we don't want people to be concerned about something that in reality is not the case. Even if we wanted to, which we do not want to do, we wanted to somehow change aspects of the Equality Act. We are not able to do that. We don't have the competence to do that. And so let me just be absolutely clear, for the avoidance of doubt again. The Equality Act protections are absolutely fundamental here. Single-sex exceptions are absolutely guaranteed in the same way as they have been since the 2010 Act came into being. I have no intention, and my government has no intention, and this bill has no intention of changing that whatsoever. And I hope that members will support my Amendment 54 and vote against the other amendments in this group.
Thank you, Cabinet Secretary. The question is that Amendment 54 be agreed. Are we all agreed? Point of order, Douglas Ross.
I'm grateful, Deputy Presiding Officer. Before we come to the votes on this group of amendments, the Presiding Officer earlier ruled on the proposal for a manuscript amendment from my colleague Rachel Hamilton. The consideration of the Presiding Officer lasted from 2:53 to 4:08, at 1 hour and 15 minutes, which I welcome. This was clearly a very difficult choice for the Presiding Officer. Indeed, she said in her ruling that she accepts that this amendment could not have been lodged before the deadline. It therefore came down to the opportunity to lodge a manuscript amendment earlier than today. I've looked at the standing orders of this Parliament, and there is nothing in the standing order concerning manuscript amendments about a timing for introducing that. So was the Presiding Officer's ruling that it should have been earlier today, yesterday, or at what point from 12 noon on Tuesday when the ruling was made by Lady Haldane? I also note that the committee this Parliament has asked to scrutinise this bill did not seek to have an emergency session on Lady Haldane's ruling. The committee was able to have an emergency session in the intervening period, and one of the witnesses who was brought forward by the committee had already given evidence. And I find it strange that someone could be asked to come back to give evidence in that time when we couldn't look at this important ruling. Therefore, I wonder, Presiding Officer, before we enter the votes on this issue, if you could confirm if the Presiding Officer had considered the fact that the committee had not had an extra session on this ruling, and if you are able to confirm that from the Presiding Officer. And could I, through you, Deputy Presiding Officer, repeat my offer and indeed my request to the First Minister, who's in the chamber right now. If the Presiding Officer's ruling on such a crucial issue rests on the fact that we have to get through amendments today, and the timing therefore led the Presiding Officer to make this difficult decision, surely the First Minister could meet with myself and other party leaders to look at scheduling the remainder of this debate on amendments and the Stage 3 debate early in the new year, so this Parliament can be fully apprised of all the points before it votes on this issue.
Thank you, Mr Ross. I think the presiding officer made her position entirely clear. She explained the basis on which that decision was taken, and I'm sure, as an experienced parliamentarian, you would not be challenging the ruling of the presiding officer. Can I... Sorry, this doesn't need the applause of other members in the chamber, I have to say. It will also, you'll be aware, Mr Ross, that business managers are due to meet very, very shortly to discuss the remaining business this evening. And that, Mr Ross, I have taken the point of order. If this is a repeat of the same point of order, I have nothing further to add, and I would warn you that you are at risk of challenging a ruling by the presiding officer. Mr Ross.
And I hope you will see I am not trying to do that, and I made it very clear I was not doing that. But I did ask to allow me, as a member of this Parliament, to understand that the ruling that the presiding officer made, was she aware of the fact that the committee we have tasked to scrutinise and take this bill up to this point had not had the opportunity...
Mr Ross, could you please resume your seat? As I've explained, the presiding officer gave her ruling, she explained the basis of it, and as you yourself acknowledge, some time was taken in arriving in that decision and coming forward with her ruling. On that basis, it is time to move on. The question is that Amendment 54 be... Are you challenging the...
No, I'm saying further to...
Could you please resume your seat, Mr Ross? I have warned you about challenging the decisions of the Chair. Your previous attempt at a point of order was simply a repeat of the earlier one, and I've already pointed out to you that that bordered on challenging the ruling and the decision made by the presiding officer. If this is a different point, I'll invite you to make it, Mr Ross. But I would stress very strongly that you are skirting close to being in contempt of the Parliament by calling into question a ruling by the presiding officer. Mr Ross.
I'm grateful for you allowing this subsequent point of order, but I am simply trying to get all the facts as a member of this Parliament who is just about to vote on this issue. So are you able to confirm or otherwise if the presiding officer considered the point about the committee that is scrutinising this bill when she made her ruling? I'm simply asking for that information, not challenging the ruling that was made.
Mr Ross, there was nothing further in that contribution to what you'd asked in your previous two contributions. We are going to move on to the question that Amendment 54 be agreed. Are we all agreed? We are not agreed. Okay. Right, we are in the middle of a division. I will take the point of order after the division. Please resume your seat, Ms McCall. The question is that Amendment 54 be agreed. Are we all agreed? We are not agreed. There will be a division and members should cast their votes now.
They're getting a bit busy, aren't they? It's good. They're literally trying to delay it over and over again.
Okay, the earlier vote had already started by the time I called it. Therefore, we're going to rerun the vote to ensure that nobody that was attempting to vote has an opportunity to vote. The question is Amendment 54 be agreed, and members should cast their votes now.
I'm sorry. Microphone.
Okay, I can advise the Chamber that we are going to attempt to run that vote again. Members should cast their votes now.
They were very. Why is it so loud? Is it loud, Critical Cupcake? Wow.
And the vote is closed. The result of the vote on amendment number 54 in the name of Shona Robertson is yes 94, no 31. There were no abstentions. That amendment is therefore agreed. I'll take a point of order from Ros McCall.
Thank you. Oh, there we go. Thank you, Presiding Officer. I'm just trying to get some clarity, if I may. During Group 13's debate, we extended the business for 2 hours. You'll know after these amendments, and the programme suggests that we've got over an hour of portfolio questions, then 2 hours of debate, followed by decision time. Now, I previously mentioned in this chamber that I am the carer of my husband, and I made arrangements yesterday and today so that he was taken care of. And I did that for a time that was meant to finish about 6:30, which brings me to my questions, and there's a couple. Will you be making more extensions to business tonight? If so, when will we have that information so that I can make extra arrangements? And lastly, I can't help but notice that I'm the third member to raise the impact of this sort of thing on family and carers this week. So will you consider keeping decision time at an earlier, more convenient time than we've experienced over the last couple of days? And I thank you for taking the point of order.
Thank you very much for that point of order, Ms McCall. It echoes earlier points of order. I think, as I said previously in response to that point of order, that is a point that the presiding officer has underscored on numerous occasions with business managers. I can advise you and the rest of the chamber that business managers will be meeting after the next vote. I'm sure they'll be seized of the points that you have just made. And further to that meeting of the business managers, I would hope that the chamber can be advised on any decisions arising from that. But thank you very much indeed. With that, we move on to, I call Amendment 111 in the name of Jackie Bailey, already debated with Amendment 54. Jackie Bailey, to move or not move?
Moved.
The question is that Amendment 111 be agreed. Are we all agreed? We are not agreed. There will be a division and members should cast their votes now.
I think, based on what she just said, I think we might have another 3 hours. And I think the last 2 hours will be open debate, which might be, probably the most interesting bit of the day, although I think it's likely to be just disingenuous. I was trying to be polite.
So there you go, trying to be polite again.
And the vote is closed. Okay, the result of the vote on amendment number 111 in the name of Jackie Bailey is yes 58, no 65. There were 2 abstentions. The amendment is therefore not agreed. As I just advised Ms McCall and the Chamber, there will be a short suspension now to allow both a comfort break and business managers to meet. The bell will sound when we're about to resume. Thank you.
Right, I'm going to take this opportunity to run away and use the bathroom and sort myself out. Feel free to entertain people. Can you do a dance? We'll be back soon. I'm assuming they're going to be 20 minutes at least, probably half an hour. But for all I know, it could be 5 minutes.
No, I can't do a dance.
I bet you could.
I'm not going to, though. I need a second human being here to help me put these monitors on this new stand.
Oh, when I had to put these monitors, these are 2 24-inch 4K monitors, and it's a balancing stand. So trying to get one on one side and one on the other, I ended up putting it flat. So I had the monitors flat on the desk, and then put the stand on it, and then had to get Caroline to help me lift it up.
Well, I had to mount the arms to the desk. I had to drill a hole through it because of the way it's constructed. The little screw-on brackets wouldn't work. It was quite secure. Just had no idea how I'm going to do a monitor swap. I can't because I have to unplug them, and I'm not willing to do that right now. But I'm ready to. Go to that.
Oh, right. I shall be back in.
You could start a little video or something.
I was thinking about that. I just don't know what I could put on. I was thinking about putting something on.
Well, I think it's only you and I, so just go to the bathroom. Nobody will ask.
Fair enough.
I'll sit here and smoke a cigarette and drink coffee later on. See if anybody in the chat's still there. You're still here. Go away. It seems like we interrupt this broadcast. So Parliament can take a bathroom break. All fisticuffs should be isolated in the potty area, please. That's where you can get into a pissing match and it's easier to clean it up. Oh, I'm terrible. I see you playing with things on the screen. I'm not a dad jokes. Okay, let's see. Oh my goodness. Well, in the news, there are at least 2 other people in the community streaming. Somehow I doubt they're covering the Scottish Parliament. And here I am once again stuck talking to myself. Thank me, I just stopped myself from starting to sing. I'm not going to dance. I'm not even sure where my camera is pointed right now. Let's find out. It's probably up at the wall. Oh, nope, it's right there next to me. Oops. Once upon a time, a long, long time ago, we lived in a more natural state than we do today. Life was harder then. I wonder, oh, I probably put on some music for you guys. I do have a sound subscription to Epidemic Sound. I'm not going to get this finished today. I've got to run chords. Critical cupcake. Don't forget to flush and leave a quarter. I don't think I can do this alone. Disappointing.
I in no way. I'm back.
But are you back live?
Kind of. I in no way tried to shout at my phone to respond to you. Oh, right. Well, they aren't very interesting, are they?
Feeling better out than in, is it?
Oh, God, I'm cold. Temperature is it here? Right, why is this in the wrong place?
Did you see my note?
Which one? Welcome to the Sound of Silence.
About how cold it's going to get here this weekend?
Yes. No. I don't know.
It's supposed to get down to -1. I did it at -9. It was not any fun.
-9?
That's our scale. I got seen at -9.
Oh, in your scale?
Down to -1. Yeah, -1, my scale, which is -18 on yours. I have to scroll back up through the chat and it's not there anymore. Freeze our little tushies off.
How good's your insulation? Now that the mice have stolen it all.
Oh no, honey, you got massive sections in my roof dome where I had the roof repaired where they put the insulation out. There is no insulation in those triangles.
Oh.
I still haven't had anybody come out, pull the sheetrock down, and put it back in so I can put fresh sheetrock up that doesn't have mold on it. I'd be doing it myself in one section, and the other requires the scaffolding from the basement.
See, I feel the way yours is a dome, that you should have a kind of a handrail and be able to walk up it in a spiral.
That would be lovely. Would you like to pay for it? I'm going to hide behind my microphone.
Oh, you're on? I didn't even notice. Hello. Not that my connection is enough to, do it. You just go jerky. I didn't even notice you turned you. How long has your camera been on?
Just a few seconds, I'm going to turn it off because it is so jerky.
Oh.
You can keep it. All right, so fiber optic.
Right, that roboted completely. I didn't get a word of it.
Fiber optics.
Nope, still again. I hate this connection.
I said, what will it take? Can you hear me?
Yes.
What will it take to get you on fiber optics?
I've got to. I don't know. I need to argue with BT or find another company. We had another company we were going to go with. What I need to do is to phone BT up and find out what it'll cost to do a generic thing that will transfer the IPs over. Part of me is tempted just to go with their package, forget the IPs, and keep both. But I think it's too expensive to. I can't just. It's not even that it's too expensive. I can't justify it.
Oh, I understand.
If I still had the other place has only got 2 IP addresses available to it, which is not enough for all the servers. If I still had Windows machines there, I might have been able to move a load of stuff over and scrap the other stuff. But this is the problem. The problem is it's a massive headache, and I'm not convinced I'm up to dealing with it. That's what's stopping it, not anything else.
Well, A massive headache would stop me in my tracks.
Oh. What is Katie up to?
Are you going to keep the stream going?
Say again?
Are you going to keep the stream going?
I'm going to keep the stream. I'll keep the stream going until my back stops screaming. It's funny. I'm starting to wonder now if the reason that I had the stuff with the stream. Right, when I had the quiz live, I only used the Vodafone stuff for outgoing to do the stream. The inbound, I did over the internet connection, over the normal internet connection, because the download speed is not terrible. It's not great, but it's not terrible. Okay, so that's why I got a reasonable signal from people, and I think this might have always, the entire time I was streaming, I think this. Now, obviously, you know why I can't do that now with you. Do you?
Do I know why you can't do that now with me?
Yeah, why I can't have the StreamYard. The reason that StreamYard is so terrible and the reason the stream from Scotland is so terrible is because of Windows 11. Windows 11 is networking is so broken that you can't route to two different places. I can't have inbound from everywhere and outbound just to YouTube out through the mobile, which is what I always did. That's how I ran the stream and was able. The fact that I managed to hold together that stream is beyond me now that I'm struggling so much with it. Oh, don't do that.
I think I have no idea.
Say again?
I have no idea.
No, it's roboting really badly.
Your feeds are so much more complex than mine.
Nope.
No.
No, I didn't hear you. It broke up.
I said your feeds for your streams are so much more complex than mine.
Yes, you could just click and go live.
Well, I'm not fancy like you are, darling.
Oh. What I should have done. The problem is I can't remember trying it. What I should have done is what I did with the Ukraine streams and tried to run the stream from somewhere else with just me being sent from here.
Okay.
And then you would have come in there and I should have been able to. That should have worked. Oh.
Well, if you get a wild hair up your behind again, you can try it a different way.
I mean, they're talking at the moment as to whether or not this bill is going to get put off till tomorrow. As to whether or not that.
And you're nowhere near wrapping up. Might as well put it off until tomorrow.
The problem is, I think they're going to try. I think that all these delaying tactics that they've done, I think they're going to try again tomorrow and the next day and the next day. I don't think that putting it off is necessarily a good idea.
Gotcha. I understand.
They're arseholes. Oh, why do they have to be such arseholes about this? Make sure you're still live. You are. Christmas time. People are freaking out about about last night's question.
What was? Hold on, let me go.
Last night's was, would you rather have hair made of spaghetti or sweet maple
that
or
one,
sweet
yeah.
maple syrup?
Yeah, I can do it. I don't like spaghetti much, but I don't want to be eaten by ants.
No, I'm going to have to put my game on again. No.
New game, I'm going to move for a minute. I have to go to another game for a minute.
I forgot what it's called. Pirates? No. Zombie something? The problem with the game is it's too, my brain can't go as fast as the game anymore.
I don't know. You were doing pretty good to me. Is that the zombie game you were telling me about the other day?
Yeah, Plants vs Zombies. But the worst thing is it's terrible. I've got another monitor to put it on, but I have the thing to arrive today. Why are people arguing on Twitter?
You have to do that, but I'm just
Breaking up again. Oh, why is my connection so shit?
Maybe it's my connection.
It really isn't. I just know it's not. Shall I put the sound on? Oh. There are now digging zombies, but no flying zombies.
Get the world at large.
Say again?
You can't see me moving around the
The fact that you can hear that is somewhat disturbing. I wonder if you're echoing on the stream. 2 seconds. Can you tell me? No. I wonder if you... Oh, I'll put my headphones on. That'll solve the problem. But then you might not be able to hear that music. Well, you don't need to. I don't know if you'll hear it or not. Oh, Say something?
You want me to say something?
Yes.
Okay, saying something.
I
have no clue. I have no clue what it sounds like from your end.
Okay, now I've got music again.
No. Which one?
So can you hear the game music now?
No.
That's the problem with turning my speakers off.
But I also don't have the YouTube stream volume up high.
No, you wouldn't.
So I don't know whether they can hear it on the stream or not. That's what I'm saying. I was listening to Parliament on the link.
No, they should be able to hear it on the stream. It goes because they can hear you, so it goes in the same way. Which is why I can't feed it back easily. Because if I feed it back, it would just echo massively to you. You'd hear
Yeah, we don't want that. I don't need to hear the noise from that game anyway. Noises from the games are probably one of the reasons I don't play them.
Should we try them? They're cheap. Oh, we have a spam man.
Great. I got him.
Yeah. We don't have balloons. We have blowy up things.
Actually, still working the box, but I'm getting bored anymore.
Oh, I have no idea what I'm doing. Let's try that. Brains?
Where?
In America.
Prove it.
I can prove at least one. The rest are up to you.
Which one can you prove?
Yours.
Oh, that sounds like a fallacy to me. Pain in the butt these remotes are when you're not attached to the monitors. They're in the way. I can't see shit.
Shite, I didn't want to do that.
Oh, now I see where everybody is. They're all over there hanging out.
I accidentally moved all the smoke out the way.
Oops. I have absolutely no clue what this game does.
Well, we're plants and the zombies are attacking us. Say again?
Is this smoke protecting you?
No, no, it's getting in the way intentionally. That's his job. Oh, shit.
It's not easy to watch.
Say again?
It's not easy to watch. It's not easy to watch you gameplay in laptop.
No, I didn't get that. It was up too much.
said, it's difficult to understand what's going on and the extreme lack of time.
See everything for a minute.
Be nice if they just come back or not.
Say again?
It would be nice to tell us if they're actually coming back or not.
Well, I'm assuming they've got to come back. Even if they decide to cancel, they'll come back and tell us.
So explain to me again the situation with these bills.
Right.
Not sure I understand.
The Gender Recognition Act is built on the back of the Equality Act.
The Equality Act was supposed to give everybody equal rights.
It does, but it has certain protected characteristics that are based upon.
Okay.
So that basically every attempt to all this is doing at the moment, the Gender Recognition Act recognises that someone's transgender and they can apply for a Gender Recognition Act to acknowledge their switch in gender that will allow them to update their birth certificate and passport and things like that. Not your passport, but your birth certificate and how you're treated when you die and things like that.
Not your passport?
No, your passport you can do anyway. Lots of things. Listen, you don't need this for lots of things. You just need it for some very specific things. I think their main ones are you need it to get married as your chosen gender. You need it for how you're treated when you die, and to have your birth certificate changed. I think. Don't quote me. And the problem, and right now, to do this process requires a medical diagnosis to live as your gender for 2 years and multiple psychologist reports, I think. It's right now it's complicated. It's like a 50-page form that requires evidence from medical professionals. All right. Now, what the Scottish is trying to do is to modify this so it doesn't. So it requires 3 months and does not require medical any medicalisation of it, which is basically what it is in most other places where they've implemented this. And this is it. That's all they're trying to do. So the legislation for these certificates is already there.
Oh my.
It's already implemented. It's already been sorted with how it conflicts with the where and how it conflicts with the Equality Act. All this is done. But they're trying to use that to stop it because they don't want this. But the problem is, it's not that they don't want this. They don't give a shit about this. They want this bill repealed altogether. They want the GRA scrapped. They don't think there should be any acknowledgement whatsoever. And but they're trying to sabotage these changes because they don't want it overall. This is why it's very disingenuous. Yeah, they will do anything they can to try and get rid of it, rather than be in any way constructive. And it's why they're coming up with these ridiculous arguments. But firstly, they think they can get people angry. Yeah.
Yeah.
And they're not wrong. It works to get people angry. And the way they ask loaded questions, again, to get people angry. It's ridiculous that they're doing this, but they just don't want to be seen to be being reasonable to something they want to scrap.
Sorry about that.
That's okay.
No, the delivery truck
Nah, I broke up. My connection is for shit.
Good. You need your lucky barking.
Say again?
You did not hear lucky barking.
No, I did hear Lucky Barking.
Oh, you did.
That was crystal clear. I didn't hear any of that old robot. Have you tried barking? Oh, there we go. What's that? Nothing. How long have we been gone for now? Oh, am I still running that? Let's stop that. Right. Oh.
Been a long time. 6 hours ago, we started streaming. Can you
say again?
6 hours.
The stream's been going for 6 hours. How long have they been out at recess?
I don't know. You started streaming 6 hours ago.
That feels like forever ago.
No, at least a half hour.
Oh, I'd have thought they'd be back by now. 35 minutes.
Feels like a half hour.
I could have taken longer.
Maybe mine cuts out because I'm not speaking on it.
No, that broke up completely.
I said maybe it goes funky because I'm not speaking on it that much.
No, it went. Okay, with that, they're asking Pickleby.
Yeah.
It's not your microphone. And someone says here, the Tory position is quite interesting. They believe the GRA reform bill debate is taking up too much of Parliament's time, while also believing that the GRA is being rushed through without discussion. I don't know. No, I couldn't work that one out.
So
you sound like, okay, I can't hear any of that. It sounds like you're Shogun from Portal. The worst thing is I bet if I logged in on my phone, I could hear you on my phone. I'm wondering whether or not my microphone would pick it up and it would work that way. I can put it in my ear. Oh, fantastic. Scottish Conservatives, the only party with a clear majority of MSPs opposed to the gender reform bill. Say again? Nope, go on here. Oh, make the connection. Why would you not work for me? maybe they're having drinks. They are having drinks. They had. It was a comfort break, which to them is going to the bar and getting drinks. So they'll all come back drunk. I'm going to play back a bit, see how it's almost certainly robotic. I'd be intrigued to know if it's echoing. I'm coming to, yeah, because it's going one way. It's the inbound stuff that it's struggling with. Which if I wasn't on Windows 11, it would work. Wow, they're going fast. What do we get now? Right, a pumpkin protects plants that are within its shell. Oh, seems like a good idea. I should have a go and see if they fixed it, but I can't think. I bet you they haven't.
Fixed it.
Say again?
Fixed what?
The networking, so that I could have working like I used to have it, so that the stream goes out via the mobile, but the inbound is via the normal connection. Right, there's news here. I'm being told that the two parties that are against debating the bill into the night are the Tories and Labour. However, the government wants to keep Labour on side, so we might get cancelled for tonight, which is really annoying because I've got stuff. No, I might be back home by tomorrow. Oh shit! I've got to be up early tomorrow, actually. How very annoying!
Maybe you should go to bed. It is getting. It's not that late.
It's only it's 10 to 8. I mean, the biggest issue is I've been sat here all day. When I actually lie down, my back is just gonna. Oh, we're back.
Are we? Oh, we are. I hear it. Good, baby.
Before we resume consideration of amendments, I'm going to use my powers under Rule 9.8.5b to take a motion to approve an SSI at this point. And I therefore invite George Adam, on behalf of the Parliamentary Bureau, to move motion S6M 07734 on approval of an SSI.
And happily moved, Presiding Officer.
Thank you, Minister. The question is that motion S6M 07734 be agreed to. Are we all agreed? We are agreed. I can also inform the Chamber that business managers have agreed to move items of business other than consideration of Stage 3 amendments to tomorrow afternoon, and a business motion to give effect to that will be taken at the conclusion of proceedings on amendments.
We now move to Group 14, copying of certificates to other registrars general. And I call Amendment 55 in the name of the Cabinet Secretary in a group on its own. The Cabinet Secretary to move and speak to Amendment 55.
Thanks, Presiding Officer. This amendment in my name removes Section 12, which requires copies of gender recognition certificates to be given to other Registrar Generals in the UK so they can update register entries as required. So if the UK Government decides not to update English and Welsh birth certificates on the basis of a GRC issued in Scotland, there can be no need for the requirement to send copies. This amendment essentially future-proofs the bill against that possibility. Whether or not... yes.
Michael Mara.
Thank the Cabinet Secretary for giving way. I'd just like to take this opportunity to clarify a point raised in a briefing that was received by MSPs from Murray, Blackburn, Mackenzie. They say that it's unclear whether or not the bill in front of us removes access to the UK Gender Recognition Panel for people living in Scotland. So I just want some clarity, if the Minister is able to provide that to the Chamber, whether or not people living in Scotland will continue to be able to obtain a GRC from the UK Gender Recognition Panel, or will that route be closed?
Cabinet Secretary.
Well, they will until this bill and act is in place, because obviously there will be a delay until commencement, and up until that point, that route, of course, will be open to people, and then the new route will be open to people once this legislation is enacted. Provision for... Sorry, this is another important point I should make. Whether or not register entries in the rest of the UK will be updated is a matter, of course, for the UK and Northern Irish governments. Provision for sharing GRCs can still be made in a Section 104 order if agreed. And on Monday, I met with the UK Minister for Equalities, Kemi Badenoch, where we agreed to continue to work constructively together on these matters, and I'm sure that will continue to be the case. And I move Amendment 55.
Thank you. I call Jeremy Balfour.
Thank you, President Officer, and I can thank the Cabinet Secretary for the information shared so far. I am tentatively wanting to support this provision, as I notice it's in the Gender Recognition Act 2004. So presumably it is not necessary to replicate this provision in this bill. However, I would like to get some clarity if that is the reason for the removal of this provision from the face of this bill. So I would be grateful if the Cabinet Secretary can confirm that this, or if it is being removed for another reason. For example, is the entire provision of copying gender recognition certificates no longer deemed necessary due to technology? And if that is the case, could the Cabinet Secretary confirm that she has spoken to each Registrar General across the United Kingdom to confirm that this is the case? I hope the Cabinet Secretary can provide clarity to the public and myself with these answers before we vote on this amendment.
Cabinet Secretary.
Well, as I say, the reason for this is to future-proof this bill against the possibility that the UK Government may decide not to recognise Scottish GRC. So it's just a practical measure to take if that's the case. I should add, I hope that that's not the case, and I hope that the UK Government will decide to recognise GRCs, but we have to make this provision just in case they do not. Now, provision for sharing GRCs can still be made in a Section 104 order if agreed, and I know that officials from the Scottish Government and the UK Government have actually been working very closely and very constructively for a number of months around some of these issues. So I hope that provides some clarity to Jeremy Balfour.
Thank you. The question is that Amendment 55 be agreed to. Are we all agreed? We are not agreed. There will be a division and members should cast their votes now.
Right. So we are going to get the rest of the amendments tonight. We are going to get the final debate and vote on the overall thing tomorrow night. Tomorrow daytime. Afternoon? Sometime tomorrow.
At the risk of roboting, are you
Yes.
going to try to cover it tomorrow?
Assuming it's not, assuming it's in the afternoon, starts in the afternoon. Yes, I will. Well, I don't. Okay, this is the problem. If I can, I will. I don't have anything else on, but I'm killing myself being here now. So I don't know how I'll be tomorrow.
Yeah. Well, do it at your own pace, honey. Don't put it on anybody else's account.
But I'll have a look in the morning when I get back from electrolysis to see whether or not they fixed the bug with Windows 11, to see whether or not. Because if I could get the stream going out one way and StreamYard on the other, the roboting, all of that goes away, and the stream can be better quality. It's all better.
2000 hours. The result of the vote on amendment number 55 in the name of Shona Robison is yes, 119, no 3. There were 4 abstentions. The amendment is therefore agreed. I call amendment 112 in the name of Ash Regan, already debated with amendment 54. Ash Regan, to move or not move?
Not moved.
Thank you. I call amendment 113 in the name of Ash Regan, already debated with amendment 54. Ash Regan, to move or not move? The question is that amendment 113 be agreed to. Are we all agreed? The Parliament is not agreed, therefore we'll move to a division and members should cast their votes now.
It's very annoying that they don't agree when they know they're going to lose. Although saying that, I do like that it only takes 45 seconds to vote now.
The vote is closed. The result of the vote on amendment number 113 in the name of Ash Regan is yes 60, no 66. There were no abstentions. The amendment is therefore not agreed. I call amendment 114 in the name of Jamie Green, already debated with amendment 108. Jamie Green, to move or not move?
Moved.
The question is that amendment 114 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now.
Say again?
Was that last?
No, I don't hear.
I lost track of the amendment. I was wondering if that last one was good or bad vote.
It's roboting too badly, sorry.
Fuck a duck.
See, now why did that come through?
Because it just wants to be me. That last vote good or bad?
The vote is closed. The result of the vote on amendment number 114 in the name of Jamie Green is yes 98, no 14. There were 14 abstentions. The amendment is therefore agreed. I call Amendment 115 in the name of Jamie Green, already debated, with Amendment 108. Jamie Green, to move or not move?
Moved.
The question is that Amendment 115 be agreed to.
I don't know what
Are
these
we
amendments
all
are,
agreed?
so I don't know if they're good or bad. I'm not from what I'm seeing on Twitter. No
The
one's
Parliament
screaming
is
about
not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 115 in the name of Jamie Green is yes 100, no 10. There were 17 abstentions. The amendment is therefore agreed. I call amendment 116 in the name of Rachel Hamilton, already debated, with amendment 108. Rachel Hamilton, to move or not move?
Not moved.
Ooh.
Not moved. The amendment is being moved. The question is that Amendment 116 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now.
I wonder how many more amendments there are tonight. They want to get all the amendments finished tonight.
The vote is closed. The result of the vote on amendment number 116 in the name of Rachel Hamilton is yes 37, no 76. There were 12 abstentions. The amendment is therefore not agreed. I call amendment 117 in the name of Pauline McNeill, already debated, with amendment 54. Pauline McNeill, to move or not move?
Moved.
The question is that amendment 117 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now.
I've eaten all the biscuits. The last packet of biscuits. You've not eaten today. I've eaten too much today. I'm very worried about my weight this evening. and I don't think I want to look at my weight again until after we've done what we do next week. Something distracted me. It was the monitor stand arriving. Oh, I see. The reason the vote before went weird was the person that had created the amendment said she wasn't going to move it, but the rest of the Tory benches then moved it. Hand over those biscuits.
The vote is closed.
The problem with that is they're all gone. Completely. Oh, I'm wrong. I do not have electrolysis tomorrow.
The result of the vote on amendment number 117 in the name of Polly McNeill is yes 59, no 67. There was one abstention. The amendment is therefore not agreed. I call amendment 118 in the name of Claire Baker, already debated with amendment 54. Claire Baker, to move or not move?
Moved.
The question is that amendment 118 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 118 in the name of Claire Baker is yes 57, no 70. There were no abstentions. The amendment is therefore not agreed. I call amendment 119 in the name of Claire Baker, already debated with amendment 54. Claire Baker, to move or not move?
Moved.
The question is that amendment 119 be agreed to. Are we all agreed? Yes. Parliament is not agreed and members should cast their votes now.
Is this the final group, I wonder? Or doubts?
The vote is closed. I call Jamie Halcrow-Johnston for a point of order.
Thank you, Presiding Officer. Sorry, my app wouldn't refresh. I would have voted yes.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 119 in the name of Claire Baker is yes 56, no 70. There was one abstention. The amendment is therefore not agreed. I call amendment 120 in the name of Rachel Hamilton, already debated with amendment 54. Rachel Hamilton, to move or not move?
Moved.
The question is that Amendment 120 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now.
Yes, pretty much all of them are at the moment. I think the first one might have been the government one, and the rest are ruining ones.
The vote is closed. Point of order, Jeremy Balfour.
App didn't load. I would have voted yes.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 120 in the name of Rachel Hamilton is yes 59, no 67. There was one abstention. The amendment is therefore not agreed. I call amendment 121 in the name of Rachel Hamilton, already debated, with amendment 54. Rachel Hamilton, to move or not move?
Moved.
The question is that amendment 121 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 121 in the name of Rachel Hamilton is yes 59, no 67. There was one abstention. The amendment is therefore not agreed. We move to Group 15, Review of the Act. I call Amendment 56 in the name of Jackie Bailey, grouped with amendments as shown in the groupings. Jackie Bailey to move Amendment 56 and speak to all amendments in the group.
Thank you very much, Presiding Officer. I am hopeful for success with these amendments, not least because I worked with the Government to deliver them. At Stage 2, the Equalities Committee agreed a number of amendments from MSPs of different parties. The purpose of these amendments was to review elements of the bill and any impact which the changes to the process for applying for a gender recognition certificate may have made. This included an amendment lodged by my colleague Pam Duncan-Glancy, which placed a duty on ministers to initiate a review within 3 years of the bill coming into force, and it also covered a number of issues, including the need to review the operation of Section 22 of the 2004 Act. The Cabinet Secretary said in accepting the amendment that this could form the basis of incorporating other review items at Stage 3, including those that were agreed at Stage 2. The Scottish Government has worked with members across the Chamber to develop this set of amendments which bring together all the strands of review. Using the new Section 15B of the bill as amended as a base, this creates a single provision review, and I'm happy to move them all in my name. Amendments brought forward by other members and agreed at stage 2 are all incorporated into this overarching provision. So Jamie Green's amendments, which place the duty on ministers to report on the impact of this Act on the placement of transgender people in prison, are included. Claire Baker's amendment requiring a review of the operation of Section 22 is included, as is Pam Duncan-Glancy's amendment, which already contained a related provision. An amendment from Maggie Chapman, which requires a review of the impact on trans people of the time periods for living in the acquired gender and the reflection period, is also included. Amendments 56, 60 and 91 removes those individual provisions and replaces them with the new single provision covered by Amendments 82, 83 and 84 and adds gender identity healthcare whilst not changing the intent of those agreed amendments. My other amendments strengthen the existing provision added by Pam Duncan-Glancy and reflect the views of members across the Chamber. Amendment 85, 86 and 87 extend the scope of the review beyond that currently required by Section 15B. The additional areas covered by these amendments were asked for specifically by Labour members and include the impact on the provision of services by Scottish public authorities, whether any other amendments to the 2004 Act are appropriate, and whether any changes to the guidance required by Amendment 54 are also appropriate. Amendment 90 provides for a number of items that the report of the review must set out, including any changes that Scottish ministers consider that it would be appropriate to make to the time periods required by the bill, both before and after an application is made, the age at which a person can apply, and the process for 16 and 17-year-old applicants. Amendment 76 varies the wording of Section 15B in relation to the timing of the review. The bill currently requires Scottish ministers to begin the review no later than 3 years after Section 2 comes into force. This would be altered to be as soon as practicable after the end of the period of 3 years, beginning with the date on which Section 2 comes into force. This is to ensure that 3 full years' worth of data is available for the review to examine and provide Scottish ministers with a little flexibility in the case of unforeseen circumstances which could prevent the review from starting. Amendment 78 expressly sets out that in carrying out the proposed review, Scottish ministers must have regard to any data provided to them about the effect of a person obtaining a gender recognition certificate. The amendments also include that the review will include any other steps that ministers intend to take as a result of the review. The review may, of course, include further matters not explicitly covered here, but must, as a minimum, cover these items. The existing provision in the bill that the Registrar General is not required to publish information if it risks identifying an individual who has applied for a GRC will also still apply. Amendments 75, 77, 79, 80, 81 and 89 are largely tidying amendments which are necessary to make the section read correctly as a whole. These amendments, Presiding Officer, bring together a wide range of areas which must be reported on when the bill is commenced. They are comprehensive and collectively reflect the views of members from across the Chamber as well as the views of Government. They provide reassurance that the provisions of the bill and their effect will be monitored and reviewed. Taken together, I believe they provide a sensible way forward, and I hope all of Parliament will be able to support this.
Thank you, Ms Bailey. I call Pam Duncan-Glancy to speak to Amendment 76A and other amendments in the group.
Thank you, Deputy Presiding Officer. Amendment in my name aims to ensure we consider properly the impact of the Act and that we therefore comprehensively review it over time. Amendments from my colleagues Jackie Bailey and some from the Government have just been outlined seek to ensure these reviews. My amendment ensures we do this 4 times, with the first review taking place within 3 years of the bill commencing. Scottish Labour know how important the operation of this bill is and that some people have concerns about it. It's therefore essential to consider what further changes could be needed to the process further down the line to ensure it works for trans people and the wider public. This amendment seeks to monitor that. In short, Presiding Officer, this amendment is designed to ensure scrutiny so that should improvements be needed or indeed concerns raised come to pass, Parliament can address them. And I move the amendment in my name.
Thank you, Ms Duncan-Glancy. I call Russell Finlay to speak to Amendment 83A and other amendments in the group.
Thank you, Presiding Officer. Today is the shortest day of the year, but it perhaps feels like the longest, and I'll try not to make it any longer. I want to begin by explaining what I'd hoped to do in this group, which is largely about future scrutiny of this bill. A UK government statutory instrument was introduced last year. This made it no longer an offence in England and Wales to disclose information about a person's GRC status for the purpose of the management of offenders. To my surprise, this SI was not emulated by the Scottish Government by way of an SSI. UK-wide consistency is important for trans people and the general public. We're already aware of the potential for confusion and other repercussions between the home nations of the UK. I think this Scottish Government inaction on this perhaps tells us something more generally about the lack of safeguarding considerations in relation to self-ID. So, Presiding Officer, I attempted to introduce this statutory instrument another way by lodging an amendment to this bill. However, this was deemed to be not within the scope of the bill by the Presiding Officer. I mention it because it relates directly to Jackie Bailey's amendment number 83, which asks for ministers to review the prohibition of disclosing someone's protected information in relation to a GRC. I agree with Jackie Bailey. This should be reviewed by the Scottish Government. However, I believe that such a review should also ask and assess whether it's appropriate to disclose someone's GRC status for the purpose of managing offenders, just as the UK Government statutory instrument already does. For completeness, it's worth recording that this amendment is linked to my amendments 30 and 31 from Group 8. However, for members' information, number 83A could be passed separately to them. I now turn to my final amendment, thank goodness. Now, separate to this bill, I believe that Scottish ministers should consider bringing forward the SSI, and Amendment 134 relates to this. It's fairly straightforward in that it would oblige ministers to provide an explanation of the reasons that they might choose not to. I will also now briefly address some of the other amendments in this group, which Jackie Bailey has described as being comprehensive and collective. I will support both Amendments 83 and Amendment 91, since they generally seek to achieve the same thing. Jackie Bailey's Amendment 56 is a consequential amendment to 84. It requires any review of the bill to include the impact of this legislation on the placement of trans people in prisons. I will support this amendment so we can properly establish the impact of the bill on women's safety in prisons. Amendment 84A is a technical subsequential amendment to 84, which I will also support. Amendments 75, 77, 79, 80, 81, 89 are also technical, and I will be supporting. 60 removes section 14B from the bill, removing the review of time periods set out in this section. I understand various amendments from Labour MSPs are effectively replacing this provision, so I'm happy to support it. Amendment 60, also from Jackie Bailey, is a substantive amendment that alters the initial review period of the Act, originally set out in sections 15B and 76A in Pam Duncan Glancy's name, further alters this review period. I'm pleased to support Amendment 78. It requires ministers to consider relevant data about the effect of a person obtaining a GRC when carrying out a review of this bill. This should be common sense for the Government. Amendment 82 requires ministers to report on the impact of this bill on transgender people, specifically those below the age of 18. I don't support under the age of 18 being able to apply for a GRC. I will therefore support this amendment, since at least it will measure, analyse and report on the consequences of this bill on those under the age of 18 who do seek a GRC. Amendment 85 will require any review of the bill to include the impact it has had on the provision of services by public authorities. I'll support that amendment and also Amendments 86 and 87, which require a review of the bill to consider any further amendments necessary to the Gender Recognition Act 2004. Home straight. Amendment 90 requires a review to consider changes that can be made to this piece of legislation, and 90A determines the length of the review period. I will be supporting both. Amendment 88, in the name of Ruth Maguire, would require the impact of this bill on Disclosure Scotland to be considered. My own earlier amendments sought to include a disclosure check on applicants, which would be administered by Disclosure Scotland. They were unsuccessful, but nonetheless, I will support this amendment. Thank you.
Thank you, Mr Finlay. I now call Polly McNeill to speak to Amendment 84A and other amendments in the group. Ms McNeill.
Thank you, Presiding Officer. Really, it's just a very small amendment to include in the list of data to be collected, to include those with a GRC and those without for completeness. That's really what I wanted to say to the amendment. That was really just to add to the substantive list in the amendment. Thank you.
Thank you, Ms McNeill. I now call Ruth Maguire to speak to Amendment 88 and other amendments in the group. Ms Maguire.
Presiding Officer, I will not be pressing Amendment 88.
Thank you, Ms Maguire. I now call Jamie Green.
Thank you, Deputy Presiding Officer. Can I commend Polly McNeill for her remarkably short contribution in that group? I'd like to chat just briefly to two amendments, 84 and 90. 84 is a replication of an amendment that I submitted at stage 2, a very welcome one. It's good to see it make a return. However, it does seem to include an additional clause at the bottom of Amendment 84 for the benefit of members, that any impact amendments made to the 2004 Act by this Act have had on the provision of gender identity healthcare by health boards and special health boards. It wasn't quite explained why that was added. However, I would note it is a welcome amendment, given that Group 17, which we'll come on to hopefully shortly, will also discuss a similar issue. So at least that is on the face of the bill. The second amendment I wanted to look at was Amendment 90. Clearly, there's been a lot of division over pretty much every amendment that we've had to discuss over the last few days. But I would hope there is some consensus amongst members around Amendment 90, which I think is a welcome addition, because what it says is that as a result of the review, should that amendment pass, make clear that ministers must set out any changes that it considers appropriate to meet three very specific things: the period of living in the acquired gender, minimum periods, the age at which a person can apply for GRC, and the process for 16 and 17-year-olds. And those three issues have, by and large, been issues of debate and division. What I'm not clear, though, and this is maybe where I'll ask the Cabinet Secretary to respond, is as a result of Amendment 90, this not just setting out any changes that are proposed by ministers or the government of the day, it is unclear what then happens thereafter. So, for example, what happens next if such changes are quite substantial in any direction to the major provisions that underpin the legislation? Would that be presented to Parliament via a primary legislation or a reset of the bill? Would it be through secondary legislation, subject to the affirmative procedure, or would it go through the appropriate committee of the day? And I don't think it quite specifies that. If it does specify it later in the bill, I'd be grateful if ministers pointed me in that direction. And the only reason I mention it is because I do think it is important that if after this review period, which is not that far away, possibly in the next Parliament, if it transpires, that members of that Parliament are able to scrutinise any proposals and changes that would largely replicate the debate we've just had this week and could reopen that. And I think those decisions must be held to account and rightly debated by members of any Parliament. So I would ask the Minister to perhaps reflect and comment on that in closing remarks. But otherwise, it's good to see these coalesce in a single reporting requirement, which I will support.
Thank you, Mr Green. I call Maggie Chapman.
Thank you, Presiding Officer. I want to begin by thanking all of those involved in the discussions that led to the amendments in Jackie Bailey's name. As we've heard, at stage 2, committee deliberations covered many different issues on which different members wanted reviews. My own amendment that was accepted at stage 2 to review the impact on trans people of the living in the acquired gender and reflection time periods and report on what changes to these might be appropriate given that review is captured by amendments 82 and 90. This bill deals with a process that affects trans people, and so I believe it is right that its impact on them is at the forefront of the review process. I am grateful to all of those who worked together to ensure that these amendments are presented in a coherent and consistent way and present, as Jamie Green has just identified, a clear review process. I think this shows some of the best of the consensus and compromise working that we have undertaken across the Chamber as part of the post-committee process. Were it up to me, I would not have included some of the reviews that are now part of this process, but I agree that this is actually the best way forward, and I thank all of those for working on these amendments that we have in Jackie Bailey's name. Thank you.
Thank you, Ms Chapman. I call the Cabinet Secretary.
Thank you, Presiding Officer. I agree with members that it will be important to review the impact of this Act, as with all legislation. As I undertook to do so at Stage 2, I have worked with members to coalesce a number of areas raised at Stage 2 into a single review requirement, and was pleased to be able to work with Jackie Bailey to bring these forward. These amendments reflect a number of helpful conversations with members across the Chamber, where there were suggestions for additional areas to review and report, including from Maggie Chapman, as well as amendments agreed at Stage 2, including Claire Baker and Jamie Green, and to expand on the provision lodged by Pam Duncan-Glancy. Amendments 76A and 90A, in the name of Pam Duncan-Glancy, would require the Scottish Government to review the impact of the Act after 3 years, 8 years, 13 years and 18 years. And we think this is a disproportionate review requirement for a bill that is about an estimated 250 to 300 trans people per year being able to apply for a gender recognition certificate. As with all legislation, yes.
Pam Duncan-Glancy.
Thank you. Thank you, Presiding Officer. The review period that I've suggested is that the bill is reviewed 4 times. The reason it goes on for that length of time is to allow the proper collection of data and understanding of the impact of the Act. And I don't think that is particularly well characterised in the way that the Cabinet Secretary has just set out. And I hope they should agree with me that review over a period of time, so that we can get proper longitudinal analysis of the positive, presumably, impacts that this will have on trans people. And I concur with my colleague Maggie Chapman in that regard, but also of other impacts that may or may not transpire.
Well, of course, there will need to be further reviews after the 3 years, but to say that they have to be so specified in terms of every 5 years, we don't think is proportionate. As with all legislation, the operation of the Act will be kept under review and can be updated as needed by the Parliament. But, as I say, this amendment, I think, is disproportionate, and I'm not able to support it. I also can't support amendments 83A and 134 in the name of Russell Finlay, as they completely duplicate what has already been provided for in the bill, and we will review whether further exceptions are required under Section 22 of the 2004 Act, and we will set out that in due course. I cannot support Amendment 84A in the name of Pauline McNeill, because this is already covered by the amendments in the name of Jackie Bailey, which contain provision to review the impact of the Act on the accommodation of trans prisoners, including both those with and without a GRC. This was introduced by amendments brought forward by Jamie Green and agreed at Stage 2, and incorporated into this one overarching review and report section of the bill. I don't support the amendment in the name of Ruth Maguire, which would require us to review the impact of the bill on Disclosure Scotland, but I heard Ruth Maguire say she didn't intend to move that amendment anyway. In terms of the question that was asked by Jamie Green around if any changes are required after the review, how would those be done, I think was this question. I think it depends what those changes are. So, for example, making exceptions under Section 22 could be done by regulations. There are some other things that could be done by regulations, but fundamentals like the requirements for issuing a GRC would require primary legislation. So it is various, depending, I think, on the seriousness and of the change that is required. And I suspect that Parliament would want us to come back to Parliament with any substantial changes of that nature. So I think I will just leave that there, Presiding Officer.
Thank you, Cabinet Secretary. I now call on Jackie Bailey to wind up and to press or withdraw Amendment 56.
I will be brief, Presiding Officer. I think there's been a considerable degree of consensus around the Chamber with these amendments, as members acknowledge the importance of keeping this legislation under review. This is intended to both address the concerns expressed to all of us and to ensure that the legislation works effectively for those applying for a gender recognition certificate. I am grateful to the Scottish Government for their support, and I move Amendment 56. Thank you.
Thank you, Ms Bailey. The question is that Amendment 56 be agreed to. Are we all agreed? Yes. We are not all agreed. Therefore, there will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 56 in the name of Jackie Bailey is yes 121. There were 3 abstentions. The amendment is therefore agreed. We now move to Group 16 on operation and impact of the Act. I call Amendment 122 in the name of John Mason. Group with amendments as shown in the groupings. John Mason to move Amendment 122 and speak to all amendments in the group. Mr Mason.
Thank you very much. I confess I would rather have been at the carol service this evening, but here we go. I'd like to speak to Amendment 122 concerning prisons, and will mention some of the other amendments in the group. I think one of my colleagues will speak more about Amendment 71 and the issues around human rights. Now, of course, over the course of the discussions around this bill, prisons have featured prominently, and especially the question of who should be in which prison. The Cabinet Secretary has already said this evening that guidance is being reviewed, and that is welcome. Having asked a number of questions in the past, my understanding is that each case is currently decided on its own merits. Therefore, someone born as a man but identifying as a woman could be placed in the women's prison if they are reckoned not to be a threat to women, and also if they were reckoned to be at risk by being in a men's prison. It's important that the risk to other inmates and the risk to the prison person themselves are both taken into account. This is a reasonable approach as far as I'm concerned, and this amendment seeks to confirm what is, I understand, the current position. By contrast, in a country like the United States, I understand an inmate can demand to be placed in a women's prison, even if they might be considered a threat to women, and I think it would be a mistake to go down that route. I would also support Pam Gossel's Amendment 57. If we are going to be truly inclusive, we need to be sensitive to both ethnic minorities and to religious groups. We should not be saying that modern, secular, Western culture is somehow better than other cultures, or for that matter, than previous cultures in this country. So a review and a report make absolute sense to me. On Brian Whittle's sport-related amendments, I would be broadly in support. There are already problems around the world on this topic of sport, and at the very least, we need to keep a watchful eye on how things develop. Thank you.
Thank you, Mr Mason. I call Pam Gosel to speak to Amendment 57 and other... Point of order, Douglas Lumsden.
I would just like to... Has there been a new business motion being agreed for the timetable of today's events? Because obviously there's people in the gallery expecting the bill to either pass or fail tonight, and there's been no guidance, as far as I can tell, that whether that will be taking place.
Yes, there has. They were told that it would be tomorrow.
Thank you. I thank Mr Lumsden for his point of order. In fact, the presiding officer, when most recently in the chair, did indicate that the business, aside from the Stage 3 amendments, would be taken tomorrow, and that a business motion subsequent to a discussion at the Bureau this evening would be put before the Parliament at the end of the Stage 3 amendments this evening. I'm not sure, maybe Mr Lumsden missed that. But I would now call Pam Gozo. Point of order, Oliver Mundell.
Apologies, Presiding Officer. I'm just seek your clarification under Rule 2.2 on what basis we continue to sit, because we passed the last business motion we passed, which indicated a decision time was motion S6M 07320, and it advised that decision time would be at 6:30 today. Clearly, the Bureau's met and made a decision to change that. It's just not clear why a business motion wouldn't have been brought to the Parliament as a whole, and some members have already expressed a concern at the change to decision time. Other members have expressed concerns about the fact portfolio questions now won't get to take place. And surely, if a decision has been taken by the Bureau, it would be reasonable and proper to expect such a decision to be put before the whole Parliament so that we can properly revise the business motion.
I thank Mr Mundell for his point of order. I think I just explained to Mr Lumsden further to his point of order that, in fact, as the presiding officer herself indicated a while back, in fact, there will be a business motion put to the Parliament at the end of the Stage 3 amendment session this evening. And, of course, the member will be aware, in terms of the standing orders, that the presiding officer can make consequential amendments to the business programme as the business proceeds and changes in line with those proceedings. And that is where we are just now. So I would like to call, if I may, Pam Gozo to speak to Amendment 57 and other amendments in the group. Ms Gozo.
Thank you, Presiding Officer. My mission since I stepped foot into the Scottish Parliament is to ensure that communities, whether that be BAME communities, people with disabilities or other marginalised communities, no longer go unheard. This Parliament is supposed to be striving to be more accountable, to be more diverse and inclusive, yet has failed to listen to stakeholders who will be largely impacted by the bill. I am disappointed to see that so many across this chamber, aside from my colleagues and several others, have failed to listen. For many people, knowing the biological sex of a health professional carrying out a medical examination or treatment is extremely important. Under medical care, we are often at our most vulnerable. Amendment 57, in my name, seeks to address concerns that a self-declarational model may exacerbate existing problems with Section 22 of the 2004 Act. This amendment creates a requirement on Scottish ministers to prepare and publish a report on the impact of this Act on patients where knowledge of the biological sex of a health professional carrying out a medical examination or treatment is required, including on religious grounds. I hope now I can answer the member John Mason's question earlier on in Group 13 that he'd asked. Religious women and groups have expressed concerns that this legislation could interfere with the requirements of their religion. For example, for many religious women, practicality in the Islamic faith, it is a religious requirement that they shall not let another man touch or see their body. These women therefore feel more comfortable using the services of female GPs, carers and other medical professionals. I'd like to provide the Chamber and Presiding Officer an example, a real example. My mum is a practising Sikh. My auntie is a practising Muslim. Now, when normally they go to the doctors, my mum would ask, basically, and I am with my mother, where my sisters are, my mother and my auntie would ask the question, when they see in front of them it's a biological they see a female. And I'm sorry if my terminology is not right. I am trying to put it in the most simplest form, how people like my mother and my auntie would feel. So when they go, they see there is a woman in front of them, a biological woman, and they're quite happy having their smear test or whatever checks they have to have, cancer checks to the breasts or anything, they're quite happy. But if normally they see a gentleman on the other side, biological male, they will normally ask for, is it possible that we can have a female to basically do that check-up? And it's never a problem. I must say the medical NHS are fantastic. They're so accommodating that they're always there to help. Now, I want you to tell me, my mum, my older mother sitting there, how can she ask? What's she asking for? What's she doing? How is she doing it? She's going to break her religion because she can't ask and they can't tell. My Muslim auntie is going to break her religion, right? Because she can't ask, they can't tell, she's scared. Is the right words coming out? Can I say trans woman, trans man? Can I say biological man, biological woman? Can I ask? And some of you can actually laugh and snigger about this. I'm sorry. I thought this was a diverse parliament, presiding officer. I really did. I have mentioned this, presiding officer, in the committee as well. I really try and bring the practicality out of this. This is not political. This is about religious beliefs. And we need to listen to those people, or we need to provide them with the right guidance, the right law, to make sure that nobody is out there discriminating, nobody is out there breaking anybody's religion. So we must ensure that this bill does not infringe upon the right to freedom of religion. According to international human rights law, the obligation to fulfil human rights means that states must take positive action to facilitate the enjoyment of basic human rights. But here with me today, I have letters from both the Muslim Council of Scotland and the Scottish Association of Mosques. These letters, presiding officer, are not based solely around the freedom of religion that this bill calls into question, but they are about concerns for women, for children and for vulnerable individuals. Let me remind this chamber, these religious organisations are not alone. Other religious organisations, they were frightened to come to the committee to voice their concerns. Yeah. And we heard this from a private session, so it's not something that I am saying hearsay. It has basically been voiced in a private session. Yeah. Presiding officer, I am not going to ignore these voices like others have in this chamber.
Ruth McGuire.
I appreciate what Pam Gosler is saying, and I'm listening to her carefully. I wonder if she would agree with me that even if not every person of faith needs that single-sex care, that we have to listen to those that do.
Pam Gosler.
Presiding officer, I thank the member for saying that question, because she must be psychic that I am going to go into this next. Absolutely, we need to look at it. It's not just religious beliefs, but it's the amount of care we provide for different people, diverse people. And early on, my colleague Jeremy Balfour did highlight this about that care. So I want to go on a little bit onto this, onto my next bit of the speech, my amendment. I have been contacted by so many people who are concerned about what this means for vulnerable individuals, such as those with disabilities, those with a carer, and those in care homes. A particular letter that stuck with me, which is something that I did raise in a previous session too, was when a constituent wrote to me to ask what this bill would mean for an elderly woman in a care home and whether she could be guaranteed a female carer to wash and dress her. As it stands, I cannot answer in confidence how this bill will affect this elderly woman. Ultimately, by removing all safeguards to the process, this bill opens up the GRC process to a group of unknown size and characteristics. And with the existing privacy protection in Section 22,
no, it opens it up to
many service providers will simply not be at the liberty to confirm to a patient whether the individual treating her is biologically female. Therefore, I ask the Scottish Government to fulfil their obligation to take positive action to facilitate the enjoyment of basic human rights. In the absence of amendments to the privacy protections, which were included in my amendments at stage 2, but no surprise again, voted down, the least the Scottish Government can commit to do is to monitor the impact by monitoring the impact of this Act on patients with the knowledge of the biological sex of a health professional carrying out a medical examination or a treatment is required, including on religious grounds, and setting out any steps they consider necessary in response to any concerns expressed as a result of the review. My colleague Jeremy Balfour has also proposed Amendments 13 and 14, which ensures that this legislation does not negatively impact the freedom of thought, conscience and religion. As stated in Article 9 of the European Convention on Human Rights, which I support. Similarly, I support Amendment 71 by Ash Regan, which aims to have the same effect. I support Amendment 122 by John Mason, which ensures that this Act does not change how prisons currently operate. I also support my colleague Brian Whittle's amendments 58, 59, 67, 68 on the impact this Act on sports as biological males poses a biological advantage over biological women, and increasing the number of GRCs could lead to more trans individuals participating in sports. Finally, I support Amendment 131 by Tess White, which calls on ministers to have to consult with women and girls on how the impact of the Act on women and girls should be reported. I would urge all members to back my Amendment 57 in my name.
Thank you, Ms Gozo. I now call Brian Whittle to speak to Amendment 58 and other amendments in the group. Mr Whittle.
Thank you, Deputy Presiding Officer, it's a pleasure to follow Pam Goso, and I would urge the Chamber to support her amendments. I do appreciate the opportunity to speak to my amendments in this bill, and can I say from the outset, which I don't think I should have to, but I'm going to, that I, along with every MSP I know in this Parliament, is in full agreement that every person should be treated equally, irrespective of colour, creed, religion, sex or gender. We all should recognise the specific challenges that the trans community have had to face, and we should all want to create laws that protect them and their human rights the same as every other person. However, as I've said before, you cannot create equality for one section of society by creating inequality in another. My amendments 58, 59 and 67 speak to the impact of the bill on sport as the bill is currently drafted, which will be significant, and that the need for the Scottish Government to publish guidance and collect data on the impact of the bill, as others in this debate have asked for in their situations. Now, the committee deemed sport important enough to include in its investigation, but apparently didn't deem it important enough to take evidence from any sportswomen, despite the committee being offered that option. Instead, decided that trans activists and men would suffice. It speaks to a global issue, Deputy Presiding Officer, where women participants are being warned not to speak out when confronted by the prospect of competing against biological males, silencing those most affected. Some have been threatened with expulsion from the sports teams, and others have even been threatened with expulsion from college or university. However, it surely must be right that all are heard, and those with genuine concerns are not automatically castigated and branded bigoted or transphobic. These amendments put a responsibility on the Scottish Government to report on the impact on sport of the Act. These amendments would require the Scottish Government or the Registrar-General to publish information, guidance or reports on the operation or impact of the provisions of the Gender Recognition Reform Act Scotland when implemented. Now, I'm not... Sorry? Somebody else? I'll take the intervention from Shirley-Ann Somerville.
Sorry, who's the member taking an intervention?
It's Shirley-Ann
Oh,
Somerville.
Shirley, I beg your pardon. Could we have Shirley-Ann Somerville, please, for an intervention on Mr Whittle? Hello? Ms Somerville, can you hear us? Is she actually trying to intervene, or is it one of the kids? I think if we could maybe continue with Mr Whittle for the moment, and we can double-check whether Ms Somerville is actually seeking to make an intervention. Thank you. Mr Whittle.
Thank you, Deputy Presiding Officer. I will give way to my colleague.
Brian Whittle introduced the
Stephen
idea...
Kerr.
Sorry. Brian Whittle introduced the idea that certain athletes were being challenged in terms of their preferences to whom they would compete against on the basis of the threat that they would be removed from universities or colleges. I think, in the interest of clarity, I'd like to know if this happened in Scotland or somewhere else, because that is
Mr Kerr, could you please speak to the front so the microphone can pick up? Thanks.
Yes, I understand that. The compulsion to want to look at the person one is speaking to is quite strong. I understand that. Thank you for the education. I understand that. I understand that. So that is my... so, yes, I know I'm grateful to the Chief Tutor.
Mr Kerr, could we please get the intervention completed?
Yeah, my intervention is completed, but I've got so many people willing to help me.
Excellent. Mr Whittle.
Thank you, Deputy Presiding Officer. Can I thank my colleague for his intervention? The fact is, this is happening across the whole of the United Kingdom and globally. It first came to my attention in the USA and in Australia. It happened down south, and it's now happened in Scotland. This is happening globally. Now, what I'm asking for here is data. I'm not asking for any data to be collected that isn't routinely collected by many sports already. Members and competitors are categorised by sex, age and disability. And by sex, many sports now give the option male, female and non-binary. This kind of data is necessary to ensure that sport offered takes its membership into account when delivering fairness for competitors. Now, I'm going to quote the Equality and Human Rights Commission submission here. And I think this will be an interest to the Cabinet Secretary, this submission, because what I'm about to quote contradicts quite a lot of the position that the Cabinet Secretary took when taking other amendments around guidance and reporting with the Scottish Government. Many amendments such as Jackie Bailey's, Claire Baker was there, Paul McNeill, Rachel Hamilton and Sue Webber. So the Equality and Human Rights Commission in their submission said this: "We have highlighted several areas where the effect of the Bill's provision on the operation of the protections from sex discrimination in the Equality Act is unclear, and have urged further consideration before legislative change is made. Additional requirements to publish information and guidance and to publish reports on the impact of the legislation, for example, on the provision of single-sex services, on trans people, on religious groups and in sport, could usefully assist in ensuring the effective implementation of the Act and in monitoring its impact in practice. We recommend that such amendments should be considered." I would be really interested to hear the Cabinet Secretary's response to that. The Equality and Human Rights Commission go on to say that these amendments seek to insert specific provisions in the Act dealing with the implications for single-sex services and the definition of and data collection on the protected characteristic of sex in the Equality Act. By broadening the group of trans people who will be able to obtain legal gender recognition, the proposals have significant implications for the operation of the Equality Act in Scotland. Whilst the Equality Act makes provision to treat people with the protected characteristic of gender reassignment differently from others sharing the same legal sex in certain circumstances and where justified, for example in relation to occupational requirements, separate and single-sex services, sport and communal accommodation, such provision does not apply in every context contemplated by the Act. Now, there is a reason we must support these amendments, and I have stated many times in this place that sport should be available and participation encouraged for all, irrespective of background and personal circumstances, which of course includes trans athletes. But sport globally is in turmoil trying to deal with the trans community's participation in sport. It varies from sport to sport, country to country, even in the United States, state to state. It actually means that some trans athletes participate as women locally, but must compete as a man nationally or internationally. And there is precedence here for the trouble that sport gets itself into when trying to approach issues like this. Intersex athletes have been in the news a lot in recent years as high-profile runners like Caster Semenya and Dutee Chand come under scrutiny for having some physical features commonly associated with men. World Athletics say that intersex women like Semenya, who have XY male chromosomes instead of XX female ones, account for just over 7 in every 1,000 elite female athletes. Or to put that in context, 140 times more than in the general population, with a still higher podium presence. Now, Caster Semenya won the Women's Olympic 800 metres and dominated the event for several years. She's an absolutely wonderful athlete. Burundi's Francine Niyonsaba won the 800 metre silver medal, and Kenyan Margaret Wanmabe won the bronze medal. Now, initially, they were banned from competing. And then they were told to compete they must take testosterone-suppressing drugs to compete in certain events, which made Semenya sick. All have subsequently been banned from competing in events from 400 metres to the mile. Semenya is currently in a legal battle with World Athletics to be allowed to compete in her preferred events. Now, by coincidence, I got a call this morning from Frank Dick, who was the Director of Coaching at UK Athletics and now one of the most celebrated coaches in the world, working across many sports. And as it happens, he was the Director of Coaching for the South African Olympic team for the 2016 Olympics and worked with Semenya's coach. He told me not only was Semenya destroyed by the sport's inability to deal with her issues, her family and the community from which she came from were destroyed.
My colleague to
of course, I'll get to it.
Jamie Green.
I'm extremely grateful for the member's contribution and illustrating some real-life examples. I would ask, given his experience and knowledge of the subject that he's eloquently speaking to, notwithstanding the wording of his amendment, which talks about reporting requirements and presenting numbers to Parliament, does he have any ideas on what the solution to this conundrum might be? Because it sounds like, A, it's very complex, and I'm sure lots of members, whatever their views, will have a lot of empathy with these organisations in approaching what these are quite sensitive and difficult subjects. And is there a solution to this?
Brian Whittle.
Again, he's obviously read my mind because we're coming on to that, Mr Green. So what I would say in conclusion to that bit is rather than protect intersex athletes, sport has a clumsy approach, has caused them harm. Much as I believe the same thing will happen and is currently happening to trans athletes. To Mr Green's question, Kenyan Olympic bronze medalist Margaret Wambui competed alongside Semenya in 2016 in the 800 metres event. She too was barred from competing in her preferred race due to her elevated testosterone levels. Wambui, who also refuses to take medication to reduce her testosterone levels, suggested World Athletics introduce a third category to international sports competitions to include intersex people. And here's a quote from her. She said, "It would be good if a third category for athletes with high testosterone was introduced because it is wrong to stop people from using their talents." And who could disagree with that? These are wonderful athletes that need the opportunity to participate. And I think what she says there, I concur with. And they have tried this. In the New York Marathon, they introduced a non-binary category. This year, the entries to this category increased by 300%, which tells me that those in that category are now feeling validated and more confident about having a place in sport, which is exactly, surely, what we want. However, there's still a significant issue to settle in that the trans woman who won this category and collected the $10,000 prize money finished outside the top 1,000 overall finishers. Now, tell me that's not a situation that's not open for exploitation by the unscrupulous. Checks and balances are still needed, and there is a long way to go. You see, Presiding Officer, sports national governing bodies are unsure of the legalities in which they can act, and that they may leave themselves open for court action on the grounds of prejudice, or conversely, if a trans athlete is injured or injures a fellow competitor, then the sport may be left open to legal action for failing to take appropriate action to protect the safety of participants. In other words, many sports are not taking any action for fear of making the wrong decision. Clear guidance is required from the Scottish Government. It cannot be subjective. I was asked by a national governing body if they took action to prevent a trans athlete from competing on grounds of safety or on grounds that the trans athlete had a material advantage from the sex in which they went through puberty, would they be acting illegally? It's not just national governing bodies, Deputy Presiding Officer, who have to make the decision on sport. Teachers, coaches have exactly the same issue when selecting teams. I am one of those coaches, and I'm qualified as a senior level 4 coach. I'm a former chair of the Scottish Athletics Coaches, and I'm a member of the European Coaches Association, and I don't know. And the fallout from the wrong decision is significant here. In the case of a male and female athlete of the same size, the male athlete can generate approximately 160% of the force that a female can. A person born male transitioning to female retains many of the male characteristics which give a huge unfair advantage. Now, I never ever thought, Deputy Presiding Officer, I would ever have to talk about the Q angle at the hip. That is the angle between the hip and the knee. And when a woman goes through puberty, that angle changes into a position where they can give birth. And that really impairs their ability to apply force. Male athletes have a bone density of about 33% more. They have muscle mass of about a third more. They have a greater lung capacity and a bigger heart. Women have to deal with menstruation when competing in sport, as was highlighted by Dina Asher-Smith and Elise McColgan in the summer there. And also, of course, women have to go through menopause. In the case of trans men competing in women's sport, if they are transitioning, they are likely to be going through hormone replacement therapies, hormones which are illegal according to the World Anti-Doping Association because they give women an unfair advantage in terms of muscle growth and exercise recovery. In other words, it's tantamount to legalise doping. It is generally only at elite level that anti-doping is present, which leaves every other level of competition open to a significant inequality. Now, I want to give an example of the difference between male and female sport. And I'm going to go all the way back to 1985, where the German Democratic Republic athlete Marita Koch broke the world record for 400 metres. German Democratic Republic, of course, had a state-sponsored doping programme. She ran a time of 47.60, and since 1985, not one single woman has got anywhere near that mark. But what if I tell you that last year that mark was beaten 10,000 times by men? And I want to talk about Caitlin Jenner.
Says absolutely nothing about trans women.
She brought the issue of the trans community to the fore. She has done incredible work in that area. But in 1976, Caitlin Jenner won the male decathlon Olympic title. She states that trans women should not be able to compete in women's sport, and she should know. Surely we cannot have women excluded from sport as they are currently being, because politicians can't openly discuss concerns and develop decent law that is fit for purpose. And I don't think this is just happening at elite level. It is across all age groups and abilities, in our schools and in our sports in this country. And let's not forget the potential impact on the insurance of sports and teachers and coaches. With an increased risk comes an increased cost. The Chamber may not want to recognise risk, but you can be sure that the insurance companies will. When change is being considered, it is an absolute requirement that consequence is anticipated. At stage 2, the Cabinet Secretary told me that she cannot be expected to decide which sports are affected. But, Presiding Officer, the Cabinet Secretary doesn't need to, because sport has done that already for you. It is why sport has a women's category, to ensure fairness and safety. There are over 1 million women and girls participating in sport in Scotland, and it has been a long fight to try and get equality between men's and women's sport. We have come such a long way in my lifetime. In setting this bill, it is imperative that the Government considers the impact of the bill across all of society, does not pass the buck and negate its responsibilities for the changes it proposes. We must protect women's rights and sports, as well as ensuring trans rights are protected the same as for every person.
Point of order from Gillian Mackay.
Thanks, Presiding Officer. There's been an accident at the back of the chamber. I wonder if we could suspend for a minute. Just to
absolutely, we'll suspend.
Thank
yes,
you.
Thank you.
Not sure why I'm typing. I don't know what happened. I've asked people that are there, some of the people that are there. They said they don't know what happened. Who fell off the chair? Maybe someone had an accident with a large pebble. Tusk is being Scottish. It's a habit. Have you two met before? Oh, in English, shut up, you specky twat. I hope it was serious. Come on, tell us what happened. Someone must know. No. Tusk and Kempanda. I know that you already know Tusk. You've seen him with his mask off and his beautiful mane. Oh, no, Tusk, the public gallery was open for this debate. The issue is that every single ticket was pre-booked and given out almost universally to Tory MPs who got it for their constituents, who all happen to be the Women's Feminist Network, which is a transphobic group. They basically used a load of fake names and got booked every ticket. And they're the people also that have screamed and disrupted and multiple times and had to have the thing shut down. Oh, I see what you mean. Ticketed rather than open. But is it only open if they haven't given all the tickets out? If it's someone that's fallen over, you'd have thought they'd have fixed it by now. Do they heat it? Do they heat the chamber? Well, they add the respectfully. Oh, I should tell you about that, shouldn't I? Given that we're waiting until they come back. Have you heard of Better Help Therapists, one of the online therapist groups? They told a 21-year-old client, has he tried not being gay so he can make up with his family? Turning straight. What absolute arseholes. Did you just bake yourself, dog? Hello. Can you come say hello? Come here. Oh, you are very warm. Put it on the table. You see, they're there, just there. Oh, what? Oh, your breath stinks. Would you like your new toy? No. How about a ball? You can have your ball. Oh. You're lower than the camera. She already licked my face. You hear her? We could try. That's a better view, isn't it? No. Does that mean you can take out the Scottish Parliament with a longsword? Or would that be considered uncouth? I've seen your dog's arsehole more often than I've seen my own. Why are you looking at your dog's arsehole? Keep it full. There you go. Get backwards. Is it cheap to live in Scotland? Oh, you're going to fall over. Let's get rid of it. Go on. Then you need a better mirror. Scotland is very much on my list. Oh, my camera's now pointing farther down. The problem I have is, I have to get out of this country. I could buy an island with the castle for the price of a London flat. Yeah, but the problem there is I couldn't afford a London flat. But I'd quite like an island with a castle. I mean, are there cheap places? Is there somewhere I could get a 3-bedroom bungalow cheap in the middle of nowhere? I've got to assume that I couldn't afford to live near any of the cities. The East End of Glasgow. Is it safe to live at the East End of Glasgow? Why are you giggling? Are you listening to me? Yes. Oh, okay. Maybe not. I know the non-stabby places. I bet it's even worse with an accent like mine. Okay, so what would a 3-bedroom bungalow cost? Weird. What the hell is going on? See, now I'm going to have to look. Right, where's Dumfries and Galloway's? Should I get a cargo container and build it out so I can ship myself over? Yeah, practically the English border. I don't even know if I can spell that. How long would it take you to get to Edinburgh from there? Oh, for fuck's sake. I'm gonna go look. Whoops. Stranraer. In Scotland, about 2 or 3 hours. So quite a way. All right. How about within an hour of either Edinburgh or Glasgow? We have proper roads now and everything. Hello. You're too hot, aren't you? 9:30. You'd be looking for Bathgate or Falkirk. Forget that. We're going to look there. Oh, that's nice. Okay. Number of bedrooms, 3. Unless they gentrified it. Lviv? Well, that looks like a tiny house. Oh, shall I do it in a range of that? Shit. Filters? No. Within 40 miles of Bathgate. I would choose Burness or Bonnybridge. Biden and Zelensky just went live. Put that on while we wait if you want. Well, somewhere must have it. Huh? Play the video, damn you. Do you have to keep opening the door? Yeah, give me a link. How long does it take to get from Glasgow to Edinburgh?
Thank you, members. What I would like to say is that I would advise that one of our colleagues was unwell. I am assured by a business manager that that individual is in fact feeling better, and on that basis we will now resume business. Point of order, Jeremy Balfour.
President Officer, I'm asking if you would take a motion without notice to adjourn the proceedings for this evening. We have seen... I appreciate some members don't want to hear from disabled members, but we will not be silenced by your shouting.
Members, could we just please listen to the member who is on his feet? Mr.
Thank you, Convener. I've made this point now on 2 occasions yesterday, and I'm now rising to do it again. We have seen the business motion for tomorrow. We know we are returning tomorrow afternoon. There will be opportunity at that point to consider the rest of the amendments. In my view, we should now firstly adjourn so that we can have rest. Those that have caring responsibilities can go and do those responsibilities, and the whole chamber can return tomorrow to complete this process in an orderly way. So I would ask if this motion would be accepted.
Well, I perhaps deal with Mr Balfour's point of order and I'll take the Minister. I would advise Mr Balfour, I thank him for his point of order, that the welfare concerns raised today and yesterday have indeed been noted, that we have a decision of the Bureau to proceed with Stage 3 amendments this evening, and therefore we will continue with the business as agreed by the Bureau, and therefore I am not minded to accept the motion without notice. I call the Minister for his point of order.
Just for some clarity, Presiding Officer, the member, our colleague, actually wants everything to proceed and is pretty keen that she will remotely kind of vote from a room where she's a lot cooler and a lot comfier.
Thank you, Minister, for that update. I would now intend to forward John Mason.
Thank you. I take the point that's been made already, but would it be possible, I know that the Presiding Officer, yourselves and your colleagues have been very generous with people's time, but would it be possible for you to encourage speakers to be shorter and therefore we would reach the end quicker?
I thank Mr Mason for his point of order. I would point out, of course, that in the course of the Stage 3 amendment proceedings, no member has been subject to any time limit, and it would perhaps be somewhat incongruous to proceed on that basis now, although of course all members will have heard the point that Mr Mason has raised. I would hope I could return now to the Stage 3 amendments, and I think Mr Whittle was finishing up. Mr Whittle? Yes,
he is. I won't start again, Deputy Presiding Officer, but
he was talking.
Can I just obviously say that we wish our colleague well, and we're thinking her. So, Deputy Presiding Officer, to continue, there are over 1 million women and girls participating in sport in Scotland, and it's been a long fight to try and get equality between men's and women's sport. And we've come such a long way in my lifetime. In setting this bill, it is imperative that the Government considers the impact of the bill across all of society. It does not pass the buck and negate its responsibilities for the changes it proposes. We must protect women's rights as well as ensuring trans rights are protected, the same as for every person. We all want equality in society, but as I've said before, you do not create equality for one group by creating inequality in another. Presiding Officer, much has been made of other countries adopting similar trans rights, so I took the opportunity yesterday to look at Denmark and their experience of developing trans rights. Now, they recommended that sex should determine participation in elite sports events and that otherwise sensible measures be taken to ensure a balance between inclusion of trans-identified people and, for instance, women. Their recommendations were met with harsh criticism from the Danish LGBT organisations, much as some of us have as well. However, they made the recommendations due to an understanding of the growing need for protecting women's sport, as well as including trans-identified people where it is reasonable to do so, and not at the expense of girls' and women's possibilities in sport. Yes, I will.
Cabinet Secretary.
Just for a point of fact and clarity, that would be for the UK Government to decide if it wanted to do that with sport, because obviously what he's referring to is a reserved matter. So just for clarity, and he may wish to address that to the UK Government. It's not something this Government could do.
Brian Whittam.
Sorry, Cabinet Secretary, I'm sure as you were previously the Cabinet Secretary for Sport and Health, you would recognise that we do have an organisation called Sport Scotland in this country. So,
members, we want to hear one voice at the moment, and that is from the member who is on his feet. Mr Whittle, please resume.
Spending Officer. So, perhaps we can learn from other experiences and not make the same mistakes that they made. I am asking for guidance for sports, for teachers and coaches, as given by the Scottish Government, and that relevant data should be collected to establish the consequences of this bill. To the final amendment 68, it is essential. It speaks directly to the safety of the trans community who are seeking healthcare. Not only that, it protects our healthcare professionals in their ability to deliver the very best care to all. To demonstrate this, Deputy Presiding Officer, I want to quote from a letter I received from an NHS consultant clinical scientist and medical physics expert in ionising radiation. He quoted from the statutory regulations in optimising radiation exposure, which states that, and I quote, "In complying with the obligations under this regulation, IR/MER 2017 Regulation 12, paragraph 8, the practitioner and the operator must pay particular attention in relation to, where appropriate, individuals in whom pregnancy cannot be excluded and who are undergoing a medical exposure, in particular if abdominal and pelvic regions are involved, taking into account the exposure of both the individual and any unborn child."
So you ask them whether or not it is physically possible they can be pregnant.
Paragraph 9 states, and again I quote, "The employer must take steps to ensure that clinical evaluation of each exposure is recorded in accordance with the employer's procedure, including, where appropriate, factors relevant to patient dose." Factors relevant to patient dose, one of which is biological sex, Deputy Presiding Officer. That clinician states, and again I quote, that the regulators of IR/MER regulations in the 4 home nations are already seeing examples of gender recognition affecting the safety of patients. For example, a pregnant biological female patient identifying as male gender was inappropriately exposed to an abdominal CT scan, including their unborn child. And in another example, a biological male patient identifying as a female gender inappropriately had a CT scan of their prostate, which had been mistaken as a growth on an ultrasound examination. At the moment,
but this is a problem with the procedures in the health service.
They do not record biological sex and gender. As such, there are implications for patient safety through gender recognition, including the safety of unborn children and breastfeeding infants. He goes on to say the importance of a patient's biological sex being known prior to the commencement of any medical or clinical treatment will clearly become increasingly important as more patients identify with a gender different to their biological sex. I therefore fully support Mr Whittle's proposed amendments to assess the impact of the Act and hopefully inform how clinical risk can be mitigated. I also heard an instance where a female identifying as a male and not informing healthcare providers being treated for chest pains and eventually being diagnosed with the consequences of endometriosis. That, Presiding Officer, is an inherently dangerous position for a patient and not great for the healthcare professional either. With that in mind, it seems ridiculous that consideration is being given to remove the words woman and female from the vocabulary in a healthcare setting. Are we really going to start calling women people with a cervix? Why are we not calling people with, males people with a prostate then? Why the discrepancy? And why is it taking a male to stand up in this chamber and highlight the erosion of women's identity? Presiding Officer, this is exactly what I'm trying to do with these amendments. Mitigate risk.
Ruth Maguire.
I thank Brian Whittle for taking an intervention. It might just be because we're late in the day, but he's surely not suggesting that he's the first person to draw attention to these issues.
Brian Whittle.
The first person to draw attention to these issues in this debate.
I mean, at the end of the day, all you've got to do is tell the person that it matters.
What I'm trying to do here with these amendments is mitigate risk in sports participation, female, male and trans athletes, and in protecting the trans community in administering healthcare. The government cannot create legislation, then abdicate responsibility for the consequences of the legislation to other parties. Surely that is not too much to ask. I ask those who have spoken to me across the chamber and who have intimated reservations on the bill to support my amendments. This is one piece of legislation that, if passed as currently drafted, will open up routes to harm, especially for women and for the trans community. This is exactly the reasons we wanted the time to discuss and examine the consequences of the bill, time that has been denied by those in government who are forcing this bill through without proper parliamentary scrutiny. We cannot pass this and then think about amending it at a later date as data is collected. We cannot vote for this bill in a vacuum without any checks and balances. I urge the Chamber to vote for these amendments. This is not party political, which is why I have a free vote, nor anti any part of society.
You're exactly
Rather,
right.
it is pro every part of society. It's about making the best law possible from the outset. I urge colleagues from across the chamber, don't hide behind your party colours. If you have any doubt, and I know many of you do, please do the right thing. Presiding Officer.
Thank you, Mr Whittle. Members will note that we have passed the agreed time limit for the debate on this group to finish. I have exercised my power under Rule 9.8.4 A small c to allow debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. I call Jeremy Balfour to speak to Amendment 13 and other amendments in the group.
Thank you, Deputy Presiding Officer, and I will try to keep my comments reasonably brief. In regard to Amendment 122, I will be supporting Mr Mason. In regard to Amendment 57, I think my colleague Pam Grosso spoke very clearly in regard to some of the issues that could happen, which I'm sure are unintended. I totally recognise that for the majority, for most of us in this chamber, we don't follow a belief or a religion that will be impacted by this. But we are also here to protect minority religious groups as well, to allow individuals to be able to worship in freedom, to be able to worship as they believe is the right way forward.
I'm disappointed you
pointed to examples from the Muslim faith. I think it would also be true to say that those from the Jewish faith and some from the Christian faith will also be struggling to work out how they will be able to practice their religious freedom. And I think to be able to record and monitor that and see the effect on that will be very helpful, and I do hope the Chamber will support these. I think my colleague Brian Whittle has spoken very clearly in regard to the issues around sport. If I can just very briefly come from this from a slightly different angle, I really enjoy watching my two daughters play sport. They enjoy it, it's good for their physical health. We in Scotland want our children to be more healthy, but we all know that age from when they become teenagers, particularly female teenagers, to keep them actively involved in sport is very hard and very difficult. And I know, as a father, if my daughter is suddenly going to be never winning, never have an opportunity to win, perhaps putting her body in physical danger because someone is stronger and bigger and physically different from her, she will simply walk away. And I think this can have dangerous consequences going forward for future generations in regard to keeping our young folk fit and healthy. If I can turn to my own two amendments in regard to 13 and 14. These amendments, I think, are fairly straightforward. If I'm honest, I think probably the member Ash Regan's amendment is better, so if we've got to choose, I will choose her amendment before mine. But they seek to do the similar thing. And that is to recognise that we have a diversity within society, that we have to protect all characters, all protected characteristics, whether that's religion, disability and other areas. And all we are simply asking is that the bill has that at the heart of it, so that people understand how it all fits in. I also support my colleague Tess White's amendment as well. Thank you, Deputy Presiding Officer.
Thank you, Mr Balfour. I call Ash Regan to speak to Amendment 71 and other amendments in the group. Ms Regan.
Thank you, Presiding Officer. In Norway, a female artist is facing criminal charges for stating that men cannot be lesbians. Now, I fully accept that some people hold beliefs that I do not agree with, and I, no doubt, hold beliefs that others do not agree with, but I wouldn't compel others to agree to my beliefs. I think we should all be free to express ourselves and indeed even to cause offence, and that's important. And I think in terms of the wider debate on these issues, it hasn't benefited from that attempt to sort of shut down those questioning voices and voices that are suggesting things that other people may not believe in. So, and to come on to the point that was raised by Mr Whittle, I think it is very important that women feel that they have the right to the words that describe them, their lives and their experiences. And recently I happened to listen to a recording of Mary Richardson. She was describing her time as a suffragette, and once when she was on a train, she had left the scene of an act of civil disobedience, and she sat in that train carriage and listened to man after man after man describing all the violent ways that they would like to kill a suffragette if they ever saw one, obviously not realising that there was one sitting among them in the carriage. And I must say, I was quite struck by the parallels that we are facing today. So threats to women who speak out, threatened with rape, with murder. Even 100 years later, men are still feeling entitled to threaten and to kill women simply for saying something that they don't agree with. So I want to ensure that no one is compelled to speak up or about a holder of a GRC in any particular way simply because they hold a GRC. And the judgment in For Starter made clear that the protection of a belief means nothing without the without the protection in order to express that belief. So we need to be clear this afternoon that a process of state certification does not in itself introduce new constraints on Article 10 rights, except insofar as the bill explicitly introduces those constraints. So I would like also to talk about the effect of Section 22, and that has been raised already by Ms Gozal, on what people may lawfully say. I also attempted to bring amendments on this subject, which I know Ms Baker also tried to do at earlier stages. And I think those would have allowed us to discuss whether the provisions of that section remain appropriate for what is now a much larger and obviously more varied group of GRC holders than was envisaged by the legislation when it was drafted in 2004. So the Employment Lawyers Association have previously queried whether Section 22 remains the best approach to privacy protection due to its potential to have a chilling effect on lawful information sharing. The association asked why the protections properly afforded to everyone with the protected characteristic of gender reassignment, whether or not they have a GRC under the Equality Act, need to be enhanced in this way for GRC holders only. So I'd like to take this opportunity to put on record my understanding that the offences in Section 22 only apply to a person who has obtained information about a GRC holder in an official capacity and have no relevance outside that context, and they impose no other additional legal constraints relating to GRC holders or individuals who are going about their day-to-day lives. And I'd welcome an undertaking from the Minister that the Scottish Government will now look very carefully at amendments that were rejected as inadmissible for today, where these suggested additions to the exceptions in Section 22. And it'd be reassuring, I think, for the Chamber to hear the Minister confirm that the Government is open to using its powers to amend Section 22 by order before the bill is brought fully into force, where that can be properly justified. And I am aware there was a commitment to look further at Section 22 made in 2019, which remains to be fulfilled. And of course, now is the time to tie up that loose end.
Thank you, Ms Regan. I now call Tess White to speak to Amendment 131 and other amendments in the group. Ms White.
Thank you, Presiding Officer. We've heard over the last few days how important reporting is from several of the members. Amendment 131 creates a statutory duty for ministers to consult on how and how often they should report on the legislation's impact on women and girls in consultation with this group. Ministers must then make regulations specifying the details for reporting on that impact. Amendment 136, which goes hand in hand with 131, delays commencement of Section 2 under the regulations have been made. I brought these amendments back from Stage 2 with modifications for two reasons. I was deeply concerned by the lack of debate surrounding these amendments during Stage 2 proceedings. The Cabinet Secretary gave them cursory mention, but nothing more considered than that in such a massive grouping. The discussion of these amendments at Stage 2 felt like a microcosm of the wider GRR debate and the bill's impact on women and girls, dodging the key issues and denying there's a problem to begin with. But events since Stage 2 in just a few short weeks demonstrate precisely why these amendments are needed. The UN Special Rapporteur on Violence Against Women and Girls has raised concerns that the bill's proposals present potential risks to the safety of women. Meanwhile, last week's court ruling underscores further why the legislation's impact on women and girls should be reviewed on a statutory basis as we move forward. It states that sex is not limited to biological or birth sex, and that a person who obtains a GRC in their required gender legally changes their sex. And like Pauline McNeill, I too am confused by this. The Scottish Conservatives call for the bill to be paused while the implications of the verdict are considered. But the Scottish Government has ignored these calls. However, it desperately needs to recognise that this legislation gives the key to the door to an undefined group of people by making it significantly easier for them to change their sex. I believe the intent of this bill is good, but the unintended consequences could be greater for the rights and safety of women and girls. Those acting in bad faith will exploit loopholes where there is access to women and children, and there's a real risk that women will self-exclude from services. Last night, vital safeguards put forward by Russell Finlay and Michelle Thompson were rejected. More than ever, post-legislative scrutiny of this bill's impact on women and girls is so important. Yes?
Julie Martin.
First of all, I'd like to say I'm really glad that Tess White voted for my amendments, which I think have the same effect that Russell Finlay and Michelle Thompson's amendments had, but are actually competent and in line with the European Convention on Human Rights.
Tess White.
Thank you, Gillian Martin, for that. I didn't feel that it was robust enough, and Gillian Martin said yesterday, so we both come from the energy sector, The energy sector looks at risk and risk management. It also really focuses on data and data reporting, and that's the substance of my amendments. Yeah. The Cabinet Secretary objected not to the substance of my amendments, but to their drafting. As such, I instructed the Bills team to make the regulations clearer to address these concerns. There are some strong amendments in this group, and I'm supportive of them all. I would briefly like to highlight Brian Whittle's amendments 58, 59 and 67 on sport. Statutory changes through the GRR bill will have a significant impact on sport. This is already happening, but this legislation will accelerate it. That has implications for the safety of competitors and for fairness. It is only right that this should be reviewed on a statutory basis. It is the responsible thing to do. My amendments are a bandage. They're a sticking plaster. I deeply, deeply regret the Scottish Government's disastrous handling of this aspect of the process, but this is an opportunity to change course. I therefore strongly urge colleagues to support amendments 131 and 136. Thank you.
Thank you, Ms White. I call Kenneth Gibson.
Thank you, Presiding Officer, and I speak in support of Amendment 122 by my colleague John Mason. A particular area of concern in this bill has been its potential impact on the female prison population. Whatever the reason for a woman being imprisoned, what matters is that they are in the Scottish Government's custody and care, and it falls upon ministers to do their utmost to ensure that these often vulnerable women are safe while serving their time. A 2011 Swedish cohort study analysed crime rates after surgical sex reassignment of male to female, that wasn't my alarm, I'm glad to say, trans people, and found that they retained a male pattern regarding criminality and violent crime. So trans women are therefore no more or less likely to commit crimes than any other biological males. Official UK Government data shows that as of March this year, the total number of transgender prisoners in England and Wales was 230, 97 of whom are sex offenders, around 42%. Of the general male prison population in England and Wales, 19% are sex offenders. In the United States, of the federal system's 1,143 male-to-female transitioners, nearly half have a history of sexual offences. So given that trans women are no more likely than other anatomical males to commit sexual offences, the obvious corollary is that there must be a significant number of sex offenders in prison who falsely claim to be trans. The danger is that men who commit sexual offences may claim to be transgender in order to avoid imprisonment in the men's estate. And the very presence of anatomical males in women's prisons can cause distress to vulnerable female prisoners, many of whom have been the victim of male violence. A key issue with this bill is that by making it easier to acquire a GRC, more male sex offenders may pretend to be trans in order to be incarcerated in a female prison, whether to prey on women or do easier time.
Still wouldn't get in there.
Unlike in England, Scotland's prison service already uses individualised risk assessments to determine how trans prisoners are managed, whether those prisoners have a gender recognition certificate or not. However, in November 2021, it was reported in the Times that 12 trans prisoners convicted of violence or sexual crimes had been accommodated in Scottish women's jails within the previous 18 months, according to figures released under Freedom of Information. So the review the Cabinet Secretary spoke of earlier is welcome, if belated. Rona Hotchkiss, former Governor of Conton Vale Prison, and a constituent of mine said women were being exploited as, and I quote, unwilling participants in a social experiment. By being housed alongside trans women, adding that women are being told, and again I quote, their concerns, their fears, their despair must take second place to the feelings of men who identify as women. I therefore firmly believe that no one who is anatomically male should be incarcerated in a women's prison. The inconvenient truth is that trans women are physically male and, as a group, present the same hazard that other men present. Those who pretend to be trans, even more so. If a fox said it was a chicken, would you put it in a hen house? Of course not. Now, back in 2015, an American woman who identified as black and was a chapter president for the National Association for the Advancement of Coloured People was outed as being entirely of European heritage. Denounced worldwide, she lost her university job teaching the black women's struggle and was accused of being a race faker, of wearing a costume and lying to claim ownership over a painful and complicated history she wasn't born into. Yet if she'd declared herself to be a bloke rather than black, everyone would have been expected to agree with that self-identification. This is real Emperor's New Clothes stuff. Reality must intrude at some point. Allowing anatomical males who self-identify as women into prison
None of this is relevant. This is
and
all
a safeguarding
part of the
nightmare.
underlying act.
Support
It's
Amendment
not relevant
122.
to this.
Thank you, Mr Goosen. I call Stephen Kerr.
Well, it's a pleasure to be able to follow my colleague, and I have to say that I agree with everything that he said. These are not easy things to talk about because we're into the realm of where people may wish to take offence. But I think it's important in this context that we can speak as freely as we are speaking to each other, and there's been an immense degree of respect.
As you well know, you have
before I
privilege.
say anything
You can
further,
say what the
because
fuck
I'm
you
going to
like.
address.
Even lie.
Would someone like to intervene?
Mercedes Villalba?
Yeah,
Is the member's microphone on?
Thank you. Yes. Would the member like to clarify in what way the previous contribution demonstrated respect? Because from where I was sitting, it was extremely disrespectful and it was bordering on hate speech.
Well, I'm not sure that I am
Stephen
here
Kerr?
to defend my colleague, but he's speaking as a parliamentarian in a parliament of adults. And I think we respectfully heard him deliver his speech. I think if the member had wanted to make an intervention to say what she's just said, it would have been much fairer on the member, because he's in a situation now where he can't readily respond to that, although he could intervene on me if he wishes and respond on his own behalf, but I'm not sure if he wants to. But before I go any further, because I wish to speak probably fairly exclusively about the subject matter around freedom of religion or belief, I would refer members to my register of interests. This is a subject area that is very important to me personally. To that extent, I must say that I probably agree with what John Mason said earlier. I think many of us would rather have been at the carol service tonight. And sadly, as just been illustrated, sometimes there's too little joy to the world. And I think sometimes we should afford each other the benefit of the doubt when it comes to the way that we choose to express ourselves, however clumsy that might be. But I wish to support Amendment 57 in the name of Pam Goswell in particular, and Amendments 13 and 14 in the name of Jeremy Balfour, and Amendment 71 in the name of Ash Regan. Now, that doesn't mean that I'm not supporting the amendment in the name of John Mason, or indeed Brian Whittle's amendments, or Tess White's. I think they have also given excellent speeches, which have also respected the subject matter, and I'm grateful for that. But I would specifically like to refer to the freedom of religion or belief issues. Now, on the 20th of October, I was invited by Faisal Chowdhury to attend a meeting in this Parliament, in one of our committee rooms, where he and I were privileged to meet with a group of about 60 people from all kinds of backgrounds, all forms of religion and belief, and none. And there were also representatives there from the trans community. I have to say that the whole evening was exceptional in this respect, that it showed that it was possible to discuss very sensitive issues in the same respectful way that I think, in the main, we've been discussing them in this chamber for the last couple of days. And that has instilled in me a belief that when it comes to human rights, it is always possible, when people are speaking to and listening to each other, for there to be an accommodation. And I think that that is what is required in respect to some of the clashes that occur in respect to human rights. But at that meeting, these representatives of Scotland's major faiths, Muslim, Hindu, Sikh, Christian, they expressed their views very forthrightly. Faisal Chowdhury and I gave them their commitment that we would allow their voices to be heard in the proceedings of the Parliament, and I do so now as a great honour. just raised the concerns that they had in relation to their faith. They felt that they had largely been left out of the process that has brought us to this point this evening. I don't think that's changed since October, sadly. They had grave concerns about women's rights and the safety of women's spaces. That issue was raised repeatedly. And questions were asked,
but
and I hope that the Cabinet Secretary will take the opportunity to be as clear as she possibly can be, because questions were asked about the continued ability of religious institutions to maintain sex-segregated spaces. To many people of faith, this is a very important issue. Now, I recognise that to some people, those who hold religious faith and it becomes a leading and perhaps even dominating influence in their lives and how they choose to spend their time, this may all be a bit of a mystery to some people as to how religion can be so important to people. But I would ask colleagues across the Chamber, in consideration of these amendments, to remember, let us, if you are less religious, let us try and put ourselves in the shoes of the other people that we're talking about. To them, their religion is the most important thing in their lives. And to some people, their religious beliefs are more important than their very lives.
Why won't the Muslims let me go in their mosque and worship Jesus?
I will, of course.
Ross Greer. I'm very grateful for the member giving me on that point. I would just ask if he would recognise that many trans and non-binary people are people of faith, and he's certainly not speaking on their behalf at the moment. Stephen Kerr.
Well, I'm not quite sure why Ross Greer says that I'm trying to speak on behalf of anybody. I'm talking about a meeting I attended where representatives of faith groups in Scotland expressed their views. Faisal Chowdhury was there, and so were representatives of the trans community in Scotland. It was a very good meeting. So I'm not quite sure that I understand where Ross Greer is coming from. I'm happy for him to come back in if he wishes to give further explanation.
I'm grateful to the member for that further opportunity. My discomfort with his speech as a person of faith, which he knows, is the implication is there's a tension between the beliefs of people of faith and the rights of the trans and non-binary community, and I'm simply making the point that many trans and non-binary people are part of faith communities. Stephen Kerr.
No, I think there's a misunderstanding here. What I'm trying to say, very simply, is that people of faith who were present in a meeting in this Parliament on the 20th of October expressed genuinely held concerns. And I think, as a matter, again, of respect, it's important that we accept that people may feel differently and have a different view than us, even though we may have a view about the origins or the motives or whatever of those beliefs. And that's what this group of people of faith felt. They felt concern, as I've said already, about the need for their faith groups to get a fair hearing in this process. They felt a concern about women's rights. They felt a concern about their ability to maintain sex-segregated places, and I'm sure Ross Greer would recognise that that's a very important part of the worship of many faith groups. And they also had concern about the bill's attempt to move the age for self-ID to 16. They felt unanimously that that was too young. But the reason I mention all this is because, and I'll say again, this whole idea of freedom of religion or belief, which is at the core, I believe, of our human rights, which includes freedom of conscience, as is highlighted in Ash Regan's amendment, specifically referring to Article 10 of the European Convention of Human Rights. And the reality is that this is all about an individual's right, which I think we would all agree is sacrosanct, to determine their own path in life. And for some, this means following the teachings of a faith, and for others, it doesn't. But that's all encompassed within the Universal Declaration of Human Rights article that defines what freedom of religion or belief is. And I believe that this freedom underpins so many of our other freedoms, because without freedom of conscience, we don't have freedom of speech. We don't have freedom of assembly. And in the context of Article 18, that I mentioned earlier, the Universal Declaration of Human Rights, and Article 9, that's quoted in Jeremy Balfour's amendments, is the right to worship publicly in accordance with the teachings of your faith group. Now, I think faith groups require some assurance from the Cabinet Secretary in response to this grouping of amendments that their right, particularly, I'm thinking now of the different variations of Islam, of Judaism, of Sikhism, Buddhism, where public worship is segregated as part of their belief system. I think they need to hear it categorically stated that that right will in no way be compromised through the passage of this bill. And if this bill passes as currently worded, could faith groups feel confident that they can keep their form of public worship? And then there are other more basic questions that I feel that the Cabinet Secretary could approach in her summing up. And that is in relation, for example, to Catholicism, where it is well known that only men can become priests and only women can become nuns. So I think it's important just to clarify that the Cabinet Secretary confirms that if a biological male who has a gender recognition certificate stating they are female, would they still be legally entitled to the priesthood or some other religious right or privileged position if this bill passed? I will give way.
Thanks, Stephen.
It will change fuck all because it's got nothing to do with it.
Just, I want to steer him back, if I can, to Pam Gosel's amendment, because I listened very carefully to Pam Gosel. She made a very passionate speech, and so I would ask Mr. Kerr, would he agree with me that Pam Gosel, the amendment actually deals with not so much the things that Mr. Kerr is talking about just now, but specifically medical examinations. And I don't think, members may have got the impression that Pam Gosel was asking for special treatment for religious groups, and I don't think she was. So would he agree with me that actually what she was asking for was for us to respect the right of individuals, women mainly, to ask for somebody of a specific gender to examine them, and that's all the amendment does.
Stephen Kerr. Yes, that is correct. That Pam Gosel's amendment 57 is exactly what my friend has just outlined. But I'm specifically focusing on amendments 13, 14, and 71, which underpin the freedom of religion or belief concepts that I am currently trying to speak about. And, Presiding Officer, it's not only me that's bringing these concerns to this debate, obviously. I've quoted faith groups from the meeting that Faisal Chowdhury organised that I was privileged to attend. But the UN Special Rapporteur on Violence Against Women and Girls also wrote in the letter that's been much quoted over the last 2 days. This is what she wrote. A failure to provide single-sex services to women born female alongside gender-specific services targeting women in all their diversity could amount to unlawful indirect discrimination because of religion under the Equality Act of 2010. The International Covenant on Civil and Political Rights, the ICCPR, guarantees freedom of religion or belief under international law. Furthermore, Article 18 of the Universal Declaration of Human Rights, adopted in 1948, states that everyone has the right to freedom of thought, conscience and religion. Furthermore, the letter goes on, and according to international human rights law, the obligation to fulfil human rights means that states must take positive action to facilitate the enjoyment of basic human rights. And I think that is the crux of what the amendments that have been put down, that is the crux of the matter. That is what they're trying to achieve. That as we make law, that we are indeed facilitating the enjoyment of basic human rights, and that is all human rights. So in conclusion, Presiding Officer, I believe that for very obvious reasons, there has not been, and the obvious reason being the way in which the government is ramming this through this Parliament, with inadequate time for reflection, inadequate time for amendments to be properly considered, inadequate time for evidence to be gathered from all kinds of witnesses that have been thus far denied a voice in the procedure of this bill. I will give way to Monica Lennon.
Monica Lennon.
Yeah, grateful to the member for giving way. Perhaps Stephen Kerr could explain to the Chamber in what circumstances he would support the bill, because you're asking people to treat this in good faith, but I'm not convinced that Mr Kerr would ever support the bill, and I think it would be better if he could just be clear on that.
Stephen Kerr.
So I'm a realist, and I can count, and I know what lies ahead of us through the process of the consideration of these amendments, and at the end of the Stage 3 debate. I'm not a political naivety in front of you here, and I know what I'm trying to do is do the very best I can. I think my colleagues here and in other places throughout this chamber are doing the same, are trying to introduce amendments that will make what we believe is bad law less bad. So am I going to vote for this bill? Absolutely not. But I know there's a very high likelihood that at the end of this process it's going to become the law of my country. And therefore, that is why I and others are bringing forward these amendments. Not because we're going to support the bill, but because we just want to save Scotland from more bad law rammed through this Parliament. And that is why I think freedom of religion and belief is an important aspect to many lives, because that includes, by the way, the right to not have a religion, not to have belief. But I believe that happy to do so.
Brian Whittle.
Very grateful for my colleague for taking the intervention. It's just following Monica Lennon's intervention. I wonder if you would agree with me that what we, as I said at the start of my contribution, I think every single member in this Parliament recognises the need to develop human rights across the board, and that what we are trying to do here is ensure that the law that is made does not impinge on other people's human rights. And what we believe is that everybody should have the same right. I would vote for the bill if I believed that everybody had the same rights.
Stephen Kerr.
Yes, and Brian Whittle, I think that gives us a brilliant summation of the views of many of us in this chamber. I spoke earlier about the meeting that we had in Parliament, where there was a very happy meeting of minds. People talked to each other and they listened to each other, and there was, in all of that, there was the basis for an accommodation that would give us exactly what Brian Whittle has just described as the desirable outcome that I hope we would all sign up to, which is that all of our human rights are being respected. We respect each other enough to understand where my human rights and your human rights need to be accommodated. I'll give way.
Douglas Lumsden.
I thank the member for giving way. The outcome of that meeting, did the people go away thinking that the Parliament would take note of their voices? Did they think there would be changes? Or were they assuming the worst?
Stephen Kerr.
No. In fact, as I said a few minutes ago, they left feeling that Faisal Chowdhury, who's in the chamber, and he can speak for himself, and maybe he's going to give a speech in a minute, they felt that we had listened and that we were going to reflect their views when we had opportunities to speak in this chamber and in other places in this Parliament. So they left with that hope. But they did plead with us that faith groups in this country would be more considered. Now, I just draw attention to the chamber to the fact that through the pandemic emergency that we had, only one government in the United Kingdom was taken to court and found guilty of neglecting human rights. And that was the Scottish Government. In the Court of Session, they were found to have been in denial of the basic human rights defined in the Universal Declaration of Human Rights, defined in the European Declaration of Human Rights, in respect to freedom of religion or belief. And one of the aspects of that case was the degree to which there was a form of religious illiteracy among policymakers and advisers. And that is why I think it's important that we feel that we hear a fuller accounting from the Cabinet Secretary in response to this group of amendments on the whole subject area of freedom of religion or belief. Members of the Scottish Government may not be comfortable to be reminded that they were in violation of this fundamental human right through the pandemic. But it's a warning about the need for there to be care given in respect to any legislation that touches on this basic human right. And at the end of the day, I hope what unite all of us is a desire to ensure that Scotland remains on the right side of these fundamental human rights. Because I think that would be a source of pride to all of us. And that is why, in summation, I urge members, regardless of party, to vote for the amendments put forward, especially by Jeremy Balfour and Pam Gosal. And I think that is the conclusion of my remarks.
Thank you, Mr Kerr. And I call the Cabinet Secretary.
Thank you, Deputy Presiding Officer. I would, of course, just remind Stephen Kerr that it is his party and government that wants to repeal the human rights legislation that has protected people for many decades. Moving back to the amendments in this bill, I cannot support Amendment 122, which provides that nothing in the bill affects the exercise of the Scottish Minister's functions in relation to prisons or prisoners. It's not clear what functions John Mason is referring to or how they could possibly be affected by the bill. And of course, the Scottish Prison Service has already a robust risk-based procedure for prisoners and, of course, the rest of the prison population, and they may or may not place a trans person in the estate of their acquired gender, whether or not they have a GRC. And if they did put someone within that estate, they may not put them mixing with other prisoners. Yes, of course.
Michelle Thompson.
Yes.
Secretary for giving way. I recall her saying earlier, and of course I'm aware of it myself, that the Scottish Prison Service are currently looking at the provisioning. So I suppose my question is, how does the Cabinet Secretary know that they have a robust process that considers all key stakeholders, and particularly, as you know, my concern is women in prisons?
Cabinet Secretary.
Well, SPS have given considerable evidence and their procedures are indeed very robust. The review is to look at what more they can do, but without a doubt I think there is a level of confidence in SPS because of the fact that they do already place transgender prisoners out with their acquired gender in an estate that is not of their acquired gender if they think that is a risk. In fact, it's about half and half at the moment. Whether or not someone has a GRC now, I would just note that is quite different from the position in England and Wales, where the possession of a GRC is far more a material factor in where a prisoner is located. That is not the case in Scotland. It is based on the risk assessment, and that is the primary issue that is considered. And as I was just saying before the intervention, that even when someone is placed in the estate of their acquired gender, they may not be placed in a position of mixing with prisoners if it's believed they are a risk to others. I cannot support Amendment 57 in the name of Pam Gosal. As I believe was queried by Jamie Green at stage 2, it's not clear to me whether Pam Gosal expects all healthcare professionals to have to declare whether they are trans to every patient. Now, I'm sure she, at the time when Jamie Green asked her, the member about that she said no, that was not her intention. So let's look at what actually happens. The Charter of Patients' Rights and Responsibilities rightly sets out that NHS staff have a right to be treated with consideration, dignity and respect. And as I set out to Pam Goso when she brought this forward at stage 2, the Scottish Government expects everyone to be treated fairly and equally and with respect when seeking healthcare. NHS staff will make every effort to ensure that the privacy and dignity of all patients are maintained in Scottish hospitals. If a patient specifically requests a doctor or nurse of the same gender as them in any part of their care, then every effort would be made to accommodate this as far as possible. But of course that would depend on the availability of staff with appropriate skills to manage the patient's condition. If someone, for example, ends up in emergency care and there's only male doctors available in the emergency room, then I'm sure in that situation members would appreciate that life-saving care needs to be given, whatever the gender of the health professionals attending. Yes.
Pam Goso.
Thank you for taking that intervention, Cabinet Secretary. I'm well aware of what you've just said in relation to if there was an emergency, our religions do provide that the fact that we have to have that care first. But if you go back to my practical example, it wasn't an emergency, it was to do day-to-day care, whether it's cancer, inspection of the breasts, it was smear tests. So it's things like that that I'm talking about. And also, so sorry, if you could let me finish, Cabinet Secretary, please. Right, Cabinet Secretary, that basically looking at this, yes, we heard today that the case that the 2004 Act, that this was the case, but what I'm asking now is that are we going to continue on putting sticky plasters on this, or are we going to actually address the problem, because the increase in GRCs are going to cause a problem, and this is something that the Cabinet Secretary and her government would be able to help with us to see how we could solve this.
Cabinet Secretary.
So let me be absolutely clear again. If a patient specifically requests a doctor or nurse of the same gender as them in any part of their care, then every effort would be made to accommodate this as far as possible. And I've given the examples of where that might not be possible. No thanks. Care homes and care services, which were also mentioned, will always try to also provide the care as per the person's wishes. And as a former home care organiser, I can tell the Chamber that that has been the case for many years. The genuine occupation requirement exception under the Equality Act provides that a person must not be a trans person where there is a requirement due to the nature and context of the work, if appropriate. The exception could be used in health services, for example, where there is intimate health and personal care to be provided. And, of course, I previously pointed towards the guidance to employers from the Equality and Human Rights Commission, Schedule 9 of the 2010 Act, which is relevant here. I want to move... yes.
Monica Lennon.
I'm very grateful to the Cabinet Secretary. When this debate is over, people may go back and read the official report of what was said. I have felt uncomfortable with some things that have been said over the course of the debate. Would the Cabinet Secretary agree with me, and I'm sure others, that trans men and women and non-binary people who currently work in the NHS, in social care, are valued colleagues, and we don't want to leave this debate and anyone thinking that they're not valued and not welcome? So can we get that for the avoidance of doubt? Because I think it's really important that their contribution is appreciated and that we want them to feel able to work in our public services.
Cabinet Secretary.
Absolutely, I can put on record an appreciation of every member of staff working in our NHS and indeed our care services, whatever their gender. And I think Monica Lennon makes a good point. I can't support the amendments in the name of Brian Whittle, placing a duty on Scottish ministers to report on the impact of the bill on sport and to publish guidance. The bill makes no changes to the rules for trans participation in women's sport, whether professional, amateur or in schools. Sports governing bodies set their own policies on trans participation under the Equality Act 2010. That is reserved legislation. Section 195 of the Equality Act contains provision allowing restrictions on trans people participating in sport to be imposed if necessary to uphold fair competition or the safety of competitors. That is under the Equality at, well, as long as it's brief.
Brian Whittle.
Oh, really? Well, Cabinet Secretary, what I'm trying to say to you is the guidance is not
working.
working.
Chair, Mr Whittle, through the chair, please.
Sorry, Deputy Presiding Officer. Deputy Presiding Officer, it's not enough to have guidance. The guidance actually has to be applied and has to have worth in the field. And so many times through a lot of this debate here from many colleagues across here who have asked the Government to have to create guidance, the Scottish Government have, and the Cabinet Secretary have turned around and ignored that guidance. It isn't working, and it's going. And obviously, because there will be more transgender athletes involved, it will get worse if you do not create the guidance and the framework for which sport can act. And it's not a reserved matter. It's Sport Scotland, and you fund for Sport Scotland. You need to take responsibility for your actions.
Cabinet Secretary.
So let me repeat. Sports governing bodies set their own policies on trans participation under the Equality Act 2010, which is a reserved piece of legislation. Section 195 of the Equality Act, a reserved piece of legislation, contains provision allowing restrictions on trans people participating in sport to be imposed, if necessary, to uphold fair competition or the safety of competitors. That is where the resolution and the guidance lies. The Equalities Committee has heard clearly at stage 1 from sports bodies that whether a person has legally changed their gender forms no part of their decision-making around participation in sport, and the bill does not have an impact in this area. And as I hope the member would already be aware, in 2020, the UK Sports Council commissioned independent consultants to conduct a review of its existing guidance for the inclusion of transgender people in sport. The review was a recognition that sport at every level required more practical advice and support in this area. The UK Sports Councils published that guidance for transgender inclusion in domestic sport in September 2021, so just last year. Now, as the member himself acknowledged, sports are incredibly diverse and there may need to be different solutions for different sports, which is why the guidance encourages sports to consider options to balance fairness, safety and inclusion. Some British national governing bodies have now published updated policies. For example, British Triathlon have published a new policy to come into effect on the 1st of January. I don't support Amendments 13 and 14 in the name of Jeremy Balfour or Amendment 71 in the name of Ash Regan. As both members will be aware, acts of this Parliament cannot alter the effect of the European Convention on Human Rights, and therefore these amendments are unnecessary and indeed confusing, particularly in that they pick out specific parts of ECHR. On Stephen Kerr's point about religion, faith, I had a meeting with the Faith and Belief Forum, which has faiths across all faiths, and of course there was a consultation, responses from faith groups, and also the committee evidence sessions with faith groups also took place. So I don't think it's true to say that people of faith have not been listened to, and of course it's up to churches how they organise themselves, and nothing in this bill changes that. The range of specific exceptions under the Equality Act that apply to faith groups, the general single-sex exception could apply to religious services where appropriate. So that's already covered within the Equality Act, and there's no change to that whatsoever. I also don't support Amendments 131 and 136 in the name of Tess White. The Scottish Government has carried out 2 public consultation exercises, and the Equalities Committee has likewise carried out a full public consultation. I've also supported members with areas that they want to see outlined in the review and report amendments. So, on the basis of all of that, I would ask members to reject these amendments.
Thank you. Cabinet Secretary, just remind the Chamber that there's a bit of background noise there. It'd be grateful if you have conversations to be had that you take them outside the Chamber. With that, I invite John Mason to wind up. Press and withdraw Amendment 122. Mr Mason.
Thank you very much, Presiding Officer. And first of all, can I just pay tribute to Shona Robinson for persisting through all of these hours and, I have to say, a certain amount of delays from the Conservative group. So I admire her for that, even though I disagree with her on 1 or 2 points. If I start with Pam Gosel's speech, I thought that was excellent, and she gave us some practical examples of where her mother and her aunt really feel there could be a practical problem. And I think sometimes with this debate, we have to look at what is happening to people in practice and what people are feeling, and not just at a very kind of high-level Holyrood bubble type of thing. And she herself mentioned the Muslim Council of Scotland, and we also know that Sikhs and a lot of Christians are also very unhappy about this bill. I think the point is, if we are going to be truly inclusive, then we can't expect everyone to take on the way we do things in Western secular society, and we have to allow people a certain amount of freedom to exercise their own way of doing things and their own beliefs. And I think that was, let me finish this point, I think that was highlighted between the kind of intervention between Stephen Kerr and Ross Greer, because Stephen Kerr would represent, for most religions, a more traditional view. Ross Greer might represent a more liberal view, and that's probably where the divide is, more than between Christians and Muslims and Sikhs. Sorry, Rachel Hamilton wanted
Rachel Hamilton.
I thank John Mason for taking the intervention. Over the weekend, the Muslim Council of Scotland wrote to the Cabinet Secretary and said that they were concerned about the negative impact on single-sex spaces. But the Cabinet Secretary seems to be saying that she has engaged with faith organisations and everything's fine. But I don't understand how everything is fine if she has listened, the Cabinet Secretary has listened to the same arguments that were set in that letter to her on the weekend. Could you shed some light?
Yes, I mean, I did see the letter from the Muslim Council, and also there was a joint letter between the Muslim Council, the Sikhs in Scotland and the Evangelical Alliance, who do, between them, represent quite a range of faith groups. So I think the fact that Sean Robinson talked about there was no real change, that may be her view of things, but it's not the way people are feeling about it, and people are not convinced about that. And there is a real concern. I think just to touch on something my colleague Ash Regan said earlier about legislation sending out a message. I know we can argue that this is a very technical piece of legislation, but I think a lot of people, including the faith groups and including Pam Gosel's relatives and so on, see this as much more of a longer... Well, let me just finish this point. They see this as a much more of a longer-term trend, and they are fearful, maybe not about where we are today, but they are fearful about where we're going to be in a year's time. Kevin Stewart.
Kevin Stewart.
I thank Mr Mason for giving way. And, you know, I respect faith groups of all kinds, and I respect freedom of religion. But some of the arguments that are being made are exactly the same arguments that were made on the run-up to the equal marriage debate and the equal marriage vote, where religious groups felt that they would have to carry out equal marriage against their faith. That has not happened, and my argument here would be that this is exactly the same kind of situation. Can Mr Mason see that?
John Mason.
I certainly understand Kevin Stewart's argument, but I would disagree with him, because I think there is, on same-sex marriage, there is a drift, there is a change. Church of Scotland would be one example, where they were somewhat more firmly against it, and they have gradually moved over time. So I think that my argument that there is a drift...
Mr Mason,
sorry?
Could I've just reminded the Chamber that there had been too much background noise. The background noise has now become, I think, foreground noise and heckling. I think I've conducted this proceeding so far respectfully and courteously, and I would hope that we can continue in a similar vein. Mr Mason.
So I would say that there has been a drift on that particular subject, and I would say that some who believe in traditional values are feeling more under pressure than they were at that time. Mr Johnson.
Daniel Johnson.
And I'm very grateful to the member for giving way. Just because a particular faith group changes its thoughts and its practice doesn't make that a bad thing. And describing that as drift, I would just caution him. It's a change, and they're perfectly entitled to make that change.
John Mason.
Yes, they're perfectly entitled to make that change, but I think my point is just that some individuals are more under pressure now than they were in the past, and the fear with this legislation as well is that we are going in a certain direction, we are sending out a certain message, and it is going to become increasingly difficult for Pam Gosel's mother and Pam Gosel's aunt. To move on to just briefly Brian Whittle's speech, which some of his points were good, they were a bit long-winded, but still good. And if that is true, that committee did not take evidence from sportswomen, then I have a serious problem with that. But I think the key words there, fairness and safety, are absolutely key. And I take the Siobhan Robinson's point that the Equality Act is where people should look, but a lot of Scottish, even national sports bodies in Scotland are relatively small, and they can be easily scared by legislation if there's not a bit of guidance and reports. And really, I think that in that section 58, 59, 67, 68 is only asking for guidance and reports. It's not a very big ask. Finally, to come on to my own amendment, which was supported by Kenneth Gibson in slightly more, perhaps, stronger language than I was using, but did very much paint some of the risks and some of the dangers and some of the fears that are out there amongst normal people in society. I would just say language is very important, and probably everybody here has been a bit uncomfortable at some of the language used by the other side. So I would certainly include myself in that. We should be sensitive and respectful, but I think, Presiding Officer, we have to be honest with each other and use honest language. And I think one of the fears, again, with this legislation is that over time language is going to be censored and people are going to have to be increasingly careful about what they say. So, overall, I would support, in fact, all the amendments in this group. Finally, I would just... yes, I'll leave it at that. All the amendments in this group, and especially I would press Amendment 122. Thank you.
Thank you very much indeed. Mr Mason, the question is that Amendment 122 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. And the vote's closed. Okay, the result of the vote on amendment number 122 in the name of John Mason is yes 59, no 65. There were no abstentions. The amendment is therefore not agreed. I call amendment 57 in the name of Pam Gosal, already debated with amendment 122. Pam Gosal, to move or not move?
To move, thanks.
The question is therefore that amendment 57 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is closed. And the result of the vote on amendment number 57 in the name of Pam Gosal is yes 38, no 64. There were 23 abstentions. The amendment is therefore not agreed. I call amendment 58 in the name of Brian Whittle, already debated with amendment 122. Brian Whittle, to move or not to move?
Move, please, Deputy President.
The question is that amendment 58 be agreed. Are we all agreed? Yes. We are not agreed. There will be another division and members should cast their votes now. And the vote is closed. And the result of the vote on amendment number 58 in the name of Brian Whittle is yes 61, no 64. There was one abstention. The amendment is not agreed. Call amendment 59 in the name of Brian Whittle, already debated with amendment 122. Brian Whittle, to move or not move?
Move, please.
The question is that amendment 59 be agreed to. Are we all agreed?
Yes.
Parliament's not agreed. There will be a division. Members should cast their votes now. And the vote is closed. The result of the vote on amendment number 59 in the name of Brian Whittle is yes 58, no 67. There was one abstention. That amendment is not agreed. Call amendment 60 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie, to move or not move?
Moved.
Question is that amendment 60 be agreed to. Are we all agreed?
Yes.
Parliament is not agreed. There will be a division and members should cast their votes now. And that vote is closed. Point of order, Sharon Dowie.
Sorry, I couldn't connect. I would have voted yes.
Thank you, Ms Dowie. I'll make sure that is recorded. And the result of the vote on amendment number 60 in the name of Jackie Baillie is yes 122, no 0. There were 3 abstentions. The amendment is therefore agreed. The call amendment 61 in the name of Pam Gosal, already debated with amendment 54. Pam Gosal, to move or not to move?
Moved, please.
Thank you. Question is that amendment 61 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is closed. And the result of the vote on amendment number 61 in the name of Pam Gosal is yes 40, no 66. There were 20 abstentions. The amendment is therefore not agreed. We now move on to Group 17, Gender Identity Healthcare. I call Amendment 62 in the name of Pam Gosal, grouped with Amendments 132 and 135. Pam Gosal to move Amendment 62 and speak to the other amendments in the group. Ms Gosal.
Thank you, Presiding Officer. I move Amendment 62 in my name. The bill decouples the legal and medical aspects of the GRC process, meaning that everyone who would have had to obtain a medical diagnosis of gender dysphoria and therefore meet with medical professionals now no longer have to do so. Amendment 62 calls on ministers to commission independent research on the effect of this bill on gender identity healthcare. In a submission to the committee, the Royal College of General Practitioners talked about the vulnerabilities of young people and the heightened risk of self-harm and suicide. When questioned on this by my colleague, David Parker of NHS Greater Glasgow and Clyde said, "The proposal to reform services is not simply about providing more clinic appointments and enabling pathways forward for people on the waiting list. It is also for people who will never join the waiting list so that community support is available for those people who might be looking for all kinds of intervention. If the numbers of people on the waiting list are increasing, that need is increasing too. Therefore, it appears that there are many people who may require this type of healthcare but do not seek it. This is likely to increase as the requirement to obtain a medical diagnosis is removed. We cannot risk individuals experiencing psychological distress by falling through these gaps. The aim of this amendment, Presiding Officer, is to measure what effect the Act has had on gender identity healthcare services, who is assessing them, who is not, and where can we provide that much-needed support for those who may be suffering from a great deal of distress. Furthermore, I believe this must be commissioned by an independent professional or organisation which is not currently in receipt of funding by the Scottish Government in order to avoid any instances of any bias. Given the nature of my own amendment, I therefore support Amendments 132 and 135 put forward by Jamie Green and Sarah Boyack, which also aim to measure how this Act impacts gender identity healthcare. Should the Scottish Government wish to address concerns that this reform will lead to many vulnerable individuals suffering from gender distress without adequate medical support,
At the very least, the Scottish Government should commit to reviewing the impact of this Act on gender identity healthcare. I would urge all members to back my Amendment 62 in my name.
Thank you, Ms Gorsall. Call on Jamie Green to speak to Amendment 132 and other amendments in the group. Mr Green.
Thank you, Deputy Presiding Officer. We persevere. There's been a lot of talk in the Chamber today, a quite valid discussion about the effect the bill will have on a range of minority groups. And with permission of the Chamber, I'd like to bring the discussion back to the minority group that this bill is actually all about, and that's trans people. My Amendment 132 actually builds on an amendment that was brought to the Chamber at stage 2 in committee by my colleague Rachel Hamilton. I thought a very well-worded and thoughtful and well-intentioned amendment to raise the awareness of the state of gender identity healthcare in Scotland. I believe it's in a sorry state, truth be told, and many trans people and organisations that I speak to believe that also to be true, which is the underlying point of my amendment. My amendment asks the Government, within a reasonable time period, after 3 years of Section 2 coming into force, there is some precedent for that reporting period, that the Government will outline the state of affairs with regards to access to mental health support and availability, transitioning healthcare waiting times, and whether bespoke pathways needed for those applying for a GRC. Now, the reason for that, I think, is quite obvious to those who have been through that system. The Sandiford Clinic in Glasgow currently states that for their adult gender identity service, they are currently offering appointments to people in May 2018, who registered in May 2018, only now getting appointments. It's taken 4 years for some people to get the required treatment that they require. Yes, I'll have to give way.
Rachel Hamilton.
To Jamie Green for taking the intervention. He's absolutely right. I put forward this amendment at stage 2 and it was rejected by the Cabinet Secretary because she said that the Health Secretary was looking at a pathway to healthcare for trans people. And obviously this bill is about improving the experience of trans people, particularly to make the whole process for them less stigmatised and the rest of it, you know, just improve everything. But I think that this should be on the face of the bill. I don't think that we should leave it to the Health Secretary, who's got enough pressures on his plate, to sort this out. I think this should be on the face of the bill because
Ms
it's
Hamilton,
really
if you
important.
could address the microphone just so that the comments are picked up.
Thank you. Sorry, Presiding Officer.
Yeah, can I thank
Jamie
the member?
Green.
Can I thank the member for her intervention? I too believe that, actually, and with good reason. The recent report from Stonewall, which I think are briefings that we've all received, demonstrate that 72% of transgender people have experienced depression, and over half, and listen to this statistic carefully, over half of people that they surveyed have thought about taking their own life. That's a huge volume percentage of people. And I think these are quite harrowing figures that show the desperate state of the availability of mental health services and support for transgender people in Scotland. Stonewall also found that 37%, so over a third, of trans people actually actively avoid accessing healthcare treatment when needed for fear of discrimination. Again, that should worry us. And what this means is that many people are actually hiding illnesses of their own while struggling to deal with their gender identity. A great piece of work was done by SHAP, that's the Scottish Health Action on Alcohol Problems, and in their recent report that came out very recently actually, and they were in the Garden Lobby talking to members, who spoke to a number of trans people who were struggling with alcoholism. And I want to quote from that report because it really underpins the reason why I think this is an important issue. The person they spoke to said, on the record, for me, alcoholism means I'm not at ease with myself. And that might be a lot to do with being transgender and not being comfortable within my own skin. Growing up, having to hide things away like that, it was a lot of pressure. I've always been ashamed of who I am. We've held debates in this Parliament before that people are often self-medicating to deal with many of those issues. And of course, whilst I support the removal, and I do support the removal of the requirement for a diagnosis of gender dysphoria, I do not think that should be used as an excuse not to provide adequate services and support to transgender people in Scotland. Now, I appreciate that in the feedback on all the amendments that were given to us in some of the briefs, some of the organisations, particularly those in support of the legislation, whilst in principle were happy for me to raise this issue, they actually asked members to oppose the amendment, and I did inquire why, because I was intrigued by that. And their fear is that the amendment may have the reverse effect of improving healthcare, but actually doing the opposite. And the reason for that is quite understandably worrying. And that's because they feel that if this amendment passes, and there's a duty on the government and ministers to report on the state of healthcare, then it would divert much-needed attention, resource and money from reporting and talking rather than doing. And I think that itself is a testament to the problem that we face and the problem that I'm trying to identify through this amendment. I understand where they come from, but they shouldn't need to be afraid that we can't put this on the face of the bill, because those services should already be there, and they should be getting better, and they shouldn't be afraid for this Parliament to tell government that you must do better. So whilst I appreciate their feedback, it's a shame that their concerns are based around the lack of resource and money in these services. And I also hope they appreciate the sentiment behind why I brought them back to the Chamber at Stage 3. And I hope by doing so that I say to them that I will work hard, as other members will, to improve outcomes for them. That's a duty on all of us. And I'd like to think that whatever your views on the bill, and there have been a number of comments expressed this evening which I think should make many of us feel uncomfortable, but whatever your views on this particular legislation, we can all agree that there is a duty, a collective duty on this Parliament to make healthcare provision for transgender people in Scotland much, much better than it is now. We can commit to that, whether you pass this amendment or not. That's something the government could commit to tonight. Thank you.
Thank you, Mr Green. Under Rule 9.8.5a, I'm minded to accept a motion without notice to propose that the next time limit be extended by 1 hour and 30 minutes.
Happy to do so, Presiding Officer.
Thank you, Minister. The question is that the time limit by which the debate on Groups 17 to 19 must then be extended by 1 hour and 30 minutes. Are we all agreed? We are all agreed. I now call Sarah Boyack to speak to Amendment 135 and other amendments in the group. Ms Boyack.
Thank you very much, Presiding Officer. I'll try not to fill up an hour and a half with this speech. This amendment that I'm moving, 135, would require Scottish ministers to carry out a review into the impact of this bill into gender identity healthcare in the form of a longitudinal study. Scottish ministers would be required to consult on the remit of the review, but any review would have a focus on improving access to and provision of gender identity healthcare. The review would be repeated each successive 5-year period to deliver a longitudinal study. The committee at Stage 1 heard a range of evidence on the provision of trans healthcare, including on the CAST review, which is currently taking place in England. But a number of constituents I've engaged with over the Parliament's consideration of this bill would support work to improve gender identity healthcare in Scotland, because there are significant delays for trans people trying to receive treatment from clinics. And this bill could increase the number of people trying to access these services, which would exacerbate the demand on services that are currently provided. So the review I propose in this amendment would provide reassurances to Parliament that we don't forget individuals applying for a GRC who then go on to experience lengthy waiting periods for treatment they may wish to receive. I think when we pass legislation in this Parliament, we need a joined-up approach to ensure it's successful. And at Stage 2, I moved amendments that would require ministers to publish data on trans healthcare waiting times. I welcome the reassurance I had from the Scottish Government, from the Minister, in the letter she sent me on the 9th of December, which outlined the fact that the Scottish Government is currently looking at work being done by Public Health Scotland to improve the quality of data on healthcare waiting times, as was committed to in the NHS Gender Identity Services Strategic Action Framework 2022 to 2024. But I honestly believe we need more than that, because this bill will simplify the process to obtain a GRC. and there has been consideration on why the simplification is required. And it is possible, as the number of people applying for and obtaining a GRC increases, then we will see an increase in the number of people who need to and wish to access gender identity healthcare and potentially more complex needs. And this could be a direct impact of this bill. So I hope Parliament will agree to my amendment so we can ensure that health services deliver for the needs and demands of trans people both now and in the future. And finally, I've referenced the need for longitudinal health to be assessed. It's important that trans people get the support they need, not just in the earlier years of their transition on a short-term basis, but throughout their lives, so that this is not a one-off piece of work, but something which will need to be continued going forward, so that the health services we have in Scotland understand people's needs going forward. So I move Amendment 135 in my name. If I can briefly just comment on the other two amendments. Amendment 62 in the name of Pam Gosal, I understand would require the Scottish Government to start a review similar to the CAST review in Scotland, and I think that's something we should support, and I would support this amendment if Pam Gosal moves it. Amendment 132 in the name of Jamie Green would require a review on the availability of trans healthcare 3 years after commencement, and given that that's aimed to ensure trans healthcare is available and meets the needs of trans people, I would support Amendment 132. And the point made by Jamie Green in moving his amendment, I think, were very well made, because the delays and pressures people are experiencing are going to really impact on the experiences of people going forward. And I think we need to reflect on the statistics that he talked about in his speech. These amendments, I think, collectively would strengthen the impact of this bill, would make it more successful, and for those reasons, I hope colleagues will support them all. Thank you.
Thank you, Ms Boyack. Can I now call the Cabinet Secretary to respond?
Thank you, Presiding Officer. As I would hope the members who have amendments in this group are already aware, the Scottish Government published a strategic action framework for gender identity service improvement in December 2021, which set out a series of commitments that we are working to progress with NHS Scotland and other stakeholders with some investment to make that happen. This included a commitment to commission Public Health Scotland to provide regular publication of robust, validated data on waiting times to access specialist clinical services, and that commission has been made and work is ongoing to deliver this by Public Health Scotland. We also made a commitment, Sarah Boyack has just referred to make available funding for research into the long-term health outcomes of people accessing gender identity healthcare in Scotland. That process is ongoing, led by the Chief Scientist's Office within the Scottish Government's Health and Social Care Directorates, with a funding call issued to Scottish academic institutions in August. Therefore, much of what is sought by the amendments in this group have already begun and are ongoing outside of the bill, which, of course, I would remind members is about the process and requirements for applying for legal gender recognition, and not about access to and the delivery of gender identity healthcare. Yes.
Jamie Green.
I appreciate the Cabinet Secretary's intervention. Look, the Cabinet Secretary knows I'm not trying to muddy the water with regards to the remit of the bill. That's been clear throughout my speaking over the last few days. But there is a valid point here, and the point is now, under the existing volume of people going through the system and applying for GRC, there are years and years and years worth of waiting lists to get specialist help. If we pass the bill and that volume increases, and there's an expectation that it will increase, then those waiting times are simply going to get longer and longer, unless the government puts more resource and cash into it. So that's why it is so important that the bill reflects that, because that will be an effect of the direct effect of the legislation that passes.
Cabinet Secretary.
So let me first of all recognise the point Jamie Green is making about the waiting times and the need to make improvements. And that, of course, is why the Strategic Action Framework for Gender Identity Service Improvement was published, and the investment that is required to make those improvements. Now, as Jamie Green knows, a GRC is not required in order to access gender identity health. I think the data and the monitoring of the data will show whether or not there is an increase from this legislation. I think my feeling is that there is not, because it is about people who are seeking gender identity healthcare, whether or not they would be pursuing a gender recognition certificate. And not everybody would want to do so, and not everybody who is wanting a gender recognition certificate would want to access healthcare. But I'll come on to the data collection in a second. So, on the basis of all of that, I don't support Amendments 62, 132 and 135. I do recognise that these amendments may be motivated by a desire, as Jamie Green has just said, to improve the provision of gender identity health care services. Following discussions with members, we have, however, supported the amendment in the name of Jackie Baillie to review the impact of the Act on gender identity healthcare already discussed in an earlier group, and I'm hoping that that will reassure members, and I think that gets the balance right.
Thank you, Cabinet Secretary. I now call on Pam Gosal to wind up, press or withdraw Amendment 62. Ms Gosal.
Thank you, Presiding Officer. We've heard throughout this debate about the need for the collection of data and other aspects which will undoubtedly be affected by this bill, such as criminal justice, single-sex services, and a review on its impact on the gender identity healthcare is no less important. I am disappointed, however, not surprised at the SNP government's reluctance to review the gender identity healthcare, as I imagine, much like the CAS review, it would provide a case for further pausing any reforms to the gender recognition process and shedding light on what appears to be a healthcare pathway which does not follow the routine medical process. I believe a review into the effect of this Act on gender identity healthcare will provide some reassurances for those who are concerned about the decoupling of the legal medical process.
Cabinet Secretary.
Just to be absolutely clear, the very last sentence that I just said in my remarks was that following discussions with Jackie Baillie, the amendment that we passed or agreed to will review the impact of the Act on gender identity healthcare. It's exactly what the member is asking for. Does she not recognise that?
Pam Gosal.
I thank the Cabinet Secretary for a response, but what I'm asking for is why are you not then passing this grouping that we've asked for? Anyway, the SNP's government removal of all safeguards increases the likelihood that children, young people and vulnerable individuals may go without much-needed support, and therefore I would urge all members to back the amendments in this group.
Thank you. Ms Gosal, you're pressing the amendment. Ms Gosal? Ms Gosal, you're pressing...
Yes, I move.
Thank you. The question is Amendment 62 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. There's a vote on Mr Lumsden. (62). And the vote is closed. The result of the vote on Amendment 62 in the name of Pam Gosal is yes 54, no 68. There were 2 abstentions. The amendment is therefore not agreed. Call Amendment 123 in the name of Pam Gosal, already debated with Amendment 54. Pam Gosal, to move or not move?
Moved, please.
Question is that Amendment 123 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division and members should cast their votes now. And the vote is closed. The result of the vote on Amendment 123 in the name of Pam Gosal is yes 36, no 67. There were 22 abstentions. The amendment is therefore not agreed. With that, we move to Group 18, Reporting. I call Amendment 124 in the name of Rachel Hamilton, grouped with Amendments 63, 64, 65, 125 and 66. Rachel Hamilton to move Amendment 124 and speak to all other amendments in the group. Ms Hamilton.
Thank you, Presiding Officer. I move the amendment in my name. My first amendment in this group would shorten the time period in which the Registrar-General would be required to report on the information mentioned in subsection 5. Given the evidence that this bill will open up the possibility of obtaining a GRC to a much larger and wider and diverse group of people, I believe it is important that the impact of this is assessed more regularly than 1 year. Moreover, as set out in Amendment 125, the scope of the Registrar-General's duty to report should be expanded to include the number of applications for gender recognition certificates and confirmatory gender recognition certificates that are rejected, the number of applicants under the age of 18, the number of gender recognition certificates granted to applicants under the age of 18, and the number of applications for gender recognition certificates and confirmatory gender recognition certificates where the acquired gender is male or female. Gaining clarity around the effect of this legislation would be aided by ensuring the Registrar-General collects this data. Painting a clear picture of the number of applicants and the number of applications granted on a 6-monthly basis would allow us to apply a greater level of post-legislative scrutiny to this bill. The importance of doing so relates to evidence heard by the committee that this bill would lead to an uptake in the number of individuals applying for and obtaining a GRC. We must also ensure the impact of opening this process to 16 and 17-year-olds is properly assessed, and that is why I have included provisions for the Registrar-General to report on the number of people who apply for and obtain a GRC under the age of 18. I would find it difficult to believe that choosing not to require the Registrar-General to report on these matters would be in any way beneficial. For these amendments, and for these reasons, I also believe Pam Duncan-Glancy's amendments in this group 63 to 66 are necessary to further our understanding of the effects of this bill. And she will do a far better job, I'm sure, of explaining the purpose and effect of her amendments than I will. But my understanding is that they will require the Registrar-General to collect data on several important factors, including the number of GRC applications rejected by the Registrar-General. Thank you.
Thank you, Ms Hamilton. I call Pam Duncan-Glancy to speak to Amendment 63 and other amendments in the group. Ms Duncan-Glancy.
Thank you, Deputy Presiding Officer. Members will know that I brought a similar amendment at stage 2. Between then and now, I've worked with the Government because I believe it is essential that we gather data in relation to this bill, and on that basis I hope to have their support for my amendments tonight, and I welcome support offered from Rachel Hamilton a moment ago. Amendments 63 to 66 in my name strengthen data collection requirements in the bill. In addition to the data outlined in the amendments, I have also sought assurances that other data originally included in my amendment at stage 2 would be collected as well. I have had assurances from the Government that this will indeed be the case and would appreciate further reassurance again tonight on the record. This includes data on the number of appeals to the Sheriff and the grounds under which applications to the Sheriff were received or granted. The Government have confirmed that data of this sort is held by the Scottish Courts rather than NRS, and that the Scottish Government already publishes statistics on civil law cases in the courts. I also asked that applications received from people in prison be monitored. Because of the low numbers, I accept that this could identify an individual, and I am satisfied that this will be monitored and reported on in terms of the review and impact amendments already debated. Between these assurances, which I seek again, as I say, I am satisfied that the relevant data needed to inform reviews that are required in other amendments will be available. The remaining information and data that is needed is set out in the amendments before us tonight. These introduce additional reporting requirements for the Registrar-General, including the number of applications of each type of GRC granted, rejected or withdrawn in the year, and breakdowns of applications by type and application and gender of applicants. The collection of better data on GRCs will be of paramount importance to any future reviews of this Act and for monitoring purposes. Supporting these amendments in my name will ensure that Scotland will start with a strong evidence base from which to carry out any future scrutiny, monitoring, reporting and reviewing of this bill. Presiding Officer, I therefore move the amendments in my name and encourage members to support them. Thank you.
Thank you, Ms Duncan-Clancy. I call Jamie Green.
I think it's just briefly to say that I think these are a good set of amendments, particularly that around Amendment 64, 65. One of the things we've really struggled with throughout this process is gleaning data on statistical numbers of the amount of people that are currently applying or have been rejected a certificate. That historic data, I've tried to put in a number of parliamentary questions around that, and I was told that because the volume is low, it's difficult to get that data because it would potentially breach the confidentiality of those that are involved, and that's not something I particularly buy. I think that data is important. It doesn't need to have names, addresses and faces attached to it, but that data will help inform public policy. We also have enhanced data that may arise from census data, whilst that wasn't the most perfect exercise in the world as we saw, but it is nonetheless helpful to inform public policies. And I would ask members that even if they are generally not supportive of the legislation, to at least allow the collection of valuable data to help inform future public policy to be collected.
Thank you, Mr Green. I call the Cabinet Secretary.
I said to Pam Duncan-Glancy at stage 2 that I would be happy to consider what could be incorporated from her Amendment 147 that was not agreed to at stage 2, and I'm pleased, therefore, we have been able to work together to bring forward the amendments in her name, and I'm happy to give her the assurances that she was looking for, because I think the point being that some of the information that is collected is from sources out with the Registrar-General, but we gave a commitment to collect that, and I can put that on the record again. We agree there that there's benefit in including more detail in the duty to report to provide assurance to members of the information that will likely be available. This information will contribute to our understanding of the operation of the process and ability to monitor and review the impact of this bill as with any other. Amendment 124, in the name of Rachel Hamilton, provides that the Registrar-General must report every 6 months instead of annually on everything for which reporting is presently done under the Registration of Births, Deaths and Marriages Scotland Act 1965, not just information related to gender recognition, and we believe that is disproportionate. Amendment 125, in the name of Rachel Hamilton, requires the Registrar-General to report on the number of applications rejected, on the acquired gender and the age of applicants. And as we expect the Registrar-General to receive between 250 and 300 applications per year, requiring the Registrar-General to report every 6 months reduces the likelihood that the information will be able to be published, given the small numbers and the risk of identifying an individual. Further, the amendments in the name of Pan Duncan Glancy already include a requirement to report on the number of applications rejected and on the acquired gender. Therefore, I do not support amendments 124 and 125.
Thank you, Cabinet Secretary. I call on Rachel Hamilton to wind up and to press or withdraw Amendment 124.
Thank you, Presiding Officer. Given the concerns that have been raised by members of this Parliament, by organisations and individuals who gave evidence in our committee sessions, and by a swathe of Scottish public about this legislation, I believe it is right that we can do what we can here to monitor robustly the impact of it. Ensuring that the Registrar General regularly reports on the information outlined is an important step in allowing us as elected representatives and anyone else to see and understand the outcomes related to the bill's implementation. And as I said before, it is difficult to consider how choosing not to collect this data would be beneficial. Understanding the consequences of new legislation is a vital part of applying adequate post-legislative scrutiny. And although this SNP and Green Party has throughout this process sought to avoid scrutiny in any form, these amendments represent an opportunity for them to put this right and commit to that very action. The Cabinet Secretary didn't explicitly say that she wasn't going to support, I didn't hear her say she wasn't going to support 124, but I know that she's not going to support 125, so presuming that she's not supporting either, I'd just like to ask the Cabinet Secretary before I close, how does she know how many applications of gender recognition certificates there are going to be? How does she know how many GLCs there will be, and indeed how the impact will have on this Parliament? Sorry, I couldn't get my words out.
I think Rachel Hamilton's giving way to the Cabinet Secretary. Is that correct?
So we've based the numbers of 250 to 300 applications per year on the Irish system, which we consider to be very similar to our own.
Rachel Hamilton.
Thank you for the Cabinet Secretary for clarifying that, but every jurisdiction has a different system, and it's not exactly the same as the system that we are going to be voting on today. So that's slightly unfair to pick that as one example, and I'm just disappointed. I will move the
amendment. Less sedentary chit-chat and
I will move
Rachel
the
Hamilton's
amendment in my name. Thank you, Presiding Officer.
Thank you, Ms Hamilton. The question is that Amendment 124 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Point of order, Rhoda Grant.
Stopped working after I voted, and I want to check if I voted.
Your vote had not been recorded, but it will now be recorded.
Could I vote no, please?
You voted no. Thank you, Ms Grant, for the clarification. Thank you. The result of the vote on amendment number 124 in the name of Rachel Hamilton is yes 30, no 93. There were no abstentions. The amendment is therefore not agreed. I call Amendment 63 in the name of Pam Duncan-Glancy, already debated with Amendment 124. Pam Duncan-Glancy, to move or not move?
Moved.
Thank you. The question is that Amendment 63 be agreed to. Are we all agreed? Yes. We are not agreed. Therefore, there will be a division. Members should cast their vote now.
I can't believe the Tories have forced it this late again after last night. But they're worried that they're not worried that people will fake it. They just use it to scare people and use it to try and delay the bill. I mean, don't forget that most of the things that they've brought up, the amendments they've tried to make, it's not that the amendments there aren't genuine concerns about certain things, not most of them, but they're just not related to this bill.
The vote is now closed. Kenneth Gibson, point of order.
I was unable to get onto the app. I would have voted yes.
Point of order.
Thank you, Mr Gibson. That will be recorded. Point of order. Colin Beattie.
Presiding Officer, my system didn't connect. I would have voted yes.
Thank you, Mr Beattie. That will be recorded. Thank you. The result of the vote on amendment number 63 in the name of Pam Duncan-Glancy is yes, 123. There were no votes against. There were 3 abstentions. The amendment is therefore agreed. The question, I call amendment 64 in the name of Pam Duncan-Glancy, already debated with amendment 124. Pam Duncan-Glancy, to move or not move?
Moved, Presiding Officer.
Thank you. The question is that amendment 64 be agreed to. Are we all agreed?
Yes.
The Parliament is not agreed. There will be a division. Members should cast their vote now.
They will move on, but the problem is that if Labour don't fight this now, they're going to end up fighting it at the next election. And they don't have good answers. And I'm not convinced they're not going to throw us under the bus.
The vote is now closed. Thank you. The result of the vote on amendment number 64 in the name of Pam Duncan-Glancy is yes, 121. There were no votes against. There were 4 abstentions. The amendment is therefore agreed. I call amendment 65 in the name of Pam Duncan-Glancy, already debated with amendment 124. Pam Duncan-Glancy, to move or not move?
Moved.
Thank you. The question is that amendment 65 be agreed to. Are we all agreed?
Yes.
The Parliament is not agreed. There will be a division. Members should cast their vote now.
The Tories are going to try and turn everything into trans or LGBT because they've got quick answers. It's a nuanced, personal thing that they can just kick us over and over again. And Labour do not have any easy answers. Not because Labour are shit as much as they have been. It's just there aren't easy answers. These are complicated issues.
be on the core rights issue. And they frame them so badly.
The vote is now closed. Thank you. The result of the vote on amendment number 65 in the name of Pam Duncan-Glancy is yes 122. There were no votes against. There were 3 abstentions. The amendment is therefore agreed. I call amendment 125 in the name of Rachel Hamilton, already debated with amendment 124. Rachel Hamilton, to move or not move?
Moved.
Thank you. The question is that amendment 125 be agreed to. Are we all agreed? No. The Parliament is not agreed. There will be a division. Members should cast their vote now.
Get the advantage of the division, so I get to talk. Group 19, data collection, unnecessary grants, and we can transfer the groups. And then we have 69, dog whistle to trans people in prisons and trans nurses again. The Tories have been politely nasty as fuck.
The vote is now closed. Thank you. The result of the vote on amendment number 125 in the name of Rachel Hamilton is yes 36, no 90. There were no abstentions. The amendment is therefore not agreed. I call amendment number 66 in the name of Pam Duncan-Glancy, already debated with amendment 124. Pam Duncan-Glancy, to move or not move?
Moved.
Thank you. The question is that amendment 66 be agreed to. Are we all agreed?
Yes.
The Parliament has not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 66 in the name of Pam Duncan-Glancy is yes 122. There were no votes against. There were 3 abstentions. The amendment is therefore agreed. I call amendment number 67 in the name of Brian Whittle, already debated with amendment 122. Brian Whittle, to move or not move?
Moved, please.
Thank you. The question is that amendment 67 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Point of order, Mary McCallan.
Thank you. My app froze. I would have voted no.
Thank you, Ms McCallan. That will be recorded. Thank you. The result of the vote on amendment number 67 in the name of Brian Whittle is yes 55, no 69. There was one abstention. The amendment is therefore not agreed. I call amendment number 68 in the name of Brian Whittle, already debated with amendment 122. Brian Whittle, to move or not move?
Move, please.
Thank you. The question is that amendment 68 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Point of order, Colin Beattie.
Presiding Officer, my app froze. I would have voted no.
Thank you, Mr Beattie. That will be recorded. Point of order, Jeremy Balfour.
I just wanted to check my phone is disclosing whether my vote was counted or not.
Thank you, Mr Balfour. Your vote was counted.
Thank you.
Thank you. The result of the vote on amendment number 68 in the name of Brian Whittle is yes 58, no 67. There were no abstentions. The amendment is therefore not agreed. We will now move to Group 19 on data collection. I call Amendment 69 in the name of Pam Gozo, grouped with Amendments 70 and 126. Pam Gozo to move Amendment 69 and speak to all amendments in the group. Ms Gozo.
Thank you, Presiding Officer. As this is the final grouping, I will try to deliver to the best of my ability, bearing in mind it is nearly midnight and I am slightly just feeling tired now. I move Amendments 69 and 70 in my name. Data collection is key to understanding and analysing the impact of this Act. As was made clear by the United Nations Special Rapporteur, Reem Assalim, in evidence given to the committee, data collection on the impact of the self-identification model does not go far enough. Amendment 69 calls on ministers to collect data on detransitioners. Detransitioners are people who have gone through the process of changing their gender and then returning to the gender observed at birth. Specifically, my amendment calls on ministers to collect data on the number of people that detransition. How many of these detransitioners are male to female? How many are female to male? And the average time elapsing from being granted a GRC to beginning to detransition. Last month, many of us in this room attended a meeting arranged by the member Ruth Maguire with two detransitioners, Sinead and Richie, who bravely shared their experience of transitioning and then detransitioning, which was extremely powerful and very heartbreaking. Sinead's transition from a female to a male left her with permanent changes such as a deep voice, while Richie, who had transitioned from a male to a female, underwent gender reassignment surgery, which he later ended up regretting. Both individuals also expressed concern over the lack of data on detransitioners. The pair went into great detail about the lack of support available for detransitioners, speaking of how different the support was when seeking to transition versus detransition. They also spoke about how gaining legal recognition of your gender identity is likely to lead you to feel that pressure to align your physical gender identity, leading to irreversible changes. Richie even spoke of the health complications he has suffered from since undergoing medical transition. Since this bill removes important safeguards such as lowering the age, one can apply for a GRC from 18 to 16 years old, and shortens the 2-year waiting period to 3 months for adults and 6 months for those under the age of 18. Many young people and vulnerable individuals risk making rushed decisions they might later end up regretting and without adequate support. This amendment seeks to ensure that data is collected on individuals who detransition. Only with that data can we expect to understand the extent to which individuals detransition. Such information would be crucial to informing any review of the gender recognition process and informing any review on gender identity healthcare. Amendment 70 also calls for some more data collection, this time regarding acquired gender and sex at birth in certain settings such as healthcare and criminal justice. For example, it will be important to know how many GRC holders work in healthcare settings and in prisons, as women in these settings can be a vulnerable population. But without collecting specific data on acquired gender and biological sex, it is nearly impossible to know this. Professor Alice Sullivan told the committee, "We need consistent and accurate data on sex to make comparisons over time and between countries, and to evaluate the effect of policy interventions." She then said, "When the Gender Recognition Act 2004 was introduced, it was designed to cater to a tiny number of transsexual people who suffered from severe psychological distress. The Act was not intended to raise barriers to the collection of data on sex, yet that has been one of the unintended consequences of the legislation. Therefore, I believe it would be in the interests of trans people with a GRC and the wider public for the Scottish Government to collect data on both sex, gender identity and gender recognition certificates if we are to understand the impact of this legislation and accurately track the outcomes of people in society. My amendments refer specifically to healthcare settings and criminal justice because both include large numbers of vulnerable individuals under the state's care, and therefore it is important that data is collected in these settings. Speaking to the committee on Monday, the United Nations independent expert on sexual, oriental and gender identity, Victor Madrigal-Borloz, mentioned that previously no one knew about violence against transgender people because they were being recorded as men. However, I believe that given that conflation of data collection on both sex and gender identity and a substantial increase expected in the number of people holding GRCs, it is important that we do not conflate these terms for the purpose of data collection. Otherwise, instead of trans women being recorded as men, they will be recorded as women, and we will still lack data on violence against trans people. Data collection is the least that can be done to monitor the impact of this bill, so I hope that members will support my amendments in this group. I will support Stephanie Callaghan's Amendment 126, which also calls for more data collection in public sector settings and on biological sex and gender regarding the number of those holding a GRC.
Thank you, Ms Gozo. I now call on Stephanie Callaghan to speak to Amendment 126 and other amendments in the group. Ms Callaghan.
Thank you, Presiding Officer, and I move Amendment 126 in my name. My amendment is a very simple one that places a duty on the Scottish Government to ensure all public sector bodies collect data on biological sex alongside data on gender identity. And this amendment is not designed to frustrate, challenge or place onerous demands on the Scottish Government and public bodies. It is purely about ensuring access to clear, accurate baseline data on both biological sex and gender identity now and in the future. Throughout this amendment stage and during committee evidence sessions, we've heard opposing views on pretty much every issue. But I think it's fair to say that the value of good data is something we can all agree on. Therefore, I'm proposing that Scotland's public bodies routinely and as a duty collect, retain and report quantitative data on biological sex, including all administrative and in-service process data, in addition to legal sex gender identity. Presiding Officer, data is an essential tool for health and well-being. And we already know that many medicines we use today affect male and female bodies differently. However, we also need good data for diseases and medicines that we don't yet know about. Researchers have found that missing data in patients on sex and gender has meant there is no accurate data on whether trans and non-binary people were, for example, more or less affected by COVID-19. Yes, I will.
Tess White.
Thank you to Stephanie Callaghan for taking an intervention. Does the member think that a public board that's 50% men and 50% transgender women is gender balanced?
Stephanie Callaghan.
I don't really see where that's particularly relevant to this one, but I would actually agree. Now, some may argue that this is just a matter of personal choice. If a transgender person wants to change their sex on their medical records, even with those associated risks, then that is their choice. But are people receiving the best advice for their health? There are countless reports of people missing cancer screenings and experiencing delays in receiving care. The importance of longitudinal data is a fundamental principle for researchers and healthcare professionals that allows them to understand people's lives over time and improve services for all people. While some will say there is no reason the legislation that we're considering would affect data collection, Professor Sullivan told the committee that would be an understandable assumption, but it would be a mistake. The Professor went on to say, when the Gender Recognition Act 2004 was introduced, it was designed to cater to a tiny number of transsexual people who suffered from severe psychological distress. The Act was not intended to raise barriers to the collection of data on sex, yet that has been one of the unintended consequences of the legislation.
On that point, would you give way?
Yes, I will.
Michelle Thompson.
Thank you for giving way. Can I also draw attention to, in February 2021, 91 quantitative social scientists wrote to Scotland's chief statistician to express concern about the proposed loss of data on sex. And they said, and I quote, "We find a conclusion that sex-based data should rarely be collected astonishing. Sex is a fundamental demographic variable essential for projections regarding fertility and life expectancy." They went on to finish part of their paragraph by quoting Caroline Criado Perez, "A lack of sex disaggregated data often leads to the needs of women and girls being ignored."
Stephanie Callaghan.
I thank the member for that intervention and certainly I welcome the sharing of that information. I believe there was also a letter to the Health Committee as well. So, in closing, Presiding Officer, I would remind the Scottish Government of its public sector equality duty to monitor and publish data on the protected characteristics of sex and point out that mandating the collection of this data across public bodies now is likely to save future governments and parliaments a lot of time and trouble. Presiding Officer, I urge members to support Amendment 216. Thank you.
Thank you, Ms Callaghan. And I call on the Cabinet Secretary.
Thank you. Amendment 69 in the name of Pam Gosal would place a duty on Scottish ministers to collect and publish information about people who detransition. We have supported an amendment in the name of Pam Duncan-Glancy that includes more detail within the Registrar-General's reporting duties of the information that will likely be available, and this includes the number of applications withdrawn. Given that we expect the Registrar-General to receive between 250 and 300 applications per year, there are data protection considerations involving in amending this provision to be more prescriptive, because information will only be available where it does not risk disclosing the identity of an individual, where there's very small numbers. Amendment 70 in the name of Pam Gosal and 126 from Stephanie Callaghan place a duty on Scottish ministers to set out in regulations the data that is required to be collected in order to monitor the operational impact of the bill. Amendment 70, already debated, regarding the post-legislative review, ensures Scottish ministers must have regard to any data provided to them about the effect of a person obtaining a gender recognition certificate under the 2004 Act as amended. The amendments agreed in the name of Pam Duncan-Glancy also set out more detail about the data that will likely be available from the National Records of Scotland. This information will contribute to our understanding of the operation of the process and the ability to monitor and review the impact of the bill. As that has already been agreed and provided for in the bill, I see no added value in Amendments 70 and 126, and therefore I cannot support them.
Thank you. I call Pam Gosal to wind up and press or withdraw Amendment 69.
Thank you, Presiding Officer. I'm disappointed once again that the Cabinet Secretary isn't accepting the amendments in this grouping. I think that what I've asked for goes further, and that I would basically like that the Cabinet Secretary would have supported my amendments on detransitioning and obviously collecting the data. So I do urge that members here today do support and back my amendments in this group and the other amendment. So I move the amendment in my name.
Thank you. The question is that Amendment 69 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now.
Up for that. We're almost at the end.
The vote is closed. The result of the vote on amendment number 69 in the name of Pam Gosal is yes 55, no 70. There were no abstentions. The amendment is therefore not agreed. I call amendment 70 in the name of Pam Gosal, already debated with amendment 69. Pam Gosal, to move or not move?
Move, please.
Thank you. The question is that amendment 70 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 70 in the name of Pam Gossel is yes 53, no 71. There were no abstentions. The amendment is therefore not agreed. I call amendment 126 in the name of Stephanie Callaghan, already debated with amendment 69. Stephanie Callaghan, to move or not move?
Move, please.
The question is that amendment 126 be agreed to. Are we all agreed? Yes. Parliament is not agreed and members should cast their votes now. The vote is closed. The result of the vote on amendment number 126 in the name of Stephanie Callaghan is yes 58, no 66. There were no abstentions. The amendment is therefore not agreed. I call amendment 72 in the name of Sue Webber, already debated with amendment 54. Sue Webber, to move or not move?
To move, please, Presiding Officer.
The question is that amendment 72 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 72 in the name of Sue Webber is yes 32, no 94. There were no abstentions. The amendment is therefore not agreed. I call amendment 73 in the name of Sue Webber, already debated with amendment 54. Sue Webber, to move or not move?
To move, please, Presiding Officer.
The question is that amendment 73 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now.
Are any of these likely to pass? The galleries are complicated because the gender criticals managed to get all the tickets.
The vote is closed. The result of the vote on amendment number 73 in the name of Sue Webber is yes 54, no 72. There were no abstentions. The amendment is therefore not agreed. I call amendment 74 in the name of Sue Webber, already debated with amendment 54. Sue Webber to move or not move?
I'll move my amendment, please, Presiding Officer.
The question is that amendment 74 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now.
I assume that they talked about that we're going to get a business announcement after the amendment.
The vote is closed. The result of the vote on amendment number 74 in the name of Sue Webber is yes 54, no 72. There were no abstentions. The amendment is therefore not agreed. I call amendment 127 in the name of Jackie Bailey, already debated with amendment 54. Jackie Bailey to move or not move?
Moved.
The question is that amendment 127 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 127 in the name of Jackie Bailey is yes 54, no 68. There were 5 abstentions. The amendment is therefore not agreed. I call amendment 128 in the name of Pauline McNeill, already debated with amendment 54. Pauline McNeill to move or not move?
Moved.
The question is that amendment 128 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now.
I'm looking forward to the final debate and vote. I mean, SNP are obviously going to whip, and Lib Dems have said that they are all going to vote for it. So with the Greens, even with the rebels in SNP, it should go through. I'm interested to see how Labour votes. They've not been wonderful on some of these amendments.
The vote is closed. The result of the vote on amendment number 128 in the name of Pauline McNeill is yes 58, no 67. There were no abstentions. The amendment is therefore not agreed. I call amendment 129 in the name of Pauline McNeill, already debated, with amendment 54. Pauline McNeill, to move or not move?
Moved.
The question is that amendment 129 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 129 in the name of Pauline McNeill is yes 59, no 66. There were no abstentions. The amendment is therefore not agreed. I call amendment 130 in the name of Jackie Bailey, already debated, with amendment 54. Jackie Bailey, to move or not move? Moved. The question is that amendment 130 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. Colin Beattie for a point of order.
My app didn't connect. I would have voted no.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 130 in the name of Jackie Bailey is yes 60, no 66. There was one abstention. The amendment is therefore not agreed. I call Amendment 13 in the name of Jeremy Balfour, already debated, with Amendment 122. Jeremy Balfour, to move or not move?
Move, please, Presiding Officer.
The question is that Amendment 13 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 13 in the name of Jeremy Balfour is yes 62, no 63. There were no abstentions. The amendment is therefore not agreed. I call Amendment 14 in the name of Jeremy Balfour, already debated, with Amendment 122. Jeremy Balfour, to move or not move?
Move, please, Presiding Officer.
The question is that Amendment 14 be agreed to. Are we all agreed? Yes. Parliament is not agreed, and members should cast their votes now. The vote is closed. The result of the vote on amendment number 14 in the name of Jeremy Balfour is yes 59, no 68. There were no abstentions. The amendment is therefore not agreed. I call Amendment 71 in the name of Ash Regan, already debated, with Amendment 122. Ash Regan, to move or not move?
Oh, sorry, moved.
The question is that Amendment 71 be agreed to. Are we all agreed? Yes. Parliament is not agreed, and members should cast their votes now. The vote is closed. The result of the vote on amendment number 71 in the name of Ash Regan is yes 64, no 63. There were no abstentions. The amendment is therefore agreed. I call Amendment 131 in the name of Tess White, already debated with Amendment 122. Tess White, to move or not move?
Moved, Presiding Officer.
The question is that Amendment 131 be agreed to. Are we all agreed? The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 131 in the name of Tess White is yes 53, no 73. There were no abstentions. The amendment is therefore not agreed. I call Amendment 132 in the name of Jamie Green, already debated with Amendment 62. Jamie Green, to move or not move?
Bear with me, Presiding Officer. Moved.
Thank you. The question is that Amendment 132 be agreed to. Are we all agreed? Yes. Parliament is not agreed. Members should cast their votes now. The vote is closed. Point of order, Jeremy Balfour.
The system wouldn't load. I would have voted yes to the amendment.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 132 in the name of Jamie Green is yes 54, no 73. There were no abstentions. The amendment is therefore not agreed. I call amendment 133 in the name of Jamie Green, already debated with amendment 54. Jamie Green, to move or not move?
Not moved.
The question is that amendment 133 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 133 in the name of Jamie Green is yes 53, no 73. There was one abstention. The amendment is therefore not agreed. I call amendment 75 in the name of Jackie Bailey, already debated with amendment 56. Jackie Bailey, to move or not move?
Moved.
The question is that amendment 75 be agreed to. Are we all agreed?
Yes.
Can I just confirm, are we all agreed?
Yes.
Okay. Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 75 in the name of Jackie Bailey is yes 120, no 5. There were 2 abstentions. The amendment is therefore agreed. I call amendment 76 in the name of Jackie Bailey, already debated with amendment 56. Jackie Bailey, to move or not move?
Moved.
I call amendment 76A in the name of Pam Duncan-Glancy, already debated with amendment 56. Pam Duncan-Glancy, to move or not move?
Moved.
The question is that amendment 76A be agreed to. Are we all agreed? No. Parliament is not agreed. Members should cast their votes now.
Wasn't this meant to be over 3 minutes ago?
The vote is closed. The result of the vote on amendment number 76A in the name of Pam Duncan-Glancy is yes 54, no 69. There were 3 abstentions. The amendment is therefore not agreed. Jackie Bailey, to press or withdraw amendment 76.
Press.
The question is that amendment 76 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 76 in the name of Jackie Baillie is yes, 123, no, 2. There were 2 abstentions. The Jackie Baillie to move or not move?
Moved.
The question is that amendment 77 be agreed to. Are we all agreed? Yes. Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 77 in the name of Jackie Baillie is 124. There was no one, 2 abstentions, and the amendment is therefore agreed. I call Amendment 78 in the name of Jackie Baillie, already debated with Amendment 56. Jackie Baillie to move or not move?
Moved.
The question is that Amendment 78 be agreed to. Are we all agreed? Yes. Parliament is not agreed. Members should cast their votes now.
Why are they being arseholes and not just letting these go through? I'm sorry, I answered my own question. They're arseholes.
The vote is closed. Point of order, Murdo Fraser.
Thank you, Presiding Officer. My app would not connect. I would have voted yes.
Thank you. We'll ensure that's recorded.
Why does this feel like a giant game of quick?
The result of the vote on amendment number 78 in the name of Jackie Baillie is yes. 124. No, 0. There were 2 abstentions. The amendment is therefore agreed. That's 78. Yes. I call amendment 79 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie to move or not move?
Move.
The question is that Amendment 79 be agreed to. Are we all agreed?
Yes.
Parliament is not agreed, and members should cast their votes now.
See, they're getting pissed off that someone keeps saying no. mean, lots of these ones here are all in green on the gender critical cheat sheets, which means that they should get passed because everyone supports them.
The vote is closed. Point of order, Murdo Fraser.
Connecting, Presiding Officer. Again, I would have voted yes.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 79 in the name of Jackie Baillie is yes 125, no 0. There were 2 abstentions. The amendment is therefore agreed. I call amendment 80 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie, to move or not move? Moved. The question is that amendment 80 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 80 in the name of Jackie Baillie is yes 125, no 0. There were 2 abstentions. The amendment is therefore agreed. I call amendment 81 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie, to move or not move? Moved. The question is that amendment 81 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now.
I think there's like another 15 of these, of which all bar 3 should pass.
The vote is closed. The result of the vote on amendment number 81 in the name of Jackie Baillie is yes 125, no 0. There were 2 abstentions. The amendment is therefore agreed. I call amendment 82 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie, to move or not move? Moved. The question is that amendment 82 be agreed to. Are we all agreed? I call Amendment 83 in the name of Jackie Baillie, already debated with Amendment 50.
Sorry, was there no 82?
Okay, can I believe there was a no to 82, but I will require members to make sure that I can hear them, and I would ask anyone who is wishing to vote to make that quite loud. The question is that Amendment 82 be agreed to. Are we all agreed? Yes. Okay, Parliament is not agreed and members should cast their votes now. The vote is closed. The result of the vote on amendment number 82 in the name of Jackie Baillie is yes, 124, no 1. There was 1 abstention. The amendment is therefore agreed. I call Amendment 83 in the name of Jackie Baillie, already debated with Amendment 56. Jackie Baillie to move or not move? Moved. I call Amendment 83A in the name of Russell Finlay, already debated with Amendment 56. Russell Finlay to move or not move?
Moved.
The question is that Amendment 83A be agreed to. Are we all agreed? Parliament is not agreed and members should cast their votes now. The vote is closed. The result of the vote on amendment number 83A in the name of Russell Finlay is yes 53, no 73. There was 1 abstention. The amendment is therefore not agreed. Jackie Baillie to press or withdraw Amendment 83. Press. The question is that Amendment 83 be agreed to. Are we all agreed? Yes. Parliament is not agreed and members should cast their votes now.
That one almost threw me. I thought they were doing 83, not 83. 83, not 83A.
The vote is closed. The result of the vote on amendment number 83 in the name of Jackie Baillie is yes 125, no 0. There were 2 abstentions. The amendment is therefore agreed. I call amendment 84 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie to move or not move? Moved. I call amendment 84A in the name of Pauline McNeill, already debated with amendment 56.
Not moved.
Thank you. It's not moved. So you just go back to Jackie Baillie. Jackie Baillie to press or withdraw amendment 84.
Press. Thank you.
Thank you. The question is that amendment 84 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 84 in the name of Jackie Baillie is yes 125. There were no votes against and there were 2 abstentions. The amendment is therefore agreed. That was 84. I call amendment 85 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie to move or not move? Moved. The question is that amendment 85 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. Members should cast their votes now.
Annoying because they know which way it's going to go and they could have easily just whizzed through them. But they want to delay it. They want to make it as painful as possible.
The vote is closed. Point of order, Jamie Green.
I would have voted yes.
Thank you. I'll ensure that's recorded. The result of the vote on amendment number 85 in the name of Jackie Baillie is yes 120. There were no votes against. There were 2 abstentions. The amendment is therefore agreed. I call amendment 86 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie to move or not move? Moved. The question is that amendment 86 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote's closed. The result of the vote on amendment number 86 in the name of Jackie Baillie is yes 124. There were no votes against. There were 2 abstentions. The amendment is therefore agreed. I call amendment 87 in the name of Jackie Baillie. Already debated with amendment 56. Jackie Baillie to move or not move? Moved. The question is that amendment 87 be agreed to. Are we all agreed? Yes. Parliament is not agreed and members should cast their votes now.
If my back didn't hurt so much from being sat here all day, I'd have fallen asleep by now in this chair.
The vote is closed. The result of the vote on amendment number 87 in the name of Jackie Baillie is yes 124. There were no votes against. There were 2 abstentions. The amendment is therefore agreed. I call amendment 88 in the name of Ruth Maguire, already debated with amendment 56. Ruth Maguire to move or not move?
Not moved, Presiding Officer.
Thank you. I call amendment 89 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie to move or not move?
Moved.
The question is that amendment 89 be agreed to. Are we all agreed?
Yes.
I call amendment 90 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie to move or not move?
Moved.
I call amendment 90A in the name of Pam Duncan-Glancy, already debated with amendment 56. Pam Duncan-Glancy to move or not move?
Moved.
The question is that amendment 90A be agreed to. Are we all agreed? No. Parliament is not agreed and members should cast their votes now. The vote is closed. I call Christine Graham for a point of order.
My connection, I would have voted no.
Thank you. We'll ensure that's recorded. I call Colin Beattie for a point of order. Thank you. We'll ensure that's recorded. The result of the vote on amendment number 90A in the name of Pam Duncan Glancy is yes 52, no 71. There were 3 abstentions. The amendment is therefore not agreed. Jackie Bailey to press or withdraw amendment 90.
Press.
The question is that amendment 90 be agreed to. Are we all agreed? Yes. Parliament is not agreed. Members should cast their votes now. The vote is closed. Point of order, Sharon Dowie.
Connect. I would have voted yes.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 90 in the name of Jackie Bailey is yes 124. There were no votes against. There were 2 abstentions. The amendment is therefore agreed. I call amendment 134 in the name of Russell Finlay, already debated with amendment 56. Russell Finlay to move or not move?
Move, please.
The question is that amendment 134 be agreed to. Are we all agreed? No. Parliament is not agreed and members should cast their votes now. The vote is closed. The result of the vote on amendment number 134 in the name of Russell Finlay is yes 54, no 70. There was 1 abstention. The amendment is therefore not agreed. I call amendment 135 in the name of Sarah Boyack, already debated with amendment 62. Sarah Boyack to move or not move?
Moved.
The question is that amendment 135 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 135 in the name of Sarah Boyack is yes 54, no 73. There were no abstentions. The amendment is therefore not agreed. I call amendment 91 in the name of Jackie Baillie, already debated with amendment 56. Jackie Baillie, to move or not move?
For the last time, Presiding Officer, moved.
The question is that amendment 91 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. Point of order, Kenneth Gibson.
I couldn't connect to the digital platform. I would have voted yes.
Thank you. We'll ensure that's recorded. The result of the vote on amendment number 91 in the name of Jackie Baillie is yes 123. There were no votes against. There were 3 abstentions. The amendment is therefore agreed. I call amendment 92 in the name of Sue Webber, already debated with amendment 54. Sue Webber, to move or not move?
Move, please.
Thank you. The question is that amendment 92 be agreed to. Are we all agreed? Yes. Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 92 in the name of Sue Webber is yes 37, no 89. There were no abstentions. The amendment is therefore not agreed. I call amendment 136 in the name of Tess White, already debated with amendment 122. Tess White, to move or
Moved,
not move?
thank you.
The question is that amendment 136 be agreed to. Are we all agreed? Parliament is not agreed. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 136 in the name of Tess White is yes 32, no 95. There were no abstentions. The amendment is therefore not agreed. I call amendment 141 in the name of Michael Mara, already debated with amendment 100. Michael Mara, to move or not move?
Presiding Officer, this was a technical amendment tied to a previous amendment that's already fallen. I won't be moving, and anyone who does move it will be spuriously wasting parliamentary time and, frankly, ruining Christmas.
I call